Morning, everyone. Welcome to the House Committee on Health and Human Services and Elderly Affairs. We have several bills noticed for today's hearings, and we'll be getting to those in a moment, but I'd like you to join me in the Pledge of Allegiance first. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you, everyone. Okay, the first bill for us to consider this morning is House Bill 188. We have the prime sponsor here, Representative Popovich Mueller.
Thank you very much, Mr. Chair and members of the committee. I appreciate the opportunity. I'm planning to keep my remarks as short as possible because it is a long day for everybody. On the bright side, I don't think we need to spend a lot of time explaining the intent of the bill. It is attempting to remove one paragraph, 14 words from the physical therapy bill. The intent of the bill is to remove the requirement to go see a physician if there is no documented improvement in 25 calendar days at the beginning of the treatment. The reason why I'm advocating for this is that we are dealing with a primary physician shortage in many parts of the state. There are people who cannot see their primary physicians, quickly. There are people who don't have health insurance and for which the burden of having to see a doctor is significant in material terms. Those concerns combined with this law can lead to people being unable to receive physical therapy, which would, benefit them. Now, of course, the law exists for a reason, but I want to point out that we have about 20 states in the US, including Massachusetts and Vermont, that do not have such restrictions in their laws, that allow direct access and allow the patient and the physical therapist to decide, what the proper course of action will be. Trust me, I'm not going to come in front of this committee very often and ask us to match the Massachusetts level of regulations, okay? But this is where we are right now. We are more tightly regulated than states, that honestly have a reputation for being over-regulated to start with. Now, to address potential concerns in terms of, what would happen if this restriction would be removed. The concern in this law was that, bad actors may take advantage of unsuspecting patients and, offer treatment that is not needed. I would like to submit to the committee that we already have insurance companies that have really tight rules around how much treatment you can have without a doctor's visit. Physical therapists are highly trained and they absolutely will refer the patients who do need to see a doctor if that's the best course of treatment. And also we have the, licensing board that is perfectly capable of handling any, unacceptable ethical violations or practice, or poor practices. But the way I see this law, it is a law that no longer has a purpose and is keeping certain people from getting treatment. So I would urge the committee to support, HB 188, which will remove that, regulation. So this, I'll stop here and I'll be happy to entertain any questions.
Questions from the committee? I'm seeing none.
Thank you.
Thank you. I know. I have no other people signed up to speak on this. Does anyone else wish to testify on House Bill 188?
Mr. Chairman, can I
Yes.
ask a question? I was assuming somebody else was going to speak. Can I ask him a question? I really
sure.
intended to ask it to somebody else.
Representative, do you mind taking a question from Representative Nagel?
I've never turned a question down in my life.
Thank you, Mr. Chairman. Thank you for taking my question. I think this question is actually more addressed to somebody sitting behind you, but I've been fortunate to work with physical therapists for over 30 years, and one of the things you develop is a mutual respect for abilities. I also work with an international group of people, of which I'm happy to work with a number of Australian physical therapists. One of the things that's unique about Australia is they basically have direct access to care, and that allows for a lot of creativity. In my mind, and I'm just curious, and I'm staring, one eyeball is looking at somebody else. I'm sorry, but this is an important question. My concern is that the way we've done things has stifled physical therapy in this country, and I'm just curious from your point of view, does that have any role in why you think this is important?
Have your professional qualifications, but I should mention that after an Achilles tear and 3 knee surgeries and a hip surgery, I have a lot of frequent flyer miles in, being a patient in an office. And it has been my experience that a lot of the times, and I don't mean that in any disrespectful way, the physical therapist is really more qualified and more trained on that specific area of medicine, and they know what needs to be done because that's what they do all day. I have a huge amount of respect for the medical profession, but they have to be way broader and, don't have the opportunity to delve into those depths as much. And honestly, my doctors and physical therapists generally agreed, but frankly, personally, and speaking just for myself, if there was a time when my physical therapist and my doctor disagreed, personally, I would lean more towards, taking the opinion of the physical therapist that I spend way more time with and knows my specific injury and how I reacted to it and what happens. And, recovering from an Achilles took 9 months of physical therapy. There was no way I was going to get any documented improvement in 25 days. And of course, I had a doctor referral because, I had a surgeon who sent me to physical therapy, but you can also recover from an Achilles tear without surgery and just by waiting it out, letting it heal naturally and having physical therapy, So I'm sorry for the long answer to that question. And of course, if anybody else who's here would like to defer and the committee would be willing, I'd be more than happy to yield. Thank you.
Yes, Representative Shapiro.
Thank you. Thank you, Mr. Chairman, and thank you for taking the question. Because of all the reasons that you just gave, that among which that many injuries are pretty intractable and might not see any gains after 25 days, did you give any consideration to, instead of eliminating this, to extending the amount of time?
Yes, I have. The concern that I have in terms of extending it is that we're just making a law that's, in my opinion, right now harming patients, less harmful, but we don't fully eliminate the potential harm. And I think that the experience of the states, 20 states in the US, not only there are no negative outcomes, but we save money. I mean, if a doctor visit is not necessary, we shouldn't mandate it. We stop preventing people from accessing care. Extending the term would limit the harm, but I think the best policy would be to eliminate that.
Thank you.
Other questions?
This is a follow-up question to represent, thank you,
Follow-up?
Mr. Chairman, to
Follow-up.
Representative Shapiro's question. Do you believe that physical therapists have the expertise to know when they need help from a doctor?
I'm not a doctor, but I will give you a personal example. Before my Achilles tear, I had a pre-tear in the Achilles, and you could feel a bit of a bump in the Achilles. And I saw my doctor, and he told me, yeah, you have a pre-tear, but you are fine playing 2 more games in the season and then come back to me in the summer and see what's going on. I saw my physical therapist, and my physical therapist told me I would not play soccer under any circumstances with that. I went and played my 2 soccer games, and in the second soccer game, about half an hour in, I tore my Achilles. So I genuinely believe that, and the doctor told me there was a risk of tearing it. He just said, the risk wasn't, huge. I believe that because they do this on a daily basis, and this is the one thing they do in that area, they absolutely have the ability to recognize and the intent. And please understand, if they don't do it, if they make a mistake, they will be sued for, malpractice. If you look at the insurance premiums charged for malpractice to physical therapists, they're tiny. compared to the medical profession. And that's because they don't generate the complaints, and that's because they do refer people to the doctors, not as many as. So thank you.
Other questions? Yes, Representative Murphy.
Thank you, Mr. Chairman, for taking my question. The bill actually says no documented improvement.
Yes.
So it doesn't say resolution of symptoms or the Achilles tear. Personally, I know exactly what we went through with an Achilles tendon rupture, and that does not get better in 25 days. I agree with you there. But there is oftentimes improvement. So my question is not so much whether or not they should be able to continue treatment if they have documented improvement. My concern is that they would get maybe 2 months, 3 months down the road and still no documented improvement. And there's no obligation necessarily to refer back into the medical, or to see a physician about that. So my question, I guess, indirectly is, why not extend the period of time? Or if not, what I'm saying is that documented improvement is different than no resolution. And how do we resolve that? Because I would like to see something that if somebody's not getting better, they at least get referred back into the system, or no improvement.
Thank you, Mr. Representative Murphy. To make a long story short, I absolutely understand the distinction, but I believe that the patient and the physical therapist and the regulatory bodies and the insurance companies provide enough protections right now for everybody to not get into those situations that you describe where they may get excessive treatment. At the end of the day, a patient knows, whether what they are doing is good up to a point. The physical therapist has a huge burden professionally and ethically and in regulation to provide those references, to the doctor if needed. And if that doesn't happen, there are plenty of mechanisms through which a patient can seek recourse for any mistakes that were in treatment. I just don't feel that, and I'm looking at the experience of all the states that have implemented direct access, because I recognize that the concern is, I can absolutely understand the concern, but if you look at the experience of the states that have done this, they just don't see that happening in any way that cannot already be handled by their existing licensing boards.
A follow-up?
Follow-up.
Just a question. You mentioned the protections. I'm curious, what are the protections to protect the patient from not being seen in an appropriate period of time?
Well, first, again, there is a licensing board. If a patient feels that they should have seen by a doctor, but a therapist took advantage of them and treated them forever just to bill them and without providing improvement, they can, file a complaint with the licensing board. Most patients do have insurance. Insurance companies have very specific regulations about what improvement do you want to show at most times. And frankly, again, I just trust that the combination of the patient's self-interest, the physical therapist's self-interest, and the need to maintain their professional reputation will outweigh the temptation for the vast majority of them to take advantage of it. And again, for the ones that don't, there are other forms of recourse. And one last comment. I have not, in my personal experience, found the follow-up to the doctor to be, much more than of course, you need more physical therapy type of appointment. Now, of course, I don't know, I respect their professional opinion. I'm sure they considered a lot of factors they didn't necessarily share with me, but it's really hard for a doctor to deny physical therapy anyway. So the outcomes tend to always be automatic referral back to the physical therapist. And we seem to create this, need for all this and the expense and the delays without, providing a benefit that covers the, burdens provided by it. Thank you.
Other questions? Seeing no other questions? Okay, thank you.
Thank you.
Also signed up to testify this morning is Representative Ellen Reed. Morning, Representative. You have 3 minutes, please.
Good morning. Thank you. Thank you, Mr. Chair, and thank you, honorable members of the committee. For the record, my name is Ellen Reed. I represent Rockingham 10, Newmarket, and Newfields. I will say that I have been in physical therapy probably the majority of the last 10 years. I've had 3 surgeries on my knee, plus other issues you may hear. For those of you who've been in the in office for long enough that my voice, as of the last year, has not been the same. Part of that physical therapy has also been vocal therapy. So I'm pretty familiar with being bounced back and forth between doctor and physical therapist. One of the biggest reasons that patients do not see improvement is compliance. We are assigned exercises. A lot of us do not do those daily exercises that our physical therapist tells us. In that case, the physical therapist, not the doctor, is the one to help us figure out ways to find how it works with our schedule, how we can remind ourselves to actually comply with those exercises. I want to be very clear that there's nothing in this that says a physical therapist can't kick a patient back well before 25 days if they think that physical therapy is not the solution, regardless if there's improvement or not. There may be a little bit of improvement, but they're seeing something that they know physical therapy is not going to help with, and it needs to go back to a doctor. And I have my personal, so it's kind of the opposite of what we're talking about, but my personal example was one of my knee surgeries. I had a bolt put in my knee. And then I went to the doctor because there was a big lump on my knee. It was very, very hard. The doctor said, "Oh, that's just a bursa. Go through physical therapy. You'll be fine." The physical therapist looked at it, touched it, like, "No, that's not a bursa. That's a bolt coming out of your knee." Had to go back, had to have the bolt removed. So that was an example where the doctor did no less than the physical therapist, and the physical therapist kicked me back to the doctor long before the 25 days. Even though I was showing improvement, the physical therapist knew that my improvement would be limited because of that bolt coming out of my knee that was interfering with the building of the muscle. I did just get the okay from the good doctor behind me, who many of us know and love, on this bill before he even saw that my name was on it. In terms of extending the number of days, I think anytime you kind of put an arbitrary number, very few of us, except for the person behind me, very few of us in here are medical doctors. So I don't think putting an arbitrary number, even if you're extending it, is the solution. If you were to amend it, and again, because physical therapists can kick people back out well before 25 days if they see that it's an issue, I think if you were to amend it, you would simply amend A, or B rather, to say, oh, actually, it does. It falls under A. It literally falls under A. So if there's something that, like in my case, the physical therapist sees that even if you are showing improvement, that you're going to be limited because there is a medical condition that a doctor needs to look at, then they can and shall, according to this, kick you back to your doctor. But I think arbitrarily requiring that they kick you back to your doctor just because you're not doing your exercises is expensive and time consuming for the patient. And that's it.
Perfect timing. Thank you. Questions for Representative Reed? I see no questions.
Thank you.
Okay, thank you. Also signed up to testify, Maggie Donahue from NHA PTA.
Thank you, Mr. Chair. For the record, my name is Maggie Donahue. I'm a physical therapist and have been practicing in the state for over 30 years. I have served previously on the Board of Allied Health Professions, including the Physical Therapy Governing Board, and at this point I am representing the New Hampshire American Physical Therapy Association members of this state. I wasn't going to speak because it seemed to be doing okay, but I want to just give some very specific answers, and specifically Representative Murphy. The reason the number doesn't work is that it is totally arbitrary and it completely would depend on the type of condition. So if I had a client in front of me who had a total knee replacement and I wasn't seeing some changes within 2 weeks, it would be an unethical move on my part not to be referring them back to the physician. So, on the other hand, if you have someone who's being treated in a school situation where it's definitely going to be a long-term issue, 25 days is a drop in the bucket for how long they're going to be having physical therapy services. So the number really does become arbitrary as far as that's concerned. That is why we count on good ethical behavior on the part of the physical therapist, and why the licensing board would provide that part of the job. So hopefully that would answer your question more specifically. I'd be also glad to have answer any other questions anybody has.
Yes, Representative Palazzo, Representative Palmer, sorry.
Thank you, Mr. Speaker, and thank you for taking my question. So just to preface this, I've worked in a rehab hospital for years and was a primary care doctor before that, working a lot with physical therapists. and I've had a bunch of surgeries. And I would say one of my concerns about this bill, and I'm asking you if you have the same concern, is it says, if we leave it the way it is, it says that the physical therapist shall refer a patient. Now, when I was having problems with my neck, my physical therapist did not refer me back. He merely said, this isn't working. And he talked to my primary care doctor who referred me to a neurosurgeon, but the physical therapist did not actually make a referral. He just told my doctor what's going on. That might not fit this law, the way this law works, because it wasn't technically a referral by the physical therapist. It was simply a call. And that would be one of my concerns here, is that it makes it's a little too prescriptive aside from the 25 days. Do you share that concern, or?
I don't. In all practicalities, that to me would be making the referral. You've consulted out with the physician or whoever the appropriate healthcare provider is. The language does allow for that sort of latitude, and I would document that in I've referred them. I've talked to the doc and referred. Oftentimes, depending on what the situation is. So, neck pain could be complicated. It could be, I may want the primary care to make the decision about whether they're going to the neurosurgeon versus an orthopedic surgeon. It behooves us to have the communication, and to me, the referral part is having that communication that goes with it.
Thank you.
Representative Palmer. Murphy, I'm sorry.
Thank you. Thank you, Mr. Chairman. Thank you for taking my question. I would agree with you wholeheartedly that an arbitrary number of 25 days is not necessarily an appropriate number, nor even the time frame for many. You've been around for 30 years. You have had experience with this, and therefore your experience has taught you a lot. When this concept came up, I remember testifying here over 30 years ago when we went to a PT1, PT2 designation. Mm-hmm. Is that still in effect right now?
No, as a matter of fact, this compromise came out of the bill that replaced that with essentially direct access for physical therapy in the state. That was approximately 15 years ago. Yep. And I will, since being there for as part of that, this was a compromise with the medical world at that point, because PT2s who were allowed to have direct access after 30 days, it was a hard number improvement or not, had to go back to the client who did not need a referral to see the physical therapist after 30 days. Even if they only needed one more visit, needed to go back to the physician to get a referral before physical therapy could continue. So this was a compromise, the 25 days, because the physicians felt that physical therapists still needed to have a check-in and have that back and forth communication. And that's really not necessary anymore.
Right. Just a quick follow-up.
Follow-up, sure.
Thank you. And I would agree with you with that. You have a lot of experience. You would fall into the PT3 category probably, if there was one. I guess my concern is always going to be, somebody that does not have your experience, that they have a certain amount of, hubris about their capabilities, and they don't refer a patient back in because they don't have your experience or maybe not the skill set to diagnose another problem that may be present. Knee pain is not always the knee, it could be the back, that sort of thing. So I guess that's my concern about the inexperienced therapist that may not or may be able to refer back in. So thank you.
Just as an informational point, back then, physical therapists were educated at a bachelor's/master's level, and they are now at a clinical doctorate level. So there is significantly more education, particularly around differential diagnosis. There is also a significant increase in that time frame that their education around clinical experience and internships. Which is part and parcel of why all of the states now allow direct access for physical therapy in some form. There are still some that have some limitations, but so those go hand in hand. And the ones I would worry about the most personally would be the ones who get their degree as a clinical doctorate and just open up down the street and just don't do any cooperation with other folks or work with peers. Most of the time they are working with other peers. They're oftentimes in a hospital or a private practice, and their colleagues won't, for their own benefit, would not do that. I'm now retired, but as a private practice owner, I can tell you that was not going to happen. So,
thank you.
Representative Nagel.
Thank you, Mr. Chairman. Thank you, Ms. Doctor.
No, no, I actually
So you
was
guys-
educated back in the days of a bachelor's
I know,
degree,
I
so.
know. I wasn't sure if you took that step or not. I think my questions kind of, the two questions I asked earlier were actually for you.
I kind of got that.
I've been working with you folks for a long time. I'm just curious, do you believe you have the expertise to know when it's time to ask for help from a doctor? And put yourself at year 1, year 30, year 15, whatever.
I would, my answer would be unequivocally yes. And part of that is based on recently, well, 6 years ago, our practice had hired a new grad, and while they may not have, they were not necessarily asking a doc at that point. They were very, very concerned about discussing with us as colleagues. The office had 7 therapists in it, discussing with us questions and concerns, and if any of us had seen something. So there was always a teaching moment as part of that. And then about 3 years ago, we also had another relatively new grad, and the same experience. So they really are taught that. And the bottom line is, if they are not able to make a change or not able to discern something that really is appropriate for physical therapy, then the training is they need to go on to another healthcare provider.
All set. Representative Weber.
So I just want to go back to the issue of the new practitioners. Am I right in thinking that just as a new attorney is required ethically and under the licensing laws to either associate themselves, educate themselves, find somebody else to work with if they are in a situation that is beyond what they are competent to do, and they're the person who judges, but the malpractice board is always there over their shoulder. So isn't it true that just as in many licensed professions, every physical therapist has that same duty of what I would call collegiality and consultation at any time that they are out of their depth? And so whether they are consulting with another physical therapist or referring somebody to an MD, they have that obligation from moment one anyway. Is that not true?
That is absolutely true. And we also, as part of our licensing laws, we all are required to do a continuing education and take courses on a regular basis. It's one of the good things that came out of the PTs getting direct access. Prior to that with PT1s and PT2s, part of them did not have to do continuing education. Now every physical therapist has to do that continuing education on a regular basis. I thank you for that question.
Other questions? Seeing no other questions, so thank you very much.
You're welcome.
I have no one else signed up to testify on House Bill 188. Does anyone else wish to testify? Seeing no one, I'm going to close the public hearing on House Bill 188 and open the public hearing on HB 554 FN, and welcome my fellow Londonderry resident, Representative David Lungren, the prime sponsor. Good morning, Representative Lungren. Is that a pink card, Representative?
Yes.
Yeah, if you could pass that up, please.
Here's this one. Did you finish circulating? Sorry, I stopped circulating the ones for this bill earlier, so it didn't get lost.
Whenever you're ready, Representative.
Your microphone is off.
Sorry. I would like to especially thank Representative Merchant for his hard work this past summer regarding 258, putting together the forefront of bringing to the forefront the opioid crisis. Thank you. I would also like to thank Representative Dr. David Nagel for his assistance on this bill. Before I get started, I'd like to share a brief story about the opioid crisis. A woman that I had met was suffering with back pain, was prescribed opioids for pain, in which she continued to take them for as long as permissible. When those meds stopped working, she turned to heroin. She lost her family, her business, and almost all her life. Due to the grace of God, she was able to recover and get back with her family. The reason for the story is that she had related to me, had she known about alternative care for back pain, she would have given it a try. HB 554 deals with evidence-based treatment of chronic pain utilizing alternative care. I believe the opioid crisis is in large part the consequence of the absence of effective, affordable, alternative care available to residents of New Hampshire for the treatment of pain. Every leading medical profession in this country, including the Joint Commission on Opioid Abuse, has recommended alternative care as cost-efficient, effective means of dealing with this opioid crisis. Alternative care is only performed by duly licensed practitioners in the state of New Hampshire. Regarding insurance, there would be no increase in insurance costs as long as these practitioners are already prescribers for participating insurance providers. This bill is giving the patients the choice whether to seek alternative care or rather than prescribed medications. In closing, this bill, the reason this bill is necessary is due to the over-reliance on pharmaceuticals, specifically opioids. It is a condition that has been created by overprescription and or abuse of opioids within the medical community. I realize we do need to have medications available, but I also think that the opportunity to let the patient choose how they want to get their care. And with that, I conclude my testimony because I know you folks are really busy. I've included in the pack a unapproved amendment to 554, which is eliminating a few sections in the bill, mainly on page 1, 6 and 7 would be eliminated. On page 1, 25 through 29 would be eliminated. On page 2, number 31, and eliminate yoga therapy and replace it with physical therapy. And on page 3, number 5, eliminate the yoga therapy, replace it with physical therapy. Same page, number 3, number 9, eliminating when ordered by healthcare practitioner. And that would take care of the amendment. The letters that I sent around too are from a couple of patients of mine that were heavily into opioids and have realized that their alternative care has helped. And if I have the ability to answer any questions, I'd be happy to right now.
Okay, thank you. Representative Leon.
Thank you, Mr. Chairman, and thank you, Representative, for bringing this bill to us. My question is about the insurance coverage sections in this bill, and if those are essentially the same as House Bill 303, which is in commerce, because I know that insurance coverage is a little bit different than health policy. So I was curious if you would be willing to remove the coverage section and defer to the bill that's in commerce.
I'd be willing to look at that. I don't know about 303, so I'd have to look at that, but yes,
Thank you.
thank you.
Other questions? Yes, Representative Weber.
Thank you. And if you could, I'm having a little trouble meshing this bill with what I'm seeing in the current statutes. I see that you've added, if there are definitions, and I haven't looked them up in 126A, I think by inserting after section 88 the following new subdivision, you are getting rid of all the definitions that are in the current 126A:89 because they have the same number, unless I'm in the wrong place. And then, so you're going from the definitions that are already there, which are extensive, just down to 2. And then 126A:90 appears to me to be to replace in its entirely the controlled prescription health and safety program. And I'm assuming that was not your intent, and this is perhaps a numbering issue.
Correct.
So, but that was not your intent. So we need to figure out about the numbering. Is that correct?
That'd be good. Thank you.
Okay, thank you. And I was going to ask, with your indulgence, yes, with 2 different indulgences, Mr. Chairman, could you go over your quick walkthrough of the amendment again and just tell us again which
Oh,
lines
sure.
it omits?
Absolutely. So
Thank you very much, and
No,
thank
no
you for
problem. On page 1, it's eliminating 6 and 7 under,
so the definition of healthcare practitioner. Okay, yep.
and then it's eliminating number 25 through 29 at the bottom. Okay. And then on page 2, it's eliminating on number 31, no, number 29, I'm sorry, when ordered by a healthcare practitioner to treat conditions. And then-
On line 29 of page 2?
Yeah. And then on,
I'm not seeing those words on page
okay,
29, on line 29.
it's under section 3.
No,
No?
page 2 of the bill that I have is, it's section 3, Roman 3, and then I have a numeral 2,
Okay.
and I'm
And
in
under that, on number 29, you
29.
see where it says ordered by a healthcare practitioner to treat conditions?
Oh, I see, yep. Okay, thank you very
Elim-
much.
No, no problem. Eliminate that. And on number 31, eliminate yoga therapy and replace it with physical therapy. And then, you okay?
Yep.
Okay. On page 3, number 5, eliminate yoga therapy, replace it with physical therapy.
Yep.
And number 9, eliminate when ordered by a healthcare practitioner. And I think that's it.
Thank you very much.
No, no problem at all.
It's very helpful.
Representative Kofalt.
Yes, thank you, Mr. Chairman, and thank you, Representative. First of all, I have an amendment that came around, but I have 1 page,
Oh,
and it stops abruptly, so I'm assuming that there's more that we don't have, or
There
that-
is.
at least
I'll-
that I don't have.
no, I'm sorry.
And while you're handing that to the representative, I will ask you another question. It appears that again, I may be wrong, but it appears that the amendment adds rulemaking authority whereas the original bill as introduced does not include rulemaking authority. Do I see that correctly?
You know, I brought that to Legislative Services
Okay.
and told
yeah.
them that I wanted to have a few things removed, so I don't know how to answer that. I'm
Okay,
sorry.
and I'll have to, having just got the amendment, I'll have to read it more thoroughly and do a comparison. And just a note of appreciation to our committee researcher who provided a wealth of information in the memo here. So, thank you.
Representative Palazzo.
Thank you, Mr. Chair, and thank you for taking my question. I like the idea of giving choice to patients. My concern is, so the main premise we are trying to solve with some pain management doesn't work. There's a risk that patients will turn to things like heroin. But my concern is like it can happen with these alternatives too. If alternative pain management doesn't work, there's still a risk that patient will turn to some street drugs. And my question is like, is there a mechanism to quickly switch? Like if like physical therapy doesn't work, can a patient quickly switch to some pharmaceutical options for pain management? Thank you.
Yes. The intent of the bill would be for the treating physician to offer alternative care at a maybe 10-visit treatment period. I'm just throwing that number out. And then reporting back to the physician as to how things are going. So, yeah.
Yes, Representative McLean.
Thank you, Mr. Chair, and thank you for taking my question. And my question is just kind of stemming out of a little bit of ignorance and trying to understand some of the sausage making. So the back end of the bill deals a lot with the insurance and the coverage and those kind of aspects of it. So once you accomplish that, I'm going back to the voluntary non-opioid directive form. Once you incorporate the coverage, what is the necessity for that, and what would it look like? Because once you have the coverage, I would assume doctors would already be allowed to go forward with this. So just trying to put everything together.
I'm sorry, I really don't understand the question. So let me see if I can answer it, if possible. So if a patient is referred to another alternative care, and the coverage is provided by the insurance that they have, they're obviously being treated without having to pay for it other than the normal deductible. Did that answer that?
Well, no, I understand that because the bill introduces coverage. So now things which maybe were not covered in the past are now covered. So having accomplished that in this bill,
Okay.
at the very front end of it, it's talking about real rulemaking and the establishment of a voluntary non-opioid directive form. So I'm just wondering, why is the establishment of that form necessary? What would it look like? Having allowed for the coverage, why not just go forward? Why do you need to have the rulemaking and the form? So that was my question.
Good question. And I think that probably should be worked on again with other things that are popping up. I'm sorry.
Okay. Representative Weber.
So, and I apologize for sort of nitpicking here, but I think that there's very good concepts behind this bill, and I'm just trying to pick out how to deal with them. The bill is about non-opioid directives, and the first paragraph just talks about treatment, and then it says the healthcare practitioner shall honor the non-opioid directive, but you haven't talked about the non-opioid directive yet. And if I'm understanding, the commissioner is supposed to adopt rules starting with a standard form, but you took the standard form out if I have crossed out the right thing. So I guess my question is there somewhere here that I have missed that actually has the words that create the non-opioid directive before we start either honoring it or making rules about it?
No, that,
Okay.
you're right.
Okay. Thank you.
I'm sorry.
Other questions? Okay, seeing no other questions.
Thank you.
Thank you, Representative. Also signed up to testify on House Bill 554 is Representative Tom Dolan, also from Londonderry. Welcome, Representative Dolan.
Thank you, Mr. Chairman, and thank you, colleagues, for hearing my testimony. I'll be very brief, and I want to give a special thanks to Dr. David Lundgren for following this issue for now it seems like several years, trying to get it through the various wickets. This is very important, and I have some anecdotal information about things called Narcan parties. If you haven't heard that term yet, I'm not sure how germane it is to this bill, so I will offer that story if you so request, but I won't go down that road yet. I wanted to discuss testimony of third hand from Dr. Paul Reynolds, who is a 1978 graduate of West Point and a special doctor of pain management. He resides in California, so the drive to come testimony was a little long today. So I'm kind of subbing for that opportunity. I passed around a short article to his local Knights of Columbus on this topic, and I wanted to read it to you. Apparently, people cannot avoid using narcotics for longer than is good for them. Also, apparently not if doctors are aware of their prescribing drug habits can be a major problem. Many of us can look in our own medicine cabinets and find...
Representative, are you just reading the testimony you've given us? Or?
I am.
Yeah, we can do that. If you just want to summarize, and that'll be sufficient.
The summary is that people have what I'll call leftover pain medicine that's been prescribed, usually hanging around in their medicine cabinets, and they end up taking these medicines inappropriately and long after the need for them has subsided. And what this particular doctor has pointed out to me is that something I didn't realize is that the body, when it needs pain relief, makes an opioid-like substance and kind of takes care of itself. So by taking these opioids, it actually suppresses the body's own ability to produce these substances and therefore care for itself, and various things can happen, like getting hooked on these things and having to deal with another doctor to help wean them off or prescribe something else. And many folks are not aware that over-the-counter anti-inflammatories like Motrin, Advil, Aleve, and so forth do quite well to relieve some of these pain instances. So we need to make sure the doctors focus a little bit more on those solutions rather than the opioids that are prescribed. So with that, Mr. Chairman, I'm open for questions, and if you want to hear about those Narcan parties, I'm prepared to talk to that too.
Okay,
It's-
thank you.
It showed itself in the Manchester Fire Department recently.
Mr. Chairman, if I may.
Yeah, Representative Weber?
My suggestion is that I think that all the people on this committee, being the Health and Human Services Committee, are aware that there is a very severe crisis with respect to opioids, and that the real issue that I would want to hear about is, as is this bill, suggestions for remediating it rather than the depths of the crisis, which we all know about.
Representative Nagel.
You kind of stole my, thank you, Mr. Chairman, and thank you for taking my question. You kind of stole my thunder. I think we really need to get back to what the bill is about. But I did have some important things that I think need to enlighten, and I just have I'm curious, do you know, and I don't mean to put you on the spot, but I am. Do you know what the likelihood of developing an addiction to opioids, if you prescribe them for a diagnosis of chronic pain?
I don't know.
Can I answer the question? It's
At an exact.
all right. And do you know what the likelihood that you're going to develop an addiction when you're prescribed opioids for acute pain?
No, I don't.
And do you know what the likelihood?
I'm not a physician.
It's all right. I just think these are important issues that I needed to raise because I think we did lose focus. Thank you.
Other questions?
Yes, I get it.
Answer them.
What's that?
I see no other questions?
People testifying who can answer.
Okay, thank you, Representative Dolan.
Thank you, Mr. Chairman.
And you can only say it in an exact.
Also signed up to testify this morning is Representative David Love from Derry.
Morning, Mr. Chair, morning, committee. Thank you for taking my testimony. My name is Representative David Love from Derry, Rockingham 13. I'd like to give you some personal experience. You know, back in my late teens and early 20s, I had like three knee reconstructions, and eventually ended up having a knee replaced. But in the middle of that, there was a lot of back injuries because I was nursing the knee and what have you. Everything was getting thrown off, and I was offered pain meds often. I had 2 opioid addiction problems, you know, in my life. They're hell to get off of. I've been a member of Alcoholics Anonymous and Narcotics Anonymous for 32 years. I've seen a lot of families destroyed. You know, I've seen 6'4", 275-pound bikers reduced to a puddle of tears because of this. I've seen doctors, I've seen lawyers, I've seen CEOs, coming out of surgery, and they get shut off from their opioids, and the next thing you know, they're chasing things on the street, and it's a serious problem. You know, to have a doctor, just all. That's pretty much what this is in the beginning was, just tell people that, there's alternative therapies rather than going right to opioids. A couple of years ago, I broke my back. I fell out of a tree stand while I was hunting. It was an icy tree stand. It wasn't my brightest move getting in it in the first place, but I went to the hospital and they prescribed opioids for me. The next day I went to an orthopedic surgeon, and they gave me stronger opioids. And having my experience, I knew I didn't want to go down this road. I had to take them for a few days, but I ended up going to my chiropractor, and he did electrical muscle stimulation on the area that was broken, and he gave me a TENS unit, they call it, and it's a thing about the size of the pink cards you've got there. And runs on a 9-volt battery, and gives small areas of electrical muscle stimulation. Trust me, that saved me from another opioid addiction. Okay, it's just a little alternative care thing, And if the orthopedic surgeon had said, instead of the opioids, try this, or I'll give you a few days worth of opioids, I would have been a whole lot more comfortable. I don't ever want to be that blubbering guy sitting there, crying and wanting to die, you know, my family, you know, deserting me, you know, my kids don't want me, all that kind of stuff. That's the kind of stuff that, you know, that opioids do. And anything we can do to avoid that is, I think we have to do it. You know, naturally it gets tied up in all kinds of complexities here, you know, who's going to pay and all the rest of it. But I know for me that that little TENS unit probably saved my insurance company, you know, a 30-day stay in a rehab, maybe some additional rehab. We're talking over $100,000, you know, for $100
Thank you,
nine volt
Representative.
thing. You know, we're not talking big charges on the insurance company here. Just an alternative to
Sure.
disaster.
Thank you.
So-
Any questions for Representative Love? Representative Cushman.
Thank you, Mr. Chairman, and thank you for taking my question. Going back to Representative McLean's question about Section 1 of the bill, or, sorry, Section 2, about the rulemaking and the non-opioid directive form versus just having insurance be mandated. Do you believe that we need the directive form? Do you think that there's value to having the physician get in the habit of offering the non-opioids first by having them have this form?
As far as the form goes, a lot of medical practitioners now practice cover your butt medicine. A form like this would save any lawsuits from happening. You know, yes, you have been informed, and here's your signature on it. You know, I think it's a great idea.
Thank you.
Other questions? See a hand down here. Other questions? I see none. Okay. Thank you, Representative Love.
Thank you.
Also signed up to speak on this bill is former Representative Jerry Kinnerk. Welcome back to what I understand is your former committee representative.
Yes, thank you very much. It is nice to be back. For the record, Jerry Kinnerk, former, has been representative. And I also am a orthopedic spine surgeon, retired, and serve as the chair of the Therapeutic Cannabis Medical Oversight Board. I'm going to deviate a bit from my written testimony because I've having heard a lot of this stuff. HB 554 is essentially the same as HB 247 from 2021, which was retained and then went to interim study, and I chaired the interim study subcommittee on that. There are a lot of structural issues that have already been brought up in this hearing by Representative Weber and others. A couple of things I would just say on those. The amendment, I haven't had a chance to see it, but eliminating yoga is probably reasonable. We had concerns about non-licensed providers being included as being mandated to be reimbursed. Regarding Representative Leon's comment, I wouldn't recommend ITL on this bill and just going with HB 303 because I think a policy committee should weigh in on the importance of coverage, not just leaving it to the people that are looking at it as a business, because this is actually taking care of people. Also, the last thing is regarding the conversation about does offering coverage make a change? Providers are often very slow to change, and we saw how long it took us to get providers to come on board just dealing with the opioid epidemic to begin with. One important change in this bill is on page 1, line 10, when the word may is used, because in HB 247, the word shall was used. And that was a problem because that then was directive and basically was legislating the practice of medicine. That's, again, page 1, line 10. And those of us who've been in this committee for more than 4 years remember a hour-long discussion of the importance of may and shall on an elder abuse bill. So anyway, but the real reason I came, though, to testify in this was to request that therapeutic cannabis be added to the non-opioid alternatives for the management of pain. I brought this up during the retained bill hearing, but it didn't get in here. So again, I serve as the chair of the Therapeutic Cannabis Medical Oversight Board that is composed of 10 medical providers from different specialties, a patient representative, the head of the medical director of HHS, and also a clinical representative from an ATC. And we're charged with the statutory oversight of the medical aspects of the therapeutic cannabis program. Cannabis has been shown to be of therapeutic value in a number of different things, such as pain and PTSD. But the strongest evidence we have is indeed in the management of chronic pain. There's a landmark study by the National Academy of Sciences in 2017 that concluded that there's substantial evidence that cannabis is an effective treatment for chronic pain in adults, period. So it's got good evidence. And the key is it has a lot fewer risks than opioids. Cannabis does not cause respiratory depression. That's the mechanism of opioid overdose death. Even a short course of opioids may lead to dependence and addiction. As many as 1 in 4 people receiving prescription opioids long-term in a primary care setting may become dependent or even addicted, to answer that question that was sort of alluded to.
Representative Knoerk, if you could start wrapping up, and then we'll ask, we can.
May I have a little bit more time than that? I'm sorry, I would not have.
How much do you think you'll need?
A couple more minutes.
Oh,
Okay, I'll do my best.
Can you make it one?
I'll make it as fast as I can. But anyway, the bottom line is risk of cannabis use disorder is very small in therapeutic cannabis. In therapeutic cannabis, we are using cannabis at a low dose, trying to get a therapeutic effect without intoxication, because that is a side effect which is not desirable. We have in the therapeutic cannabis program, over 70% of our patients are certified for treating pain, with over 55% certified for treating chronic pain, which allows them to lessen the use of opioids. 82% of our therapeutic cannabis patients in New Hampshire report that therapeutic cannabis has allowed them to decrease the use of prescription medications. I saw this in my own practice as well. I retired just before therapeutic cannabis came in. As a spine doc, I saw a lot of back pain, and I saw patients I inherited on opioids. I tried to wean them down, rehab program, everything, couldn't get them off. When they went on therapeutic cannabis, they were able to go off. They did not need it anymore. I have one that kept up with some of these patients, their neighbors. And this person was able to just occasionally use a little bit of cannabis when he had an episode of pain and didn't fall back into that cycle of dependency again. But one of the major barriers that our therapeutic cannabis patients face is affordability, because it's not covered by insurance. Patients can access opioids cheaply with all of their risks, but they cannot afford the therapeutic cannabis. So some of them resort to black market cannabis, which then they lose the safety of testing and labeling and the counseling of the ATC. And that's, of course, the factors that make it more expensive out of an ATC. So I would really strongly urge the addition of to HB 554 of therapeutic cannabis as an alternative to opioids, given the proven effectiveness of therapeutic cannabis in relieving chronic pain, and a risk profile which is better than opioids. And I have a little list in the bottom of my testimony that talks about where you might do this to add therapeutic cannabis to the list of things that are offered to be done, and then also for the coverage. Also important to realize, as written, Medicaid, Medicare, and VA are not included. We can't do anything about Medicare and VA, but we should include this for Medicaid. Those are the people who are least likely to be able to afford therapeutic cannabis. And I'm glad to take any questions.
Thank you. Questions? Representative Polozov.
Thank you, Mr. Chairman, and thank you for taking my question. Would you be open to open it up to wider list of pain for pharmaceuticals that help with pain management? Maybe it's not only opioids or cannabinoids. We know there's some over-the-counter pain management that is not in these two categories. Is there a specific need to single out only cannabinoids in this amendment, or if we can open it to a wider range? Thank you.
I don't, thank you very much. I'm not sure one needs to, because in lines, let's see, where is it? Lines 15 to 17 on page 1 say by first administering less addictive non-opioid medications. The evil with making a list in statute is that the medicine changes. Statutory changes of necessity go slowly, so we should not have a list of medications that we put into statute, I don't think. But non-opioid opioid medications are included in this and should be used prior to opioids. All I'm asking is that therapeutic cannabis, which would be a non-opioid medication, would be included in that list. But I mean, to be explicitly included, because it's not something that would be necessarily often thought of. It's easy to think of Tylenol and naproxen, but a lot of people won't think of therapeutic cannabis.
Representative Weber.
And isn't the reason for another reason for including therapeutic cannabis specifically, as opposed to the entire range of non-opioids that can either be bought over the counter or prescribed, is that it's the one that is still up in the air as to its legal status, and so it falls into a different category than all the other non-opioid medications, all of which are legal either over the counter and by prescription, and therefore don't really need to be listed for exactly the same reason you were talking about. To list one is to include another.
Yes, it's that easy in the office to quickly write a prescription for Motrin or something like that. It's a little more cumbersome to certify a patient for therapeutic cannabis. It is something that we are working in Therapeutic Cannabis Medical Oversight Board to work on our provider education to have more people understand how it can be useful. But also, the other reason to explicitly include it is those other drugs are covered unless they're over the counter. Therapeutic cannabis is not, and I think it should be.
Representative Shapiro.
Thank you, Mr. Chairman, and thank you for taking the question. Do you foresee complications and problems with requiring the insurance companies to pay for therapeutic cannabis when, as the representative suggested, it's kind of in a gray area between legal and non-legal, and also because it's not prescribed by a physician. It comes to people through a different mechanism. So this is not a reason to not pass a bill, but do you foresee complications and resistance to actually doing this?
Yes, of course I do. That's perhaps why it hasn't been done before, and I'm certain that Heidi Kroll will make comments about this in just a few moments. But the bottom line is, yes, it is a little bit of a dicey situation. The way I've seen the federal government backing off from enforcement of federal rules in terms of therapeutic cannabis. That's been clearly delineated by President Biden, but also by various other directives and legal issues in terms of Department of Justice. So they are not pushing to enforce the federal rules over. So I think the state might have the ability to request that this be done.
Thank you.
Representative Nagel. I'm sorry, did you have a follow-up, Representative Shapiro? Representative Nagel.
Thank you, Mr. Chairman. Thank you for taking my question, Representative Knirk,
Excellent.
who has unwittingly become my role model for writing opinions. So you and I have had a lot of discussions about these issues over the years, and you know I've been involved with working on these bills for quite a while. This bill itself is really about non-pharmacologic options. I think a lot of what you raise is really important, but I'm wondering, is there a better strategy to doing this than incorporating it within a non-pharmacologic bill?
Sort of agree a little bit. That's why, for example, on the next one, HB 66, I chose not to weigh in because that was purely non-pharmacologic. But this one, again, in lines 15 to 17, does still make reference to other non-opioid medications, less addictive non-opioid medications. So that's the one thing that made me think it was still reasonable to attach it to this bill, because it did not appear to be purely non-pharmacological, but non-opioid. That was my reasoning.
Other questions? Yes, Representative Cushman.
Thank you, Mr. Chairman, and thank you for being here. It's nice to see you. I'm wondering, do you have any idea? I don't have an updated fiscal note for this bill. I'm just wondering what requiring coverage of these alternative therapies will, how that will affect insurance rates for private insurance payers in New Hampshire. Do you have any idea?
Well, I would defer on some of that to Ms. Kroll, who can answer that probably better than I. But there is important to understand how much impact we may have to be able to decrease other costs. There have been some good comments made earlier the addiction issue and rehabilitation is a problem, but also a lot of the interventions we use when we decide to do, facet block injections. Those aren't cheap. TENS units aren't $100 either. They're a lot more money than that. So if we can save those kinds of costs, that'd be fine. The patient that I alluded to, there was an old patient of mine, uses very little cannabis, but it keeps him out of that cycle. He went through an enormous amount of other interventions over the years before he found that actually gave him this relief that he needed. So there should be some real cost savings. Clearly, though, if we do add Medicaid, that will increase, in terms of a fiscal note, that would increase the state's responsibility because that's from us. For the insurers, whether there might be some upward pressure on premiums, I'm not sure that there would be. I think it might be neutral or even positive.
Follow up.
You're too young for that.
Well, I have a new baby, so that's my excuse.
It's true.
Wanted to ask you. I'm sorry.
All set. Representative Weber?
My question is, if you had a choice, as I think we have, between passing a bill directing people's attention towards using non-opioids first, and having a bill founder on the issue of the legality and insurance coverage and Medicaid coverage for therapeutic cannabis, which would you choose?
I would actually choose neither. I put a severability clause in. I would think, the severability clause if because this may change, but in essence, in terms of your question, I think it's a great devil's advocate question. I would choose getting this passed without therapeutic cannabis because it's important that this be passed.
And just as a quick follow-up, would you recognize that usually severability clauses apply to whole chunks and not eliminating pieces here and there?
That's probably true, but I just don't know if it could be structured that way or not. Yeah.
Thank you.
But I wouldn't want it. The key is to get where you're getting at. I wouldn't want therapeutic cannabis to torpedo this bill. Bottom line.
Other question? Okay, Representative Cushman.
Thank you, Mr. Chairman. I remember. Are you aware of any funds that have come from lawsuits against those who have kind of instigated and perpetuated the opioid epidemic? If there are any state funds that maybe could be used to offset the costs to either private insurance payers or maybe the cost if we were to add it to Medicaid. Do you know anything about that?
I don't have any knowledge of how the settlement funds are being used, nor do I have any capability to direct that.
Okay. I just,
Sure.
you know about a lot of things going on, so I just figured maybe you had some understanding of how that all
Have not
went down.
heard.
Thank you.
Other questions? I'm seeing no other questions. Okay, thank you very much.
Thank you. Good to see you all again.
Also signed up to testify is Dr. Mark Stagnone, who is a chiropractor. You have 3 minutes, sir.
Thank you, Mr. Chairman. I'd like to get back to the specifics of this bill. Unfortunately, it appears that it's cut into my time. I am the past president of the New Hampshire Chiropractic Association. I am also from Londonderry, as others here in the room are. I've been in practice for 36 years. I've been working on this legislation and like it for over 8 years now. I carry this headline from the Union Leader from January of 2014 with me as a reminder when I first started testifying on this type of legislation. I've worked with the governor's advisors, James Vara, Marty Bolden, and Dave Mara on this effort to work on this crisis. And I know we don't have to talk about the fact that it is a crisis, and you won't get any stories from me. I believe I have some answers to Representatives Weber, Murphy, and Cushman's points earlier as well, if I'm given the chance to speak on that. I distributed some information to you prior to. One of them looks like this, studies on non-opioids, and the other one says non-pharmacologics. That's just to give you a sample of the research that has been ongoing for years now. So oftentimes the question comes up, relative to the legitimacy of these non-pharmacologic approaches, and that's just a sampling. And there's a couple of these studies that have come out of New Hampshire. One out of Dartmouth College, which is used across the country. I won't go into the details because it appears I don't have the time. And one actually was commissioned by this legislature to look into this issue in some of our previous attempts. These studies have been looked at by other major organizations for years. The result that has come out of that is that the CDC, FDA, the Institute of Medicine, the Joint Commission, the American College of Physicians, the Veterans Administration, and the Canadian Medical Association have all strongly encouraged the incorporation of these non-pharmacologic procedures early in the treatment of the patient. And so I think that speaks well to the science that's behind this and the need and the necessity for it. We've lost years of valuable time in the state when other states have moved ahead on this. This legislation, as I understand it, is modeled after legislation that's been in place in West Virginia for several years now. And it'll also gives some reason to the need for the directive as it's combined with the insurance, which I'd like to make sure that we answer that appropriately. But we've lost a lot of time, and I hope that we finally are in a position where we can move forward on this. These states are seeing positive changes, and it's Ohio, Vermont, West Virginia, Rhode Island, Oregon. They've all passed legislation that has moved this type of action further forward, and really it's about our patients, and it's about getting our patients the adequate care they need, particularly the chronic pain patient. I'd like to just say a little something about the insurance component on this. We've been working on this an awful long time as well. So the two key components as we've kind of sat down and looked at this, and one pertains to the directive. Now, we're not trying to determine what the directive specifically looks like. This is probably going to be up to you people to decide what's the best avenue. But all the research has indicated, and someone made the comment about the physicians.
You could start wrapping up, but
are slow to change.
We do appreciate
but
that.
Yes, Mr. Chairman, thank you. But the directive is to make sure that a conversation takes place between the patient and the physician, that these alternative options are available. This has not been happening as a whole. The insurance component of this legislation, and undoubtedly, as we've always seen in the past, insurance lobbyists are going to come in and they're going to raise some doubts as to the amount of research that's available, or the cost, as it has been asked, how much is this going to raise costs? There have been many cost analysis done on this, and they all support the savings that is provided. But one of the primary things that happens in the state of New Hampshire that is allowed to occur is these insurance carriers are allowed to sell a product that includes chiropractic services. And they'll say, oh, we provide it. But then the patient arrives at our office and their copays are $40, $50, and even last week, $75 copays. when our maximum that we're allowed to charge is usually somewhere between $27 and $39 for a spinal manipulation. These patients are forced to, first of all, they're disillusioned because they think they have coverage when they show up to our offices. And then we break the news to them. Many of them return to their primary care physicians, go back to the pharmaceutical management because they do not actually have chiropractic coverage. It's a phantom benefit. It shouldn't be allowed to happen. It's deceitful, and it has been going on for years. So Representative Weber, relative to the amendment, the intent of that amendment was to clarify that there was a section in there that made reference to referred by a healthcare practitioner. Sometimes the insurance industry interprets that as being a referral by a medical practitioner. We wanted to make sure that doesn't happen. Representative Murphy, relative to that two elements of this, I think you were actually asking about the two relative to the conversation. It's about the conversation taking place, the directive between the physician and the patient. And this can be in whatever form you want it to be. You know, I think that's the bill kind of says that. Mr. Chairman, thank you.
Thank you, Doctor. Questions for Dr. Stagnone? Yes, Representative McLean.
Thank you, Mr. Chair, and thank you for taking my question. So I'm pretty clear on the alternative treatments. I'm pretty clear on the insurance elements. On the directive side of this thing, you're starting to fill in some of the pieces for me. Is it the intention of this bill then that the form is voluntary, but that the communication of the form would be mandatory, and so that's what's driving the conversation? Is that the intention of the bill?
I think so. I think it's not our intent to tell the medical practitioner how to run his or her business. But one of the clear components of this problem, as we've sat down with the governor's people and you read these articles on this stuff, is that the patients as a whole are not aware that some of these alternatives exist. And they look to their physician for guidance on these things. And if they're not being introduced to these other avenues of care, particularly early in care, very important. The Dartmouth study demonstrated a 55% reduction in opioid prescription writing when the patient was introduced to chiropractic care at an early point. This was based upon over 13,000 New Hampshire policyholders. They redid the study in 2020 and included Connecticut, and there's still over 50% reduction in opioid prescription when these alternatives are introduced early in the patient's care. And the directive is a mechanism, and we're not saying specifically what that has to be, but we need to have some influence that these conversations are taking place.
Representative Cushman? All set, okay. Yes, Representative Shapiro.
Thank you, Mr. Chairman, and thank you for taking this question. In reference to your comments about high deductibles, and I think you called it phantom coverage, which is an interesting description. Is there something specific about chiropractic coverage, or is that kind of across the board for many, many medical services? And would this bill not really affect that? Not to say that it's not an issue or a problem, but
I think what this bill does is, and it uses the ACA Act to try to ensure that there's consistency in a level playing field. That has not existed for us in the chiropractic profession. There are many instances, and this is usually the point in my testimony in years previous, where someone on the committee takes out their own insurance card and they're looking at it and they say, well, my chiropractic copay is $30. And that's not coincidental, because the better policies have the copay that's the same as the primary care physician, but the majority of the policies we see in our offices have these what they call specialist copays. They rate us as specialists. but from what I told you earlier, we're not being paid like specialists, okay? But we're categorized with the neurologists, we're categorized with the medical specialist who's probably getting $300 or $400 for a specialist visit. That does not pertain to us, and that's the dilemma that our patients are facing when they come into our offices. They look, and we have to break the news to them, and some of them they say, "Sorry, I can't do this," and that's the shame of this, and it's been what has allowed to perpetuate this over such a long period of time in this state, when other states have actually taken steps to address it.
Thank you.
Representative Nagel.
Thank you, Mr. Chairman. Thank you for taking my question, and this is an important issue. And the bill, as you know, is a lot broader than chiropractic, and I really appreciate your involvement in this. I've been practicing the state for 33 years, and I know we're going to hear testimony from the insurance companies shortly, but my observation, it's all about access to care. And my observation is that when I started here, there was substantially greater access to chiropractic care than there is now. I'm curious if that's your observation.
Absolutely. I've been in practice for 36 years. When I started in practice, the typical patient would come in with the 80-20 policy. There was no shell game as to what your benefits were going to be. You paid 20%, the insurance company covered 80%. And what evolved over time was this whole specialist copay, where they decided that they could move certain professions into different categories, and in doing so for the chiropractic profession, and even they did some of this with the physical therapists as well, where they could then enhance the patient responsibility. And what they did basically was they enhanced it to the point where the patient's fully responsible for all of their chiropractic benefits. The better policies still have the copays, same as the primary care physician, and we feel that that's a fair environment in which to practice. But more and more of these companies are using this strategy to enhance their profits.
Thank you. Other questions? Seeing no other questions? Okay, thank you very much.
Thank you, Mr. Chairman.
Also signed up to speak this morning is Laura Alazam from Londonderry also. Welcome. Always like to see Londonderry people up here.
Hello, everybody. Thank you for having me here today. I'm not a doctor or medical professional. I'm just a patient. And I'm going to read so I can go fast and not take up any more of your time than I have to. As a result of an accident over a decade ago, I developed chronic pain in my back and neck, which I successfully relieved with alternative therapy. It addresses the pain and lack of mobility directly, but it also works on correcting the underlying cause of my pain to forestall future issues. Although painkillers were always an option, I have been and remain unwilling to start down this path. My reluctance stems from watching my 23-year-old daughter descend in a few short years from a straight-A high school student to unemployable and homeless, all because of an addiction to opioids. You've heard more than enough of these stories. I won't tell you any more about that. But it's clear that we can't prohibit our way out of this societal nightmare. There's always going to be another drug to fill the demand for a cheap high, like xylazine, which is in the paper this morning. It's an animal tranquilizer that's causing a spike in overdose deaths locally. It's apparently commercially available for $10 or $15 a pound. Instead of that, we need to change the expectations and habits of patients, as Representative Cushman alluded to earlier, by presenting proven, reliable alternative therapies as the preferred primary option to address pain. HB 554 presents an opportunity or an off-ramp from a road that too often leads to abuse and addiction. It will preserve lives, real lives, that are parts of real families like mine, by affording patients a range of practical, proven alternatives to opioids for pain management. I ask that you please recommend HB 554 ought to pass.
Thank you. Are you taking any questions, or
if anyone has a question.
anyone have any questions? Okay, I see none questions. Thank you. Also signed up to speak is Heidi Kroll from America's Health Insurance Plans. Try to keep it around 3 minutes, if you can.
I will do my best. Good morning, members of the committee. My name is Heidi Kroll. I work at Gallagher, Callahan, and Gartrell, and I'm here today representing AHIP, which is America's Health Insurance Plans. We are the trade association for the health insurance carriers here in New Hampshire. We did sign in opposition to the bill. Our concerns, we don't take any position on Section 1 of the bill. Our concerns really have to do with starting in Section 2 and on, which are all of the insurance coverage sections, which, often those sections or bills with those types of sections have gone to the House Commerce Committee. So I was happy to hear a comment earlier by the vice chair that maybe those should be kind of set aside from the bill. I did want to say that health insurance carriers do provide, we do support alternative treatment options, both alternative medication options as well as alternative non-Medicaid options or pharmacological options. And we do, in fact, cover chiropractic care, physical therapy, occupational therapy, TENS units are all covered under standard plans. There's coverage for acupuncture and gym membership, which could include yoga and other forms of exercise, vary by plan, and massage is covered if it's part of a chiro PT or OT services. Carriers do offer different plans with different covered benefits, which do result in different premiums, and that's so that members can choose the plan that best meets their needs and their budget. We have been working very closely on these issues with a variety of parties over the years, and you've heard this morning that there, just this year alone, there are 2 other bills that are have similar topic or subject matter. One is House Bill 303. The prime sponsor is Representative Nagel. His is relative to insurance coverage for pain management services. That was sent to the House Commerce Committee. And there is a lot of similarities, starting with Section 2 on in this bill with House Bill 303. Yesterday, Representative Nagel requested that the committee retain that bill. And as you'll hear at your next hearing on House Bill 66, which is currently establishing a study commission, but I think it will be changed to a study committee to try to look more closely at all of the issues that are kind of wrapped into House Bill 303. And we've had conversations with Representative Nagel and Representative Merchant, and we're in total agreement to participate in those that study committee efforts and try to make some progress, I think, in terms of what people are looking for in terms of integrated care around a variety of services that could be offered to patients. We do want them to have options and access to alternatives. We don't want to see people getting addicted to opioids. We understand the costs that are associated with that.
If you could start wrapping up, please.
Sure, yes. The only other thing I think I was going to mention is just a reminder for people. I think former Representative Knirk might have mentioned this. Any of these mandates that do get passed only will apply to about 25% of the insurance marketplace, namely the individual and employer-sponsored, fully insured products. So a mandate such as you see in House Bill 554 would not apply to Medicaid, Medicare. It's not going to apply to self-funded employer coverage, which is becoming a bigger and bigger share of the marketplace. So government entities as well as large and even now medium-sized employers are offering self-funded plans. military coverage, of course, uninsured. So I just wanted to make people aware that this does target a relatively narrow sliver of the insurance market. And I think I'll stop there. I know I've hit time, and happy to answer any questions. Thank you.
Thank you. Yes, Representative Nagel.
Thank you, Mr. Chairman. Thanks for taking my question. I always learn something new every time you talk, so I really appreciate that. I'm curious, and I should know the answer to this, but I don't. Is workers' compensation, would they be included in this?
I don't believe so, no.
Thank you.
Other questions? Yes, Representative McLean.
Thank you, Mr. Chair, and thank you for taking my question. So, you say you already cover a lot of this already. So, what's new in this? From you say it's a narrow band, just 25%, but for that 25%, what does it add relative to what's already covered?
Right. Well, I was, as an example, we do have concerns. I know yoga therapy was discussed earlier. There's reference in here to Tai Chi, and I'm trying to find where it is, but some other kind of like what I'll call exercise programs like that. And so that's an example of where insurance is really meant for medical providers that are licensed and credentialed. So that's an example of a concern. There's also language in here about treatments, including but not limited to. And then there's a laundry list of coverage. So part of our question is, well, what else besides what's listed here? What's in the including to? And there's reference to 20 visits per event. And so I think when you start doing 20 visits and it's per covered service, and then you have an unknown number of services. So it's things like that that are just concern us in terms of not quite sure what, in fact, we would be asked under this to cover beyond what I mentioned that we are covering already.
Follow up, Representative.
So your primary concern, aside from the licensure issue, is just that you feel that it's being overly specific and it's taking away flexibility. Is that the primary concern you're saying then?
Well, I think it's overly broad with language like including but not limited to. Yes.
Representative Palmer.
Thank you, Mr. Chairman. Thank you for taking my question. My question is about evidence-based. Now, at the beginning, the prime sponsor talked about evidence-based treatments. I'm curious about what criteria your group uses to decide when the evidence base it reaches the level where it should be covered by insurance. Is it some degree of what Medicare accepts, or is there a specific process?
So first of all, I'll say that each health insurance carrier has a panel of an independent panel of medical experts that are continuously looking at all forms of coverage, not just specific to this. And so that's they're always looking at new evidence that's coming along, new treatments, new medications, whatever the case may be, and looking at the consensus around that and kind of, what coverage would be appropriate. Medicare is certainly a benchmark standard that's looked to by commercial coverage. So I think it's a, but you're right in both of those.
Thank you.
Other questions? Seeing no other questions. Thank you.
Thank you very much.
And the final person I'm aware of who has signed up for testimony this morning on HB 554 is Sabrina Dunlap.
Thank you, Mr. Chair and members of the committee. I'm Sabrina Dunlap, Director of Government Relations for Anthem. And I won't repeat what Heidi said. I just wanted to touch on a few key points.
Again,
One,
if you could stay within 3 minutes, that'd be great.
Oh, yes. Yeah. Just really quickly. So we were part of a group that came together last summer. I think it was HB 247, a very similar bill. And we are very interested in continuing those conversations. We've talked to Representative Nagel and Merchant and others about the study commission or committee that could come out of this. And I think that is very useful because what we ran into is we do cover chiropractic, acupuncture, a bunch of the services listed in here. But one of the issues we ran into last summer, we discovered is I think there's an issue around provider education in terms of recommending these alternative treatments. And so I don't think this bill solves that problem. So, and Heidi touched on when you get into other services like yoga, Tai Chi, they're not licensed by the state. They're not regulated. So it becomes a practical problem in terms of trying to cover those services. And one other issue I just wanted to mention, Mr. Stegno brought up this issue of copays. And you really get into benefit design, which gets complicated, especially when so many people have coverage under employer-sponsored ERISA plans, which again, state mandates don't touch those. And a lot of benefit design issues are determined by the employers who have those plans. So anyway, I think I hit all the points, and thank you for the opportunity to speak today. Happy to take questions.
Thank you. Yes, Representative Nagel. Representative Shapiro, I'm sorry.
Thank you, Mr. Chairman. I wonder if you could comment about, we heard from a previous person who testified about coverage for therapeutic cannabis, and if you could comment about the advisability or practicality of insurance companies actually doing that.
That is a good question. And I was thinking earlier when it came up, I actually don't know the answer. I'm happy to get back to you. My initial response is I do think it gets complicated because of the way cannabis is treated by state and federal government. I think there are probably challenges there.
Other questions? Representative Cushman.
Thank you, Mr. Chairman. Just a brief question. Does Anthem, do you guys cover naturopathic services?
Yes.
Okay.
Other questions? I'm seeing no other questions. Okay, thank you very much. I have no one else signed up to testify on this bill. Does anyone else wish to testify on House Bill 554? Seeing no one, I am going to close the public hearing on House Bill 554. Before we move on to before I open the hearing on House Bill 66, Representative King, would you like to speak?
Thank you, Chairman McDonald. Now that everybody, unfortunately, one just left, everybody was here from the committee that was here yesterday, I'd like to take a moment to apologize to the committee, to the general public, and to an individual named Eric Liu, who was testifying yesterday. During executive session, I referred to his title in a derogatory way, which was beneath my office. And I felt shamed the moment I said it, and I felt embarrassed the last 24 hours. So I'd like to extend that apology, and with the Lord's help, I'll never make that mistake again. So thank you again for giving me this time.
Thank you very much, Representative King. Okay, with that, I will open the public hearing on House Bill 66 and recognize our own Representative Merchant, who is the prime sponsor. We just had? Yeah. Oh, good. Representative Merchant, don't forget to do a pink card, please.
Oh, my God. Not another one.
You can do it after you testify if you want. Representative Nagel already gave us one.
Yeah, I was good.
You didn't have my name to it? Can we just add my name to his? No.
And you'll only get 3 minutes.
For the record, my name is Gary Merchant. I represent Sullivan County District 6, which is the towns of Claremont and Croydon. And as you heard earlier today through testimony in the previous bill, this is a complex issue. And having worked through this on House Bill 247, I actually worked with Representative Nagel, Dr. Nagel at the time, and also Representative Copal to try to find ways to, and also with the insurance industry, trying to find ways to try to take the complexity and make it more simplistic. What we learned along the journey with a multidisciplinary group of people, which is comprised of physicians, nurse practitioners, acupuncturists, naturopaths, patients, the insurance industry, is how complex this issue really is. So in saying that, what we all agree to, it should be a patient-centered multi-approach. And right now we don't have that. And we're trying to figure out how to get the patient back in the middle and let the patient drive the bus. Pain is fundamentally very subjective. It's really determined by the patient. And therefore we have to have multiple ways to work with the patient and let them drive the bus. House Bill 303, which Representative Nagel put in, and I co-sponsored with him, went to Commerce. And yesterday, as you heard, that when you have a commission, sometimes it becomes problematic to have it staffed. It's a lot easier to work with a committee than a commission. So I have an amendment to submit to the committee itself. What I want to say at this point in time is the intent also with what Representative Lundgren was also part of that work group is I think there's a lot of sincere interest by multiple parties to try to find a way to come up with a solution, or at least solutions, to how we can help patients deal with chronic pain or acute pain. And historically, having worked in the world of pharmacy, a lot of it was done through opiates, which had its own unintended consequences we're dealing with today. So the intent of this bill is to really pull the stakeholders together through a study committee and say, what are the barriers? What are the complex issues? Are there solutions that we could work with? There's no easy answer, but I think if we can put us all in the same room and talk about this, including the patients, we have at least a shot at trying to figure out how to unravel the knot. In saying that, I want to turn it over to Dr. Nagel, Representative Nagel, because he's done a lot of work as well, and I wanted him to take some of my time, Mr. Chairman, if that's at all possible.
Sure, go ahead.
You're supposed to wipe down the microphone. Thank you, Representative Merchant. Thank you, Mr. Chairman. Thank you, everybody. He already did the third part of what I wanted to do. I wanted to tell you who I am and why this is important. You kind of heard some of it. You kind of missed a lot of it in earlier testimony. Gary, we're buddies now. He explained why a committee is important. This has been a 33-year journey for me. My practice is, I'm a doc. My practice is, I work with people with complex disabilities. Very early on in my career, I came to the understanding that pain is a part of that, and in almost everybody. And what I was struck with was what a poor job we did of handling that, managing that. And I just, at that time in my life, I realized this is a vacuum, this is a hole, something needs to be done. So I began a 33-year career in advocacy. And I don't want to go over this testimony in any great detail. This is a partial list of what I've done, but I started advocating for the rights of people in pain. In a nutshell, I represent 66 million Americans who suffer from chronic pain. I represent 1.5 million Americans who are in hospice or palliative care at any moment. I represent all the people, the 50 million people that it's kind of doubles, but any 50 million that are going to get surgery, they're going to get perioperative, post-operative care. And I represent the untoward numbers of people that are going to suffer moderate to severe pain after acute injury. All their stories are really important. We heard some earlier today, but there's a lot more than that. As part of that, I initiate and I wrote all the state policies on opioid prescribing. I wrote this book that deals with everything we're going to be talking about this morning, and I'm proud to say that was sold on 4 continents, so I think it has value. I also chaired the NFL Players Association's Pain Management Best Practices Committee for the last 7 years, and I'm the lead author of our guide to managing pain and performance in athletes, but everything that we did is about what we're talking about today. So what we're talking about, the model exists. We've learned a lot about the opioid crisis today, and we've learned nothing. It's been said a lot. Everybody wants to blame somebody for it. I mean, we're happy to talk in detail about that with anybody because I've been involved with it since day one. But I think what we need to get away from is magic bullet thinking. We always think that this drug or that surgery or this chiropractic care or that yoga treatment's going to cure everything. And we know that that's not true. It may be for individuals, but not as a group. We need to get away from that thinking. And that concerns me also about cannabis, that we're going to get into that same magic bullet thinking. We've shown in Western literature since the 1980s that patient-centered, comprehensive, integrative, multimodality care is what patients need. In Eastern thought, we've known that for over 2,000 years. If you go to an Eastern practitioner, they're not just going to stick a needle in you or give you an herb or tell you to take up karate or something. They're going to give you all of that. And they've been doing that for 2,000 years successfully, and we have not. And that's a problem. And I'll leave it up to your imaginations as to why that is. This costs us over $650 million per year by not addressing these issues, and according to the Institute of Medicine. So it's a big financial issue. I know money is really important here. Anyways, with that said, these are guides that we're going to go over page by page right now, if you don't mind. I was actually involved in the authorship of both of these. This is the CDC guide to opioid prescribing. This is the latest version that came out about 3 months ago. And the Interagency Task Force from Department of Health and Human Services created this. There's actually a quote in my testimony from the CDC guide that I think you should read, and I'm not going to bore you by reading it now. Basically, what we have now, really, I want to just talk about crises for a second, then I'll wrap up. We talk about an opioid crisis. I will tell you, we have a crisis of overprescription. We simultaneously have a crisis of underprescription. We have an epidemic of costly, poorly evidence-based procedures that we pay for. And we can talk about evidence-based. Somebody asked that question earlier. You can ask me a question if you want. We have a crisis of a costly, inefficient healthcare system. We have a crisis of dependency where we force people into dependency. And our goal is to empower people with the tools they need to manage this difficult problem. All this has fueled the mental health crisis. And my biggest concern is we have a crisis of patient abandonment. And that really bothers me a lot. I run a nonprofit patient advocacy group where we deal with people that are dealing with we call them opioid refugees, the people that have been abandoned by the system to basically go to the streets for their drugs or whatever because they can't get them from a healthcare system that doesn't seem to care anymore. Anyways, there are 3 models on why this works. The VA has put together a model that they show integrative, comprehensive management works and saves money. The University of Vermont has a pilot program that is now a real program because they demonstrated all these cost savings already. We want to figure out how to do the same. And Gary, Representative Gary Merchant, Dr. Representative Gary Merchant and I both believe that we think that by putting minds in a room together, we can solve problems a lot better than just throwing things out. And unfortunately, to date, that's really what's happened. I'm a little sad that my bill got tied into 247 only because they're really very different concepts. They should have been kept separate. I want to finish with a story. So we met with players on injured reserve a couple months ago, and we already know how they feel about team doctors. So we asked the players, they're all in their mid-20s, how do you trust your team doctor? And the answer was an expletive that began with the letter F, no, and in a very loud language. And then that didn't surprise me. I already knew the answer to that. But then one of them said, I don't trust any doctor. And I looked at him and I said, what? And he goes, I don't trust any doctor. He says they're basically more interested in what they can do for me, how much they can make money off of me, how much they're dependent on a corporate structure that reimburses them and basically forces them into an interventional model, an insurance company that reimburses all this. And he was not talking about him as a professional athlete. He was talking about his family and experiences that he'd had. So then I asked him, well, we know that every NFL player has pain 100% of the time. So I go, how do you manage your pain? He then proceeded to write Bill H303 for me. I mean, everything he said that he uses is in HB 303. And I looked at him, I said, you know, you're lucky. And he says, why is that? He goes, you're an elite athlete. You can get all that stuff. Guess what? I work with retired players more than active players. And I asked him, guess what? The minute you retire, you're going to have access to none of that. And he just looks at me, and, you know, it was really a difficult moment for all of us. But we've heard we need to make a big difference, not just for elite athletes, but for people as a whole. And I will answer any questions anybody has.
Representative Weber.
Thank you both for your testimony, and maybe you could stay because, oh, you're doing the amendment? That was one of my questions, so I won't have to ask for a follow-up. But my question is very much in the where do we go from here line. My understanding is that 303 has been retained, and that's happened already. Yes. We have before us here two bills, one of which is a study committee, so, or one of which has very good intentions behind it, but huge drafting issues in it. So I guess my first question would be, are you recommending that we retain that one as well and pass the study commission?
Representative Weber, thank you for the question. Yes, it's my recommendation. I think also with Representative Nagel that we would retain that bill here in this committee to ultimately look at 303, look at 554, and then through the study committee to look at it and saying how can either meld them together or make them more workable. So it takes care of a lot of the questions you're asking about, and that is how it's drafted, the language within it. But more importantly, I think the critical part to it is getting the stakeholders in a room, particularly insurance carriers, buying into what we're saying. Because if we don't have their support, ultimately, it's probably not going to go anywhere.
Just to follow up on that, the second best day of my life was when the insurance reps, you know, said that they wanted to do this. Obviously, the first was when I got married, but that was the second best. So, I mean, you know, bringing people together is really important to solve a problem. As far as I'm concerned, what brought us together was the flaws of what was 247, and all those flaws are still in that. I would love to take credit for 303. I wrote that with Cindy Steinberg from the U.S. Pain Foundation, so it's based on national thinking. It's not based on local thinking. I also wanted to point out that I forgot to earlier. If you look in the list of organizations that support what we're doing, the Alliance to Advance Comprehensive Integrative Pain Management, of which I'm a founding member, has been looking at this issue for a while. It represents 92 organizations nationwide, including insurance companies. So we're all trying to work together to solve this problem. There's flaws with 303. I'm not that brilliant. There's flaws with 247. This is the way I think to fix those flaws.
And can I have one follow-up?
Follow-up.
And would you agree with me that as frustrating as it is after all this time and all these studies, to have yet another study and not a bill, it's more important to get it done right?
Yes.
I don't know if you can put that on the record, but yes.
Thank you.
I think one of the things we've seen in the past is we've done things sort of in different silos. And I think pulling together the various silos, the various members and stakeholders in each silo to talk about things across the silos to come up with something that's probably more workable. And again, back to the same thing is it really needs to be patient-centered. Pain is subjective. It's really up to the patient to determine what's working for them versus someone trying to make an artificial guess at what does work. So by keeping it patient-centered, with all of us is important too, that we include patients in what we talk to and what are the things that they see as barriers that they run into that we need to consider as the committee.
Thank you. Representative Weber.
And I have one last question, which is about the amendment, which turns the commission into a committee. Unlike the approach that we saw yesterday, you have chosen not to enumerate the people who are going to be consulted by the committee, but are you convinced, because I have seen committees like this work really well when there is buy-in from all of the stakeholders, are you sufficiently convinced that the stakeholders will buy into this process and work with you despite the fact of not being enumerated as committee members?
The reason I took it from a commission to a committee, I did not realize we sort of had a hybrid, which came to my attention with Representative Pearson. To list them, yes, I believe the stakeholders we've talked to are definitely involved with being part of the process. If you think, in your opinion, we should list them within the bill, I'd be okay
And
with
one
that.
last follow-up, and then I promise I will
answer
stop.
that as well. So we've been working on this issue for 30 years. We have a collaborative, a lot of the people of our coalition aren't even here today because they testified on 303. But we have acupuncturists, we have psych, we have nursing, we have chiropractic. I mean, everybody, and we've been part of this discussion together for a long time. I think this would formalize it. And thanks to Representative Merchant for putting that together, because he started that.
And for a final follow-up.
Go ahead.
And isn't it true that by not using the hybrid form, and not enumerating people, you avoid the problem that we heard referenced yesterday, where one association is favored over another association? This permits you to gather all the people who have an interest and then figure out how to include them in your structure going forward. So it's probably a better structure than the hybrid or the commission.
I would agree with that.
Thank you.
Representative Weber.
I also don't want to forget, Myra Christopher wrote the foreword of my book. She's one of my favorite people on the planet. And Myra always insisted that a patient or 2 or 3 or 4 be involved in this process. And it's important that they be involved as well. We don't want to eliminate them because they know a lot more about this than we do.
Representative Palmer.
Thank you, Mr. Chairman. Thank you for taking my question. This is a sort of a question about who's going to be involved. So I just had a meeting with the American College of Physicians, and one of the concerns is their primary goal is taking care of patients. And in the last years, what's happened is that doctors have really, and other providers have been really embattled and struggling. And so they've been trying to put a real emphasis on making sure that the people who are providing the care to patients are healthy and happy. And so my question here is, for example, and not sure in New Hampshire because I practice only in Vermont, though I'm here, with the prescription monitoring issue, we have a new form and a whole procedure we need to follow whenever we prescribe opiates. And that has led to a decrease in opiate prescription in most cases for better, in some cases for worse, as you alluded to. I just want to make sure that on this committee you have that kind of input, so whatever comes out of it is going to make it not a cumbersome process for people to access whatever modalities they're trying to prescribe.
Thank you for the question, Representative Palmer. As it happens, I also serve on the Prescription Drug Monitoring Program as Advisory Council. So yes, we will have linkage between that and what we're doing today.
Other questions?
Can I answer that as well?
Sure.
You're going to get a long-winded answer, and we can do that as a sidebar. There's a whole chapter in my book on what you just asked. I'm not convinced that we as doctors really have our patients' best interests in mind anymore. And I'd be happy to discuss that in greater deal if you wish. And the whole purpose of everything that we're doing is to try to bring everything back to the patient, away from the corporate structure, away from the computer. Because my patients tell me that they don't think their doctors care. That NFL athlete said they don't care. And it's usually because of things that are extraneous to them that's changed all that. And that's why patients are important. I think we've overemphasized the problem with opioids, and that's a sidebar discussion too. I'm bothered by that because I know we have a list, we call it our suicide watch, of patients that have died because of being abandoned. And those are important issues to me. Thank you.
Other questions? Representative McKay.
Thank you, Mr. Chairman.
My background is in the mental health field. I'll make this very short. I had some kind of minor surgery. I frankly have forgotten what it was. They gave me these pills. I took 2, 1 and 2, and stopped because I was looking forward to the next one. Now, in the mental health field, to me, that smells like addiction. And so nobody told me to do anything. I just did what I thought was important. I went to Concord Police Station and put those pills in that container, even though one of my neighbors said those are worth $75 a piece if you want to sell them. I didn't. In other words, what I'm saying is that it's very important to involve the patient, which we all are pretty much, in this kind of terrible addiction. And to, what I did was very simple, but I think it probably stopped something that could have been quite serious. So I just wanted to add that on.
Okay, thank you. Go ahead, Representative Merchant.
If I could follow up on Representative McKay, one of the things that we'd be looking for on the study committee is members from this committee or people within the House to serve and help walk through it. If you would be willing to be part of that, I'd be more than glad to. Suggestion
I'd be
A.
glad to. Yeah.
Thank you.
I'm thrilled to death you said that. That's another sidebar discussion. We don't manage prescriptions well, and I think we need to do a lot better job. And that should be part of our discussion too.
Thank you. Other questions? Seeing no other questions? Okay, thank you, gentlemen.
Thanks. Thank you.
I have no one signed up to testify on this bill other than these 2 gentlemen. Does anyone else wish to testify on HB 66? If not, I am going to close the public hearing on HB 66 and open the public hearing on HB 500 and recognize the prime sponsor, Representative Hacken Phillips. We just did 66. We just opened it. 500. Okay. Good morning, Representative. How are you?
Good morning, Mr. Chair. For the record, my name is Representative Mary Hacken Phillips. I represent Grafton County District 12, which covers Hanover and Lyme. If the committee is ready, I'll dive in.
Sure, go ahead.
So I'm here to introduce HB 500 relative to prescribing opioids via telehealth medicine. I'm here actually today because a number of constituents who live in our district that I also serve with Representative Murphy are practicing surgeons at DHMC in Lebanon. And recently, I think it was November, they brought to my attention an upcoming change in the law that they were going to be required to change their current practices. And my understanding is that in January of this year, coinciding with the expiration of some federal flexibility in regulations related to telehealth medicine, that these physicians were being asked to change their normal practice of prescribing opioids, either new or refill prescriptions of any Schedule 2 to 4 opioid drugs. Just a side note here, that's limited exception for methadone hydrochloride, and I'll let the experts behind me speak to that issue. But this change in prescription for New Hampshire patients affected specifically telephone and audiovisual telehealth visits with their patients to accommodate a change in New Hampshire law, specifically RSA 329:1-D, related to physicians and surgeons, and 326-B:2, which is related to nursing. This change in law required any new or refill opioid script to be issued with an in-person visit with that patient, regardless if the provider had already established an in-person relationship with that patient. So to be clear, this in-person visit requirement is a much more restrictive practice than the past, and then our current New England neighbors in Vermont, Massachusetts, and Maine are practicing. This is bringing this to your attention because it's adversely affecting our state's healthcare systems. So to try to give you an example of what I'm talking about, let's just walk through a scenario. Say you've recently had a major surgery. It required you to be hospitalized for 24 to 30 hours after that surgery. The good news is that on post-op day 2, you are doing well and you're going to be discharged to go home and convalesce. You spend several hours headed home with the help of your friends or loved ones, and you finally get in your own bed to rest. But late that night, you wake up with some pain. The issue is that the powerful drugs used during your surgery and during your stay at the hospital are wearing off. You told yourself and your doctor that you didn't believe you would need an opioid to go home when you were discharged, but now that you're there, things have changed, and you realize you need help. You call your doctor's emergency line to ask for a small script to get you through the next few days of surgical recovery. Under current law, your doctor would be able to, your doctor who just saw you 2 or 3 days before would be able to give a call to your local 24-hour pharmacy, call on that script, and get you that small prescription. But under this new law, your doctor would have to tell you that you'll have to return to the hospital and see her in clinic, which may actually be the following week on a specific day that surgeon has clinic. It may not be right away. This is less than ideal because you have no more time to take off of work. Your friends and loved ones can't help you with the trip back. And frankly, gas money is really short. So meanwhile, your pain is not stopping and it's getting worse, so you're going to scramble. You may seek emergent help in an ER or first of all, we all know the ERs are overloaded right now, just anecdotally. Or you may call your primary care physician and attempt to get an appointment there, but you may also know, anecdotally, that getting in to see a primary care physician could be more than a year's wait at this time. Alternatively, your provider, your healthcare physician or nurse may plan ahead and determine to go against the last 2 decades or more of academic research in the field of studying overprescribing of opioids and the good work over the past decade of combating the opioid pandemic, and preemptively discharge patients with an opioid script in the off chance that they need these pills once they are discharged. Thereby flooding our state with additional opioids that we all know is not needed. So this example shows you how current law creates a very desperate situation that is completely avoidable. And this bill attempts to do a little something to try to correct that situation. I'm happy to walk you through the 1 page of language here in the bill if the committee would like so, but before I do that, I want to get out of the way so that the committee can hear from the experts in this matter. My job today is to briefly explain a few points of why this legislation is needed. The first, as a problem with the current law, is economic. We understand requiring patients to travel another time is expensive when many folks already don't have the cash in their bank accounts to make an extra trip to see their doctors. When we're talking about confronting soaring energy prices and inflationary pressures and other economic tough times, it's really forcing patients to do without critical pain relief, and this is really cruel. Current law also puts some of New Hampshire's largest employers at a competitive disadvantage with their Vermont, Massachusetts, and Maine competitors, their peers who prescribe opioids via telehealth, when we all know that the marketplace right now in healthcare is extremely tight. This point cannot be understated. This is a competitive disadvantage for our state. The next problem with this current law is logistic, requiring people to travel again across the state multiple hours when business can be conducted safely over the telephone or with an audiovisual telehealth medicine visit is just silly. I mean, frankly, extra trips mean extra emissions, extra costs. Logistically, we're crowding the roads and creating more problem that's really needed. The third issue is administrative efficiency. Requiring an already short workforce to duplicate efforts and find another time for an in-person visit puts additional stress on a system that's already experiencing historic challenges. Wait times are already extremely long to just get that first appointment. So Let's help our providers out at a time when burnout is high and stress on the system coming out of the coronavirus pandemic is already at an all-time high. Let's do something about, a small thing that can help out the system. Fourth, current law is problematic because it's overly paternalistic. We know that there are already federal and professional guardrails in place to make prescribing opioids safe via telehealth medicine amidst a deeply concerning opioid pandemic. New Hampshire does not need to pile on extra red tape and regulations here. It is safely regulated. Fifth, the problem is a human one. Our current law is going to make all of us suffer. Whether you're the patient seeking the actual new or refill prescription of opioids, or you're someone else seeking care with your primary care physician, or in the ER trying to get emergency care, or at some other access point in a healthcare system, the bottleneck this law creates is a strain on resources and precious provider time. It's going to adversely affect our system and all of us who take part of it. People are going to suffer needlessly for the delay in care and sometimes bypass that care altogether because of the current law. So what you have today before you, HB 500, is a fix on what I believe to be an inadvertent hiccup in current telehealth law. The drafted language was a result of DH's coordination and leadership, thanks to Matthew Hood and his team, and others, of course. I believe this legislation will make a positive impact on our state. So before I turn over the hearing to my co-sponsor, if he plans to speak, I'm not sure, and other folks here from Dartmouth-Hitchcock and the healthcare profession, I'd like to just share that I've separately spoken to stakeholders at the New Hampshire Medical Society and the New Hampshire Psychiatric Society, who are both groups are on board in support of this legislation, and I believe are submitting online testimony to that effect. So at this time, I'd like to urge the committee to OTP HB 500. Thank you for your time and consideration, and I'm happy to answer any questions.
Question, just Representative Weber.
Thank you. So now turning to the bill. I've heard a lot of very great policy, but I need to understand how this bill furthers it. And I'm just looking at the language of the bill. First of all, on line 1, there is a reference to out-of-state physicians, and I don't see anything in the bill about out-of-state physicians, nor is it inserted in a place in the statute that is restricted to out-of-state physicians. So if I may ask the first question, why is that there?
My understanding is that the chapter RSA 329:1/D regulates telehealth medicine for surgeons and physicians. I think that the subchapter out-of-state physicians is just part of the order that it comes down through the RSA. So to answer your question, I don't think it only has to do with out-of-state physicians. It creates effect to any physician that serves in the state of New Hampshire for a patient in New Hampshire.
Okay, so may I have a follow-up?
Follow-up.
I guess this is perhaps one of the details that Office of Legislative Services may have overlooked in drafting.
You've answered my question in that you want it to apply to everybody. So we just need to investigate the drafting. Then for the follow-up, what you're doing is what you're doing. Number 1 talks about what physicians are going to do. Number 2 talks about the use of telemedicine for nursing, and it's just the physicians and the nurses that you're discussing here. Is that correct?
Yes, I think those are the two major pieces of legislation that currently control opioid prescriptions through telehealth medicine. So this is where we've concentrated the effort on those two groups, essentially.
And one final question.
Follow-up.
Thank you. And is this not an issue of nurse practitioners or advanced practice nurses of any sort? Because I know that we've often had to revise 4 sections or 5 sections, and they may just not prescribe this kind of thing within their scope of practice, and only if you know.
So I can answer this question in 2 steps, Representative. Thank you for the question. First, if you'll see subsection B and C under paragraph 2, I'm sorry, B also speaks to the APRN issue that you just brought up.
But only out of state.
Yes. And then that may go back to the previous concern you had about the out of state. My understanding is that this legislation is geared for in-state healthcare providers, both physicians, surgeons, and nurses. So I will, again, I put that under the first concern that we spoke to.
Thank you.
And then I guess I would like to just follow up with that, finish that thought and say, I am not an expert in the field of medicine. I am an attorney by trade, so I will defer the more ins and outs, scientific, technical questions to the folks who are going to come after me today and speak to the issue.
Thank you.
Other questions? Yes, Representative Shapiro. Is your microphone on?
Oop. Thank you. Thank you, Mr. Chairman, and thank you for taking this question. I'm having a little trouble reading this bill in the context of the RSA, so I may be missing something, but much of the bolded text has to do with, it seems to me, maybe I don't understand it, making it unlawful for methadone to be prescribed by telemedicine. Is that your intention?
So my understanding is that there is that the methadone and substance use disorder category is separate from this legislation. So there's a special carve out for that. So it's not included, is my understanding. But we will have folks here who can speak to those ins and outs who follow me.
Representative Leon.
Thank you, Mr. Chairman, and thank you, Representative, for bringing this to us. As I was trying to look at this section, it looks to me, I'm not an attorney, but reading through here, it appears that there's already that section that you reference, which is 12D, that already provides for all of the non-substance use disorder opioid uses.
Yeah, so I think you are correct that that's why it's an exception from this legislation. There's already special language for that medicinal prescription.
Representative Weber.
So might the explanation be, as one who was been involved with this paragraph for longer than I care to think about, that the existing Roman 3 disallows prescription of any 2 through 4 drug. So currently it's disallowed. And this allows everything but methadone and drops the other things down to paragraph 4, which is the allowance part, which is not perhaps terribly clear to begin with, but might be clearer afterwards.
Your belief is my belief. Thank you.
Thank you.
Other questions? Yes, Representative Merchant.
Thank you, Mr. Chair, and thank you for taking the question. The part that's referring to the methadone is really controlled by federal law versus state law. So that's what you're touching upon, I think. But in saying that federal law through the emergency orders currently does allow for a existing patient to be treated with methadone through telehealth, would you be opposed by adding that language as long as it doesn't conflict with the federal law? Because many times for a lot of the patients who are being treated with methadone, they have to travel a long ways, which you brought up before. So would you be opposed to trying to tailor this to what the federal law does allow, to allow for people who are getting methadone, not the new patient, but existing patients, to be able to, at that point in time, not have to go all the way back 2 hours away to see a doc?
Thank you, Representative Merchant, for the question. I'm going to defer that response to the experts at Dartmouth-Hitchcock who are here today to testify about that issue.
Other questions? Yes, Representative Nagel.
Thank you, Mr. Chairman. Thanks for taking my question. This has been an entertaining discussion because access to care is really important. when I looked at this bill immediately, I mean, I work with people with addiction, I work with people in pain. That methadone thing leapt off the page at me, and our ability to prescribe that for people with addictions who live 200 miles away from me is a huge issue. Is it possible to just get rid of that language in this bill altogether if it's covered somewhere else? Oh, I don't mean that, what they've added, the language they've added, to take that out of what you've added. I don't understand why that's added.
Again, I will defer to the folks at Dartmouth Health who are here today, who helped craft the language of this draft. So they have far more expertise and understanding than I do of the issue. So I will
appreciate that. Thank you.
Other questions? Seeing no other questions? Okay, thank you. Also signed up to speak is Representative Jim Murphy. Welcome to the other side of the table, Representative Murphy. And again, we can, if we can do it in 3 minutes, that'd be great.
Thank you, Mr. Chairman and committee. For the record, my name is Jim Murphy. I represent Grafton 12, which is Hanover and Lyme, along with Mary Hacken Phillips. And I'm here today to support the bill I co-sponsored with Representative Hacken Phillips, House Bill 500. So there's a couple questions I think have to be answered first. I know we have Mr. Matthew Hood from DH, as well as one of the providers from DH that deals with it specifically. But one of my first issues with this bill is I think it's somewhat of a misnomer. The bill basically says prescribing opioids. The bill really is allowing the prescription of Schedule 2 to 4. That's a much broader and much more important in many ways. The other thing I would mention is that telehealth is here to stay. Telehealth is grown substantially in the past 10 years. For instance, at Dartmouth Hitchcock, in the telehealth section, I was talking to Dr. Kevin Curtis, the other day, and I've known him for a while. He told me that prior to the pandemic, this is amazing, we had only 12 outpatient visits per day in the telehealth clinic. During the peak of the pandemic, that went up to 2,600 a day, outpatient visits. And now currently is plateaued around 500 to 700. So telehealth is here to stay. And I would say it now represents about 10 to 15% of the outpatient visits at Dartmouth at this point in time. But this is not a bill about telehealth. I would also say it's not just a bill about opioids, it's about Schedule 2 to 4, which is much broader. And to me, this bill, and I know we have experts behind me that deal with on a regular basis, taking care of these patients. This is really this is a bill to help support patients in very difficult situations. When I talked to Dr. Curtis the other day, what is going on right now is that we were able to schedule 2 to 4 drugs via telehealth during the emergency period of time. That will be lifted, I believe, on May 10th or 11th, something like, thank you. When that happens, we revert back to the rule whereby you are not allowed to prescribe by telehealth Schedule 2 to 4. That is not just opioids. When have we ever had a bill or a policy change come before us when we've actually done the trial, the clinical trial before it? When I asked Dr. Curtis what happened during the past few years when they were allowed to prescribe opioids and other medications, they actually had absolutely no problems whatsoever. So to me, that means that has already been tried and true process in management of these patients. They had absolutely no issues whatsoever. And one of the other questions that just came up about methadone. My understanding about methadone is a Schedule 2 drug, and it has been carved out specifically by the feds because this is what they call a drug that can be prescribed only through SAMHSA, which is Substance Abuse and Mental Health Service Administration, and only by OTPs, which are opioid treatment programs. Now, I'm not sure that could be incorporated into telehealth. I would leave that to the folks from DH to tell me that if that could happen or not. But having said that, I would like to speak mostly to the clinical side of this, which I think is critically important. This is not just opioid treatment and management. It's chronic pain for many, many variety of issues.
Representative, if you could
Sure.
summarize.
So the ones that I would bring up would be palliative care. Imagine somebody at home, under palliative care needing opioids or any other medications. Imagine the adolescent at home with ADHD that is on Adderall. They don't have to interrupt a full day of school or work for the mom or dad. They could actually have a telehealth visit with mom or dad present with them. Post-op pain changes, as was mentioned by Representative Hacken-Phillips. You could send a patient home and they tell you, because you could put drugs into their surgical sites that keep them comfortable for 48 hours, but when they get discharged, they then have an escalation of pain. That can change. From a personal experience, I can't tell you how many times I would walk through an orthopedic, waiting room, tripping over wheelchairs, crutches, walkers, even having patients come from the nursing homes on gurneys through an ambulance, which is very costly. They don't have to come to the hospital to have this taken care of. We can schedule all of these drugs via telehealth, and I think it would be very, very helpful. This is basically a patient-centered caring bill, and I would support this bill. Thank you.
Thank you. Questions? Representative Weber.
Thank you. So to summarize, wouldn't it be fair to say that what this bill does in the end is remove the restrictions that were the cost of passing any telemedicine bill at all back prior to the pandemic, because we now know that we can do it safely, and it provides much better patient care and patient access. So the barriers that were created as the price of getting any telemedicine started are now not necessary because of our experience with it.
I couldn't have said it any better. When else do we ever have a clinical trial that precedes the institution of a policy?
Thank you.
Other questions? Representative Shapiro.
Thank you, Mr. Chairman. I'm hung up on the language about methadone.
Okay.
And early in the pandemic, we actually passed a telehealth bill, which was part of it was focused on enhancing MAT, medically assisted treatment, in underserved areas, in the doorways, and specifically in jails where there had been a court case where that people were entitled to get that kind of treatment in jails. So we passed a bill allowing those medications to be prescribed. To tell you the truth, I'm not absolutely certain that if methadone was included or if it was just Suboxone. Maybe there's somebody else here who knows the answer.
You took the words out of my mouth, Representative.
But maybe you know the answer.
No,
But my question is, this bill, I assume that you wouldn't want to do anything to limit those kinds of services for people, and I assume that this bill is not intending to do that. Is
No,
that true?
That's true. And I would defer to the folks from DH who deal with that much more than I do about exactly how to manage that going forward.
Thank you.
Other questions? Oh, I'm sorry. Okay, Representative Nagel.
Thank you, Mr. Chairman. You made me feel a lot better, with one exception. And I'm curious about, I still have to get back to the methadone restriction. In pain management, methadone is an awesome drug for refractory neuropathic pain. It certainly has a lot of limits. A lot of our patients live a long distance from where we go. You don't need to be in one of those settings to prescribe it for pain, but you need a lot of expertise. With an established patient, I would still want to be able to prescribe that by telemedicine. And I'm concerned that this bill takes that out.
And I agree with you, and I don't disagree with your intention with that. But I think that was actually carried forward from the previous statute, but I can leave that to, again, Mr. Hood and folks from DH to try to explain that better, and any remedies for this going forward, because I agree with you wholeheartedly.
Thanks.
Yeah.
Other questions? Seeing no other questions? Okay, thank you,
And
Representative.
I have one editorial comment on the side. I hear about the patient's disappointment with medical care in general. I agree with the sentiment that I hear it regularly, but I would argue that we do not have a healthcare crisis in this country or in the state. We have a healthcare access and administration crisis. And so I honestly I push back a little bit because providers in this state give us the best care possible. They are sometimes hackled by outside forces that we can't contribute, which trickle down to patient sentiment regarding the profession. Thank you.
Thank you. Okay. Also signed up to testify is Meredith McMartin from Dartmouth Health.
Can I come up with my colleague? We won't take up more time than is allotted.
Are you Matthew Hood? Okay, sure, if you want to both come up, that's fine. Yeah, okay, sure, go ahead.
I was just saying, I'll speak to the corporate perspective that Representative Daigle is concerned about, and Dr. McMorton can speak to the patient and provider perspective.
Yeah, I think you both asked for 5 minutes. If you can shorten that a bit each, that would be great.
Thank you. Thank you, Mr. Chair, members of the committee. For the record, my name is Matthew Hood, Vice President of Government Relations at Dartmouth Health. Pleased to be here today. I think Representative Murphy answered a number of the questions that were raised in the first go-around. So I will just acknowledge that this committee has heard a number of bills over the past number of sessions with respect to telehealth generally, as well as telehealth prescribing in particular. And I wanted to thank you for your taking the lead, the legislature for taking the lead in the SUD space. What the law currently provides is that providers cannot prescribe Schedule II through Schedule IV drugs via telemedicine with the exception of SUD treatment. Carved out of that exception is methadone. We have not changed that provision, not for any intentionality to carve that out. It's already been excluded. Dartmouth Health does not provide methadone services through our doorway. But we're not opposed to that unless from a very pragmatic perspective, Representative, it's going to kill the bill, in which case I would be opposed to carving that out. That being said, during the pandemic, the administrative arms acted as well, right? So on the state level, there was an emergency order that enabled the provision of healthcare via telehealth, all modes of healthcare, which included prescribing. That has expired. That's gone away. You also had the federal public health emergency that enabled flexibilities that has been noted before is going to go away May 11th. So what this bill does, I view it as enabling the flexibilities that the public health emergencies provided with respect to telehealth in general and prescribing via telehealth in particular. There are a range of healthcare services that would be impacted by this. The utilization of prescribing via telehealth. And keep in mind, medications for many of these health conditions are controlled substances regulated by the DEA. That's what we're talking about. So I think Representative Murphy talked about Schedule II stimulants for ADHD. Behavioral health issues were raised. Dr. McMartin is going to speak to palliative care and oncology space. I think Representative Murphy, in personal experience in post-surgical pain management, has raised that as well. We know telehealth is an effective mode of care delivery. It's also an essential tool to address the current imbalance between demand and capacity. Moreover, it addresses the inequity of care options in a rural region. Frankly, it's a whole lot harder to get to an in-person visit in northern New England than it is to get to a visit via telehealth. We've seen that through the pandemic, and we've seen patient preference for the continuation of telehealth. In closing of my portion, I would just note 3 additional pieces. I think actually, and I wanted to thank Representative Hackett-Phillips for introducing the legislation, the laws of the states that surround us, Maine, Massachusetts, and Vermont, enable prescribing via telehealth if licensed and in the state and DEA registered. The DEA is set to issue guidance with respect to prescribing, both in the SUD space and in telehealth prescribing in general. If we want to take advantage of what we expect those to be flexibilities, our state law has to accommodate that too, because you have to go to the most restrictive law. And finally, safeguards, and I'm going to leave behind a piece for you, that exist with respect to opioid prescribing concerns generally remain in the prescribing via telehealth space. And you'll see the list of safeguards that exist, or I'm happy to speak to them if there are questions. Thank you very much, Mr. Chairman, members of the committee.
Thank you. Do you want to both speak, and then we'll
I defer to you, of course, Mr. Chair.
why don't you go ahead, Doctor, and then we'll take questions for both of you.
Thank you. My name is Meredith McMartin. I'm a palliative care physician at Dartmouth Hitchcock Medical Center. I'm an assistant professor of medicine in the Dartmouth Institute for Health Policy and Clinical Practice at the Geisel School of Medicine, and I'm the medical director of the Jack Burns Center for Palliative and Hospice Care. Very glad to be speaking here on behalf of our palliative care team and our patients and their families in support of this bill. For those who may not be familiar with it, palliative care is a medical specialty focused on improving the quality of life for patients with serious or life-limiting illness and their families and care partners. Our interdisciplinary team provides support with care planning, medical decision-making, navigating the emotional challenges that come with serious illness, and often the prescribing of medications such as opioids to relieve the physical suffering from pain and other symptoms. At the beginning of the COVID-19 pandemic and public health emergency, our outpatient clinic converted nearly overnight to a primarily telehealth model. A significant proportion of our outpatients continue to receive their care by telehealth by their own choice. For our team, we want to be able to prescribe controlled substances to patients like ours as a matter of equity and patient choice. To speak to the matter of equity, we know that rural residents have far less access to health care in general than urban residents, and palliative care is unfortunately no exception to this. During the public health emergency, we were able to provide care, including the prescribing of necessary medications for patients who were too sick to travel long distances safely or who were unable to get transportation for a variety of reasons. We surveyed telehealth patients in our clinic and found that on average, our patients drive 70 miles round trip to get care with us. That's the average. And many identified the cost of travel and the logistics of transportation as major barriers to in-person visits. As an example, consider one of our real patients who has end-stage emphysema and metastatic lung cancer. She requires intensive and high-level respiratory support to help her lungs function and has extensive painful tumors throughout her bones. During the public health emergency, our team prescribed opioids to safely and effectively manage her pain and shortness of breath. Because of the severity of her lung condition, traveling quite distances is actually quite dangerous for her, and she's currently without someone locally who can continue these prescriptions. She lives 90 minutes away from our clinic, and she is suffering. We believe that all patients with serious illness deserve access to the high-quality medical care that's more readily available to patients who live in bigger population centers, who are financially secure and otherwise well-resourced. Regarding the matter of patient choice, I think our state's reputation for individual autonomy speaks for itself. Palliative care is a specialty which puts the goals and values of each patient at the very center of our work. We believe that patients should get medical care that is consistent with those goals and values, whether it's aimed at living longer, maintaining physical function, or focusing on the quality of their life. It became clear to us during the public health emergency that allowing patients to receive palliative care in the manner of their choosing was a powerful way to honor patient choice and autonomy. In our survey of palliative care outpatients, more than half expressed a preference to continue to receive palliative care by telehealth. In a state which values individual choice, we believe that patients and their medical team should have all the possible tools available to them so that they may decide for themselves how best to receive medical treatment, whether it's palliative care or has been discussed by others, cancer care, treatment of behavioral health issues, or post-operative care. In summary, our section of palliative medicine at DHMC is in full support of this bill as a way to help ensure that the sickest and most vulnerable of our neighbors and patients are able to access medical care that is consistent with their values and alleviates their suffering. Thank you very much for the opportunity to speak on about this bill, and happy to answer questions.
Thank you. Questions? Representative Weber.
Thank you so much. Thank you, Mr. Chair, and thank you both for being here, and welcome back. former Representative Hood. As a matter of drafting, are we creating any problems other than issues of political will if we remove the methadone exception? Because if there's no reason to keep the methadone exception in there, and we've heard several people say it might be nice to get it out of there, then one might be able to also eliminate one section of the bill, and instead of saying it shall be illegal except for that which is illegal except for this thing which is still illegal, which is really clunky drafting, then we could actually say it shall be legal to prescribe. And because we got here, because we had to put the provisions in order to get anything passed. So is it okay to take out the methadone special treatment and let that simply be covered by whatever the DEA requires, or are we creating more problems for ourselves by taking it out than leaving it in?
So thank you for the question, Representative. I would reiterate my first answer, which is that, yes, it would be neater to remove an exception from an exception. That makes sense. That being said, we don't have a position. We, Dartmouth Health, don't have a position on this provision. We kept it as it was in the current statute. My objection would be the political one. And so I would just reiterate that.
Thank you.
Other questions? Representative Merchant? Hard to tell which hand from this angle.
Thank you, Mr. Chairman. And thank you for taking the question. The way I read it right now, a physician can prescribe schedules 2 through 4 as long as they're not an opiate, according to the statute. Number 2, if I may, would you, again, given the fact that there's a 34-day limit on a controlled drug today, that does limit as far as any kind of abuse potential. In 3, with methadone, I know you politically where you going, Representative or Honorable Hood, Senator.
Matthew's fine. Thank you.
Okay. Is that having been in the world of pharmacy and seeing patients travel several hours to get to a physician for methadone treatments, I know politically is probably a concern, which I understand. Would you be opposed again to following the federal regulations, which do allow for a patient who's an existing patient to have telehealth visits?
Sorry. So I heard 3 questions. I think I wanted to answer them correctly. My understanding is that we're again talking about Schedule 2 through 4 controlled substances, both opioid-based and non-opioid based.
According to this, if you go back and look at the statute, which you referenced here, 329 1D3, prescribing of non-opiate controlled classified drugs, Schedule 3 through 4 by means of telehealth shall be limited to those prescribers. So what we're trying to do really is add the opiates.
But I'm sorry.
But
So I view Roman 4A1, the prescribing of a non-opioid controlled drug classified in Schedule 2 through 4 by means of telemedicine shall be limited to prescribers as defined. Section B1, the prescribing of an opioid controlled drug classified in Schedule 2 through 4 by means of telemedicine shall be limited to prescribers. I think it's both. I'm not sure we're disagreeing here. To the point, it's inartfully done in the statute in that it lists it twice. But
I think the point I'm trying to make is that right now, physicians or any prescriber can actually prescribe 2 through 4 for non-opiate drugs. All we're trying to do is add the opiates.
I'd have to confirm. I want to have a conversation with.
I'm trying to help on the political side that we already allow for it. We're just trying to take a certain class of drugs within the substance between 2 and 4. We're just trying to include it comprehensively.
Yeah, the idea is to expand it to both opioid-based and non-opioid-based, which we may already allow, Schedule 2 through 4.
And would you be opposed, again, if I try to work on the bill to amend it to allow for methadone to be following the federal guidelines versus state guidelines?
I'm just going to repeat what I've said, and I'm not trying to be hard. I'm not endorsing nor opposing to that. And finally, no, we have to comply with we have to comply with the stricter of the federal versus state law. So I would have zero objection following DEA.
Representative Leon.
Thank you, Mr. Chairman, and thank you both for being here. I'm hoping you can help me with my confusion. Last year, it was signed in House Bill 503 was signed into law, which addressed prescribing prescriptions over telehealth, including opioids. That removed a lot of different requirements about what face-to-face interaction was required, and referred all of this to 329 1D1 and 326-B to 12A. Basically, that's saying that telehealth is telehealth, and physicians who are doing telehealth can do telehealth, and the same for APR, for advanced practice nurses. Right now, I see in the statutes around the Controlled Drug Act and prohibited acts that Section 328-B to 16B permits the prescription through telehealth of Schedule 2 through 4 drugs. And as I'm looking at this, it looks like this was already addressed last year, and I'm trying to understand why there's a problem right now for Dartmouth when, in my eyes, the statute's already reading as solving the problem.
Thank you for the question, if I may. Because the section that we're proposing be revised prohibits that. So even if it's enabled in one section, it prohibits prescribing via telehealth, Schedule 2 through 4, unless it's for SUD care.
As a follow-up, in my reading, it's a section right directly below that that permits, that there's the part that permits the substance use disorder, and then there's the other. If that one section, so if you actually go back to the Controlled Drug Act, that seems to be the one that prohibits it. If we simply remove the specific carve-out for substance use disorders, would that solve our problem in a much more elegant way by removing the language that says...
What number?
I'm trying to find... So there's nothing, I can't find anything in the Controlled Drug Act that limits the prescription of opioids in Schedule 2, opioids or non-opioids in Schedule 2 through 4, that limits it only to substance use disorder.
Can I answer
Representative Weber, do you have
generally?
insight on this, or-
Was that?
I have a point of order for the chair, or a question for the chair.
Okay.
And that is, because it sounds to me very much like all of us who have been speaking are trying to deal in the same way, are trying to achieve the same end, but we're trying to wrestle with a really mightily difficult drafting muddle based on historical drafting. Would this not be a bill that might avail itself very well to the appointment of a subcommittee specifically to draft a proper amendment? Or, failing a subcommittee, a small number of people to work with the folks from Dartmouth Health to draft cleaner language? If I'm understanding that we're all trying to provide the maximum flexibility.
Clear, yes. Representative Leon?
Thank you. My statement is, I think that this is already covered under law. I don't know if we can find out, and get some information on that, and then if it's necessary, then we can look to a subcommittee or an ad hoc. But in my reading, I think it was addressed. So I'd like to send this to the committee researcher just for advice.
Mr. Chair, if I could, it's in my wheelhouse.
Representative Merchant?
Thank you, Mr. Chair. The challenge here is that the federal law and the state law now conflict. And the federal law has become more lenient, but the state law has not caught up with the federal law. So a lot of things you're referencing, Representative Leon, is in fact true based upon the state law, but we need to fix the state law to allow for the flexibility the federal law does now allow for. And that's kind of where we're caught into it. A lot of times what happens is, at least in the world of pharmacy, we have a tendency to put into state law what's at the federal level. And my understanding is why we do that is that at the state level, we cannot enforce federal law, but we can enforce state law. Federal enforces federal law, not state law. So we have a tendency to mirror the two together, but right now they're not together.
Representative Leon?
I'll remain confused, and we can discuss this later at some point.
Okay.
Okay, any other discussion? Any other questions for these two folks? I am seeing none. Okay, thank you both.
Thank you.
The final person who has signed up to testify on this bill is Jim Monahan from New Hampshire APRN Association.
Thank you, Mr. Chairman. It's my first trip to HHS this year, so
good
happy
morning.
to be here.
Still morning, I think.
In fact, the last time I was here, I worked with Representative Leone on 503, so I'll address that a bit if that's okay. But I am here today. I have a number of clients that are impacted by this bill, and I wanted to come to the public hearing to hear a little more where it's coming from. So the pink card I turned in does check off support, but I do think we want to get it right because of the because we want to get it right, and I have at least 3 clients that are impacted by this. That would include the community mental health centers, which are involved in the prescribing of Schedule 2 through 4 for mental health conditions, as well as the advanced registered nurse practitioners. Section 2 of the bill opens up their statute. And then I also represent the opioid treatment programs, which are the methadone clinics in New Hampshire, where most of the most of the use of methadone probably takes place. So I understand there's some confusion over the language, and a lot of it is the need to align state statutes with the federal statutes. And as Representative Merchant observed, those are changing and becoming more lenient. Probably on a different piece of legislation, we should deal with that alignment. But I want to call the committee's attention right now to Section 3 of the bill, which is the effective date, and it's 60 days after passage. While I know it is challenging, I don't think it would be impossible to address this issue before May 11th, so we don't end up in a situation where thousands of people that are involved in having their drugs prescribed through telehealth would have to have a subsequent in-person follow-up. I don't think anyone wants to see that happen, but there is a misalignment of the public health emergency ending in May and these statutes. So my hope is we get it perfect in the House, so when the Senate gets it, they just say great, and we can move it along as quickly as possible. And I'm committed to working with folks from DH and the department on that. A few things that came up today that I would want to work with the committee on. The first question out of the box was the reference to out-of-state physicians. I think it just doesn't belong there. It's unnecessary. It's a drafting error. You can't find that reference in the section. Would be my observation on that. And I have had great conversations with the folks with Courtney from Dartmouth to get this right as well. And it might not be a problem, but as Representative Merchant is well aware, and others perhaps as well, that for the opioid treatment providers, they technically don't prescribe methadone, they order it. So you go to the clinic and you are evaluated by a physician or APRN, and they order methadone for you. You don't get a prescription and go to a pharmacist for it. What I don't know is, does anyone prescribe in that manner, or is it all ordered? And perhaps others would understand that better than I, but I think Representative Merchant's going to jump right in and answer that question for me.
It's changing.
I'm sorry?
Federal law that's governing a lot of this is under change.
Yes. Right. And so I think getting that how we deal with methadone exception, we want it to align with federal law, but we need to be careful in the way we use the word prescribing, so we don't mistakenly prevent the methadone clinics from doing what they do. I should say, with regard to the travel issues for that, federal law and state law does allow for take-homes, very closely protected by that work, but you don't have to, for some people, you don't have to come to the clinic every day. Short durations of take-home drugs are prescribed, but that's not done through telemedicine. That's done through an in-person, because the federal law requires that, and the New Hampshire Controlled Drug Act requires that we comply with the federal laws. So, finally, with regard to House Bill 503, again, it's confusing when you stack up the Controlled Drug Act, the Telehealth Act, and the Practice Acts. But I think the intention of 503 and the work this committee did on it was to create a carve-out exception for MAT, and so it narrowed it to substance use disorder. There is another bill in the Senate which is working its way through the process, has a hearing next week, which expands that a little further to include mental health conditions. I think House Bill 500 might be more comprehensive than that, and I wouldn't want to slow the work down on this because of what the Senate might be doing, but just wanted to make the observation, Representative Lewin, that I think we need, while the work you did last year on 503 was important and helped with regard to MAT, I do think we need to go further with this legislation than we did last year. So I am happy to work with whatever process is underway, with the stakeholders, with the committee, a subcommittee, with the researchers to try to advance it here. I didn't hear any opposition. I think most of what we want to do is get it right.
Thank you. Questions? Yes, Representative Nagel.
Thank you Mr. Chairman, thanks for taking my question. I want to understand the scope of this a little bit better because the way it was presented was a very specific scenario. But
Yep.
I'm a provider. I have a relationship with a patient for a long period of time. I can still prescribe by telemedicine one way or the other. What we're talking about is initiating therapy. Is that correct? In other words, like I've known Joe Smith for forever. I prescribed for him for 10 years. I can still, one way or the other, I can still write a script. It's initiating therapy. Are you telling me I can't write an order by telehealth for a patient I already have a relationship with that I've been prescribing for?
No, I'm not.
She's nodding her head, so that's important to me.
Which way is she nodding her head?
Up and down.
I don't read this as preventing the initiation of treatment through telehealth. Those were important changes made in House Bill 1623 and 2020. But I do know that both that bill and the current the Practice Acts require that the physician or the APR and use their professional judgment to determine when an in-person is appropriate.
Okay, and
follow up?
No.
Okay.
Okay.
Other questions? Representative Weber?
So if we were going to try and align this as closely as possible with the federal regulations and also to provide the greatest degree of flexibility, would it be an acceptable drafting technique to make reference to the federal regulations in the broadest possible way as a way of doing that? Or could we simply be silent on the federal regulations, knowing that if they are more stringent than ours, they control?
I guess I don't know the answer to that.
Okay.
And I don't mean to be flip about this, but I'm wondering, maybe we don't want to get too fancy with this bill because of the time constraints on it. And if we make a unintended mistake with regard to those alignments and May 11th comes, it's really going to impact a lot of people. So I think there's absolutely, I think, a need to look at the Controlled Drug Act and these Practice Acts, which are really the only two that allow for the prescribing of 224, and align all of that with what is apt to be a changing federal regime.
Thank you.
And I thought I was going to see Representative Merchant volunteer to sponsor that bill, but
Other questions?
Mr. Chairman, if I could make a comment,
Yes.
if I could. One of the things that you're sort of touching upon is there's two parties here. One's the prescriber and one's the dispenser.
Mhm.
And we have to be sure that we're in alignment with the dispensing community to understand what we're doing in the prescribing community. Otherwise, we'll probably have some pushback. And with May 11th coming rapidly, I think we need to be sure that the dispensing community is involved with what we're doing as well as the prescribing community.
yeah, I totally agree.
Other questions? I'm seeing no other questions, so thank you. Does anyone else wish to testify on HB 500? I have no other people signed up. Representative, do you have something?
Yeah, I just had a quick 20-second follow-up for Representative Weber's earliest question about the reference to the out-of-state physicians and the out-of-state APRNs. So I went back and read both 329 and 326, and it appears that the first line 1 reference to out-of-state physicians is actually an error because it's referring to subsection 2, which is just above, so that would need to be stricken. And then to follow up on the question about line 13, the out-of-state APRN clause, the larger subsection A to C is exactly existing law. So there is no change to B, but it's here as a placeholder showing the changes to A and to C. So there is no change to the out-of-state APRN issue. It's just here as a placeholder, essentially.
Does that answer your question? Thank you, Representative Hacken Phillips. Okay, seeing no one else to testify on HB 500, I am going to close the public hearing on HB 500 and open the public hearing on HB 325 and recognize the prime sponsor, Representative Gary Merchant. Do we get this back from the other one? When he and
I saw him fill it out.
Okay. Right. Again, we need a pink card, Representative Merchant.
Thank you, Mr. Chair. For the record, my name is Gary Merchant, representing Sullivan County District 6, which is Claremont and Croydon. I come before the committee for, I think it's a relatively simple bill, but maybe others don't agree with me. What happened was in the prescription drug advisory program, there's an advisory council, which is multidisciplinary with many different healthcare, police force, and so forth that are there, along with legislators. One of the issues we run into with a lot of boards, when someone's term comes to an end, is trying to find someone to replace them. So instead of having an abrupt end, is trying to find a way to say if they're on the advisory council, they could stay on the advisory council until they found a replacement. What was brought to my attention by Attorney Williams from the Department of Health and Human Services, the way it's written right now, they could be there until they pass away. That was never the intent. So I did make an amendment based upon his recommendation to make a change. So they can stay on the advisory council for up to 6 months after the term expires. So it's just allowing for more flexibility when you have folks that are hard to find. Specifically in this case was Dr. Crawford, Stephen Crawford, who's a state veterinarian. It's a small pool of candidates. His term is coming up. That's what caused it to go forward. And we want to find at least some time to find another veterinarian. So that's the intent of the bill.
Okay, questions for Representative Merchant? Seeing no questions. Wow, really was quick. We did get your pink card for HB 66. I don't believe we have one for this one.
I'll get one. Thank you, Mr. Chair.
Okay, thank you. Okay, no questions for this bill. Okay, gone. Thank you. All right. With that, I will close the public hearing on HB 325, and we will recess until, I don't know, is 1 o'clock realistic or 1:15 perhaps? At which time we will resume our public hearings on HB 611. We stand at recess. Good afternoon, everyone. I'd like to call the meeting back to order of the House Committee on Health and Human Services and Elderly Affairs. We have a full afternoon of hearings scheduled. And the first one is on House Bill 611. And I would like to recognize the prime sponsor, which is who is Representative Sherry Vale.
Thank you, Mr. Chair. Good afternoon, esteemed colleagues of the Health and Human Services Committee. My name is Suzanne Vale, and I'm a New Hampshire State Representative from Nashua.
Sorry to mispronounce your first name, by the way.
I knew I had to speak my name for the record.
Your handwriting
Thank you.
is comparable to mine. So
It's horrible. I should have been a doctor. That was bad, I'm sorry. I am before you today to introduce House Bill 611, which is an act that will remove the language that states that one must seek traditional treatments and therapies, and one must also have failed to respond to this treatment in order to become a patient of the therapeutic cannabis program in the state of New Hampshire. I'm testifying as both a lawmaker and as a patient at Prime ATC in Merrimack, New Hampshire. I did not seek care there until my health was in a shambles. And in 2017, I walked through this door of the dispensary for the first time. I had no idea that I had qualified before that time. The statements to me seemed vague in the language in the law, and I just didn't think that I fit. I'm not a fan of spinal surgery. I'm not a fan of some of the treatments that I should have to consider and fail at. And I would never take a chance on unless I were completely unable and incapacitated in terms of trying to live my life. I had gotten very far afield with traditional medicines. Prescription labels from the dispensary include every ingredient that is in the product. While pharmaceutical manufacturers don't have to use the same compounds to stabilize medication and deliver it to you in a form that you can swallow and ingest, we have to take a difference and, look at this versus the medication that we can get through the therapeutic cannabis program. Stabilizers, suspensions, and all those things that carry your drug into the body when you swallow or when you have a topical or other route of administration is all listed. Everything in the ingredients is there. The inert substances that they say in traditional medications and pharmaceuticals you should not be concerned about, particularly in generic medications, are not in the cannabis medications that people seek. At the dispensary, like at a pharmacy, only better, in my opinion, inconsistencies in the medication are right on the label. Everything that is in the medication is right there. These capsules are manufactured, they're sourced, they're 100% within the dispensaries. They start with a grow house that has no pesticides in use. There are also no herbicides in use, no fertilizers, and there are known bacteria and viruses that the plants that can succumb to that could wipe out an entire crop. And it is a very sterile environment that these, I wouldn't go as far as to say clinically sterile, but what I would liken to a sterile environment in terms of the process of growing and synthesis of the products that they make. The very controlled process and the ability to synthesize the flower they grow into a product that is labeled with the exact ingredients empowers the patient to have a sense of direction as they try to establish their medication routine. It gives them a list of ingredients, it gives them a list of terpenes, cannabinoids, and it tells you the percentages, the amounts, and it tells you exactly what the capsule is made of. No matter what the item is, all of the ingredients are listed. There are fast-acting products, and there are products that help you sleep through the night. There are capsules, topicals, tinctures, suppositories, and many, many forms of medication delivery. Liquid concentrated for your own at home. that you can buy a thing of oil that you can bake your own goodies with if you want. And I call them goodies just because they're good when you take your medicine. And instead of trying to take medicine when you're feeling very sick or tired, when you don't have enough saliva, you want something sweet, you want something that is going to be easy to process. I will be sending you an email that has a picture of the medication labels and also excuse me, the link to the dispensary so that you can see the products that they carry. The folks at the dispensaries are trained to help you find the correct product for the symptoms you're experiencing. The feedback that you give to them extends all the way back to the grow house where they try to grow what you need. They ask you questions and they try to find out exactly what symptoms you find certain strains helpful with so that the next person who comes in doesn't have to do that. As the strains are less available, they are not always something that can be brought to harvest. People need to know what those ingredients are in order to seek the kind of relief that they need for the specific problem that we're treating. Right now, we're treating a discrete list of illnesses that we have come before this body to ask for permission to treat again and again since the program was offered up to New Hampshire residents in 2013. You will hear more about all of this in subsequent testimony. So where the law states that one must try traditional medicines and procedures has failed, one has to ask, what is that failure? Is that failure that you had too many side effects, and which side effects are considered to be prohibitive and interfering with your function? If you wake up in the morning after taking opiates the night before, you might notice that your eyes are swollen and you have difficulty opening them without having a compress. Some people have reactions to things where they cannot digest the food that they need to have and where they need to put on weight because they've been in treatment for a long time, and that many of these treatments suppress the appetite and make someone look very thin and have difficulty with managing themselves. When we talk about the medications that you can get at the dispensary and all of the forms that they come in, you realize that people get the opportunity to buy something that is concentrated but only take a tiny bit of it at a time. So I will use an example of a 50 milligram THC that is in an iced tea mix. If you would like iced tea or something to sip and you want to make sure that you can tell the difference between 1 milligram and 50 milligrams, this would be a good way to try. So a tincture would do the same thing where you have a little tiny dropper bottle and there's 1 or 2 drops and that may be all you need. Personally, I have found that the CBD concentrations that are strictly CBD are very helpful. And at times I wish that they were in a lower dose so I don't take them. But what would I do about that? I would turn around and say, you know something? Some of us might benefit from a 2.5 milligram dose. I haven't told them yet, so they're hearing now. The people who are here.
Representative, if I could ask, it appears that the bill has a very limited scope. It's deleting like a couple of lines. Could you address that aspect of it for us?
Yes, I certainly can. The rest of my testimony is just an impact statement. And although I think that's very important, so is this. So when we go through the bill line by line, as you see on line 5, we're coming to where I'm striking the qualification on severe pain that says that has not responded to previously prescribed medication or surgical measures or for which other treatment options produce serious side effects. We are not striking constant or severe nausea, moderate to severe vomiting, seizures, and other reactions that one could have.
Thank you. Relating to this aspect of the bill, does anyone have any questions? Yes, Representative Nadarapam.
Thank you, and thank you for taking my question, Representative Vale. So you're not changing a qualifying condition. You're just removing an obstacle for a doctor would have already okayed somebody as having some kind of chronic pain and that they would be eligible to go to a therapeutic cannabis dispensary and get something for pain. So this bill seems kind of simple. You're just removing that line about has not responded to previous medication or surgical measures. And I wondered how that would have been measured anyway.
The answer to that question is yes, Representative Upper Nuttam. And the reason that that we really look at this is because, you know, there's untold costs to trying these medications that cannot be accommodated in the law and may not be something that you talk about with your prescriber. So when we're looking at this, what's preventing, and the obstacle is a good word to use because we're talking about severe pain. We're not talking about severe pain that the state approves of or doesn't approve of. We're talking about asking your provider to be able to say, well, this is severe pain, I'm going to send you there. It may be or may not be chronic pain. But in the case of severe pain that has not responded, this will make a big difference for people. It certainly would have made a big difference for me. And in fact, I would have been sooner engaged in the program and probably would have resolved some of my issues a lot sooner.
Thank you.
Representative Leon.
Thank you, Mr. Chairman, and thank you, Representative, for bringing this bill to us. Just looking at these and talking about your history, were you under the impression that you might need to have
Question?
I just wanted to, if I could reframe, all we're doing here is removing barriers that might be unnecessary and which don't need to be enumerated, because if we are comfortable now, because we have more experience than we did when we drafted this, that physicians, we trust physicians to say, you could do A, B, C, or D, or you could try this, and you could try this before you had to do A, B, and C, and D and have them fail.
Yes.
Thank you.
Other questions? I am seeing none. Oh, Representative Cushman.
Thank you, Mr. Chairman. Thank you for taking my question. I'm just looking at the statute that you handed out to us, the entire 126X. And on the second page, under Roman 9, then underneath 2, where it says, there's a B, it says qualifying medical condition also means, so this is under the paragraph that you're amending with your bill, but the next thing says moderate to severe chronic pain. And then there's a redundancy. It says that same line, severe pain not responded to. Should we? Okay. Okay. So what if we just struck out chronic from that part too?
That is a ICD diagnosis. And therefore, and I forget, I'm sorry, which version we're on at this point because I'm not working in a clinical setting any longer. But chronic pain it's a diagnosis for any kind of pain that continues on. And pain syndromes are really a different animal than the kind of thing that someone goes through with severe pain. And the reason for that is because there's a feedback loop when you use some of these treatments, and it's a spiral where you can't tell what's going on, and side effects are keeping you from finding out. As we know, some of these medications are extremely intoxicating, and we don't want people to take something that's extremely intoxicating that has things that they don't know about in it.
Other questions? Yes, Representative Nagel.
Thank you, Mr. Chairman. Thanks for taking my question. I'm struggling with this a little bit, not a lot of it, just a little bit, and maybe you can help me. I personally, when we look at an algorithmic way of thinking about things when we treat people, I don't personally think of cannabis as a benign drug. I think it has the potential to cause problems in some people that we need to respect. I would never personally use it as the first line treatment for any of these things, with a couple exceptions. With that said, and I'm curious how you would answer that. Like, there's a lot of benign things that we do that don't really cause a lot of bad problems, and I'm lost about. I really need to have a better reason why we need to get rid of this restriction.
I can give you a better reason as I conclude my testimony.
All right.
And if it's not a better reason, I'm sorry, but this to me is a better reason. But I do want to also say that cannabis is in no way benign.
Thank you.
And in no way do I underestimate what the black market can do with the medications that we're talking about. We know this with opiates, and we know this with almost all of the street drugs that we have now that come from the formation of other drugs that we had in the last century that we were distributing and that we were freely flowing and we were being actually wooed into taking. Excuse me, Mr. Chair, may I continue?
Sure, go ahead.
Just take a moment. Before I go, I don't want to say anything. I don't want to ever miss an opportunity to tell the members of this committee how much stigma presents in the relationship between a person and their doctor, a person in their pharmacy, and how dangerous that is. Years back, I had been prescribed a long-acting opiate as a short-acting opiate at the same time. When I went to the pharmacy to pick up the medication, it was for a pre-surgical issue, and the pharmacy staff gave me a strange look. The pharmacist came over and he said, "Are you going to take all this medication at once?" I said, "No." I got home, I opened up the bag. I had an order for 5 milligram Percocet pills, but I left that pharmacy with something that had buprenorphine in it and something that was 20 milligrams. And this was at a CVS, 20 milligram Percocet tablets, which I didn't know existed. Not Percocet, I mean oxycodone. I'm sorry, might need to clarify some of these things. I'm extremely anxious. I have a crisis going on at home, and I'm struggling with that right now. So I have to just put that on the record. This critical error of dispensing that kind of medication, that's a terrible mistake. And of course I pursued it, but there is no accountability. I've sat in my orthopedic surgeon's office and had him look at my med list and say, "What do you do, take pills all day?" Yes, that was the last time I ever saw that doctor, but I wondered how many times he said that to other people like me. He did not say to me that he thought I had a problem or that he wondered if I had a problem or any of those things. And when I look at that medication list, it's astounding to me that I ever took those medications and stood up and walked around, let alone functioned as a state representative. And as I sit here before you, I feel like I have to prove to you that I'm not a stoner and I'm not an opiate addict, but I'm trying to treat my illnesses and I'm trying to take care of myself and the others that are behind me. And I know we have a small room and we have a small audience today, but there are 14,000 patients in the therapeutic cannabis program. So we are here to say, please, let's look at these statutes. We're going to be looking at them over the afternoon. So what I've given you is the area of law that we're going to be talking about. And we're also going to be all asking you if you would be interested in sponsoring some kind of an educational event so that we can teach the rest of the legislatures what we're talking about.
Other questions? Yes, Representative Merchant.
Thank you, Mr. Chair. And I'll make this brief. Back to Representative Weber's, if I understand this, what you're trying to accomplish through this bill is what you can do illegally, if you will, by going to the street to get cannabis. Which could be a funky source of the product, to turn it into a legal way to get it from a legal source that's controlled and has better safety for the patient. So you can still get cannabis. All this is doing, allowing the patient to go to some place that has some sort of assurance about the quality of the product and safety of it.
I find that the 100%, I find that I know every ingredient that's going into my mouth. that it's, versus a generic drug, which now I worked in psychiatry with doctors for a long period of time, and I won't mention agencies or names or anything like that. But when you look at the medications and you wonder what the standard deviation is for the medication across the board, so for instance, if I had a Latuda, then that pill has a standard deviation of being the same as another drug of 97 point, so I think 5% or 2.5%, I forget how that goes. But 97.5% of those pills are exactly the same, or 102.5% of those pills. So somewhere along that 5-point deviation, you're getting something pure. For generic medications, it's 85%. 85% consistency across the medications. A pharmaceutical manufacturer can change the compounds that they use, that they add, the stabilizers, the things that keep that drug in the form that they put it there and keep it measurable to deliver it to your body. So would you want to take something that's 85% what you are looking for in a drug that has 100 other compounds in it that you don't know what they are and where they came from? Or would you rather take something that was sourced from a dispensary up the street that actually relies on its own grow house and never accept products from outside of their supervision directly?
Yes, Representative Kofalt.
Just looking at the bill and hearing your testimony, I guess it looks to me as if this is really a simple matter of affording physicians the freedom to exercise their practice with their best professional judgment. So I think it's probably a short yes or no answer. Would you agree with that statement that this is really about physicians being free to exercise their professional judgment?
That's a really tough one to answer for me, because when I tried to get organized for today, we have a doctor here who's from the Therapeutic Cannabis Medical Oversight Board, and he can speak to what it's like for being what this would be for him. Okay, so I don't know what this is sending doctors. I don't know the message it's sending them, but it's sending the patients the message that they don't have to try all these other radical methods. And honestly, opiates are radical. That's a radical decision to take. And you never think that you're going to be taking it for the rest of your life when you take that first one. And then that's where you could be heading.
Thank you.
Other questions? See no other questions? Okay, thank you.
Thank you. I'm sorry for all my stammering, and
No,
hopefully I
not
got
at
my
all.
point across.
Also signed up to speak today is Representative Wendy Thomas. Representative, if you could hold it to 3 minutes, that'd be great.
Thank you, Mr. Chair and members of the committee. I'm Representative Wendy Thomas, and I represent the town of Merrimack. I'm also a therapeutic patient and have worked with patients in a dispensary. I'm going to focus on the opioid part of this. Oh, I'm sorry. I'm going to focus on the opioid part of this problem that this bill, the bill that stands before this one, offers. When I recently had some major surgery, I was sent home with a total of 7 opioid pills with the instructions to take 2 every 4 hours. That was pain relief for 12 and a half hours. That's following major surgery. When I developed a painful complication, I was told that, quote, "we do not prescribe narcotics after surgery," end of quote. When I had a second major operation, this time in order to be sent home with pain medication, I had to fill out a psychological profile and I had to sign a 3-page agreement that said, among other things, that I could get addicted and that I could not sell the pills on the street. This time I was sent home with 5 pills with the instruction to take 1 every 4 hours. That was 20 hours of pain relief, again, following major surgery. The issue of under-medicating patients in severe pain is a discussion for another day. Opioids in even small doses have a big impact on the body. Symptoms of opioid use include drowsiness, constipation, euphoria, nausea, vomiting, and slowed breathing. A person using opioids over time can develop tolerance, physical dependence, and opioid use disorder with the risk of overdose and death. This is nothing new. We, especially as legislators, are well aware of the opioid epidemic in New Hampshire. In the case of severe pain, often it is chronic or lifelong. Opioid medication is not going to fix it. It is only going to mask it for a while. The danger of not passing this bill is that some patients will be asked to use opioids to prove that it doesn't work. Following current trends, it is very likely that those patients will be undermedicated with opioid medication for their pain. That's when we get into trouble. Many of these undermedicated patients turn to alcohol or even street drugs in an effort to manage their pain. Cannabis provides a safe alternative to pain medication, to pain management, and it does not have the side effects or addictive qualities of opioids. If the largest health provider in New Hampshire is so concerned about addiction and abuse with opioids that they send their patients home with very few opioid pills and make us sign contracts of use, the idea of tying opioids for severe chronic pain before trying cannabis is illogical and does not fit with the current prescription and usage of opioids. I urge you to pass House Bill 611 so that our severe pain patients can, if they choose, opt for a safer method of pain management without having to go through the use of addictive opioids to get there. Sorry. Thank you. I'll take any questions.
Thank you. Questions? Anyone have any questions? I'm seeing none. Okay, thank you very much.
Thank you.
Also signed up to speak is Representative Heath Howard. And again, if you could hold the 3 minutes, please.
Yes, of course. Hello, everyone. Thank you for having me today. My name is Heath Howard. I'm a representative for Stratford District 4. And I'm speaking to you today about HB 611 because I support this bill. I'm currently a member of the Therapeutic Cannabis Program, as I have just recently enrolled in that program. I broke my back first when I was 16 years old in 2016. I had an L4 burst fracture, I had a spinal fusion, and I was prescribed several opiates. I remember being in the hospital when I was on medicinal grade fentanyl, and the nurses would either have to remind me how to breathe or I'd be screaming in pain. This bill doesn't necessarily focus on the opiate side of things, but it allows for alternatives. I spent years dealing with my pain, and previously prescribed medications had not worked. I'd gone through several, and I had gone through surgical measures such as a spinal injection. Those treatments didn't work for me, but medicinal cannabis has. It's something where I think that this could definitely provide a lot of support and assistance for people who need it. Thank you. I'll take any questions.
Okay, thank you. Questions? I'm seeing no questions. Okay, thank you very much. Also signed up to speak is former Representative Jerry Knirk.
Thank you, Mr. Chair. For the record again, Jerry Knirk, former state rep and chair of the Therapeutic Cannabis Medical Oversight Board, which is charged with the medical oversight of the Therapeutic Cannabis Program. Again, just to review, 10 medical providers from different fields, a patient representative, the medical director of the DHHS, and a representative from an alternative treatment center. As I said earlier, about 70% of our patients are certified for treating pain, allowing them to lessen or avoid the use of opioids. And about 82% of therapeutic cannabis patients in New Hampshire report that they have been able to decrease their prescription medications. A couple of things to clarify, because there's been a little bit of confusion about how you get in this program. To enroll, you have to be certified by your medical provider as having a qualifying medical condition established in law. You don't prescribe cannabis, you can't do it because it's a Schedule I drug, but you certify you have a qualifying condition. Representative Weber hit the nail on the head. HB 611 seeks to remove an unnecessary and potentially harmful step in a patient becoming qualified to use therapeutic cannabis for pain. It's almost like I sent you my testimony. Currently, a patient can qualify for severe pain only after having failed to respond to previously prescribed medication or surgical measures, or whether treatment options give unnecessary or serious side effects. But this barrier is not needed. In December 2022 meeting, TCMOB voted unanimously to support HB 611 as it is written to remove this unneeded barrier. Now, the statutes are a little confusing, and there were some questions about this as to how you qualify. Part of that is because of the structure, and part of it is because of having added in other standalones over time. You have to have both a qualifying condition and a qualifying symptom. That's the RSA 126X19A1 and 2. But there are also a number of standalone conditions that we've put in over the years, one of which, again, is severe pain. Well, one of the qualifying symptoms is listed as, quote, severe pain that has not responded to previously prescribed medication or surgical measures, or for which other treatment options produce serious side effects, end quote. This exact language is then in the second standalone condition as well. That is why you see in this bill that there are two sets of strike-throughs. One strikes the qualifying symptom for the 126X9 Roman 9A1 and 2, and the other one strikes the standalone condition restriction. Now, remember that when the therapeutic cannabis program was established in 2013, our evidence regarding efficacy of therapeutic cannabis was still evolving. The statute was written to make therapeutic cannabis an option of last resort in treating pain. We now know that that's no longer appropriate. Some of the strongest evidence we have for the efficacy of therapeutic cannabis is for the treatment of pain. And the landmark National Academies of Science study in 2016 concluded again that there's substantial evidence that cannabis is an effective treatment for chronic pain in adults. So given that cannabis has proven to be effective in treating pain, it is not reasonable at this point in time to continue to insist that a patient has to fail other options which may have poor evidence of efficacy or which carry risks which actually exceed the risks of therapeutic cannabis. As I said before, I was a spine surgeon. And though there are some spinal problems that respond well to surgery, most of the time, if you got a problem with your back, you should run the other way from a guy with a knife. Because many of our surgical procedures are really not helpful. They're not likely to make people better. So why would you force a patient to have that procedure before you could say, sure, you can have cannabis? Or why force a patient to do a trial of opioids for their back pain before trying therapeutic cannabis? We know that opioids are not effective for long-term management of pain and have far more risk of addiction and impairment than cannabis does. There's no reason to expose the patient to that risk of addiction and impairment from an opioid if it can be avoided. And this, by the way, doesn't have a whole lot to do with acute postoperative pain, because first of all, it takes some time to be certified, go through the patient, through the program. So it's really basically not an acute pain issue.
If you
This
could
is for
stop
somebody,
wrapping up,
yes, I got one more sentence.
Sure.
For somebody
Okay,
who has severe pain, it's not for post-op pain. So I urge you to pass 611 to remove an unneeded barrier to a proven treatment for pain, which is just an historical barrier that doesn't need to be there. Thank you, and I'll take questions.
Thank you very much. Representative Weber.
Continuing on the drafting theme and following up on a question asked by Representative Leon, 2B, qualifying medical condition also means 1, moderate to severe chronic pain, and then 2, the piece that we're modifying, the severe pain that has not responded to prescriptions. But as long as we are putting severe pain that is not necessarily chronic on exactly the same footing as chronic pain, would it make sense to delete number 2 entirely and remove the word chronic from number 1, so it just said moderate to severe pain, and then we don't have to discuss whether it's chronic or acute or other things?
If you look at my notes from our TCMOB meetings, we discussed these various structures and ways to do it, and that did come up as one of our options of just trying to collapse it. We thought that would be a little bit of a bigger lift because the one was really speaking about chronic pain and the other speaking about severe, which could be subacute or pain that is of somewhat shorter duration. And we decided that it made sense just to simply remove the barrier rather than try to collapse the categories and get rid of it. But I think that could be done. That was one that we entertained.
Could I have one follow-up?
Follow-up.
If we did that, would you see more pushback to this statute? Because my goal would be to get something passed. But as we've been dealing all day today with removing the barriers and inch by inch statutes that we put in order to get something passed at all, what I'm trying to find out is, are we at the stage where we could just consolidate? And I think what I'm hearing you say is, no, we're not there yet.
Well, actually, personally, I did like the idea of just consolidating it. But I am here speaking for the board, and the board voted to support this particular language. But I was very comfortable with just collapsing those categories and still keeping it in the Roman 9A2, because that one is a separate thing, just deleting it. But in the standalones, to combine 1 and 2, and then, of course, renumber the 3, 4, and 5, and 6. And I think one could just say moderate to severe pain, period. I would favor that, but that is not what the board voted on. And since I'm speaking for them, I need to report what the board voted on.
Thank you for making the clarification,
Sure.
and thank you for giving us your opinion.
Yes.
Thank you.
Representative Nagel.
Thank you, Mr. Chairman. Thank you, Representative Knirk. Just so you know, you're preaching to the choir here. I didn't want to imply otherwise with my previous question. What's unfortunate, what we're seeing right now, is not what I see when I certify a patient. When you see the form as presented to us, it makes so much more sense, and I actually like the way it is, and I would not like to see it changed personally. I really hated it when I first saw it, but now I really like it.
Yeah. May I? Okay.
Please, I want
think
your opinion and your
yes,
thoughts.
I think in a way it kind of devolves back to what Representative Kofalt said a moment ago. It just leaves it that it gives the provider the opportunity to say, I think this patient's a reasonable person to consider cannabis, and they don't necessarily have to do a trial of something else. Although, for an awful lot of pain, most any provider is going to try someone perhaps on naproxen or something before they're going to send them off for therapeutic cannabis. And I think almost all providers would. This just removes a barrier for the provider, as Representative Kofalt pointed out.
Thank you. Anyone else? Any other questions? Seeing none? Thank you.
Thank you.
Also signed up to speak is Michael Holt from the Department of Health and Human Services. And again, sir, if you could hold it to 3 minutes, please.
Thank you, Mr. Chair, members of the committee. I'll keep it to 1 minute. I have 2 points to make. One is that this bill is as straightforward as it appears. It removes a barrier to providers for certifying their patients for the cannabis program. And I would just like to confirm, as the administrator of the therapeutic cannabis program for the past, 5-6 years. This is a conversation that we have on a regular basis with medical providers when they have questions about certification. And they will ask us specifically, according to this standard, do we have to have surgery or a course of opioids first? And technically, the answer is yes. And that does act as a barrier for some patients' certification. I'm happy to answer questions about the program as well, but I just want to make the point that this can be operationalized by the state, and we have no objections to this change.
Okay, thank you. Questions? Seeing no questions?
Thank you.
Thank you. Also signed up to speak is David Landry. Again, 3 minutes, sir.
Thank you, Mr. Chairman. Thank you, ladies and gentlemen of the board. My name is David Landry. I'm from Hillsborough, New Hampshire. I currently
A little
am
closer to the microphone.
Oh, I'm sorry.
There you go. Thank you.
Thank you.
My name is David Landry. I'm from Hillsborough, New Hampshire. I currently am employed for Prime Alternative Treatment Center in Chichester, and Prime does support this bill. However, I am here today to represent myself as a patient of the therapeutic cannabis program. I support Bill HB 611 because I believe that everyone should have options on how to treat their symptoms and conditions. I became a patient over 6 years ago. When I first went into the dispensary, I was looking for something to treat my severe pain. Little did I know that cannabis would ensure that I would reach my end goal of detoxing from opiates. And that was a huge factor in my life and how great my life is now. Had I had the option of cannabis or opiates, my life over opiates would have been, my life would have been very different. Everyone should have the ability to decide whether or not they want to use pharmaceuticals or alternative treatment methods. No one should tell you that one treatment method has to fail before you can try another. And I believe that removing the language from the bill would help providers have an easier time certifying patients. And I think that right now we're having a really hard time with providers in fear of losing their license or things like that, any repercussions from this. So this program has changed my life immensely, and I'm really grateful for that. So I appreciate you all listening to me today. Thank you.
Thank you.
I'll take any questions.
Could we get a copy of that testimony?
Yes.
Any questions for this gentleman? Yes, Representative
Thank you,
Nagel.
Mr. Chairman. Thanks for taking my question. I'm not totally sure how to ask this of you because it just came to my mind. So if you come in to see me with a pain problem, I write a script, you go to the pharmacy, it's right there. One of the barriers that I see, and I'm curious how this may have affected you, is I decide I want to certify you. I write a form that goes to HH or whomever, the Cannabis Commission, they have to decide, blah, blah, blah. I mean, it used to take months to get here back. You know, so now you've dealt with pain for several months, and we're talking about an acute issue here. What was your time frame before you got certified?
Okay, so in my for me, I had to have a 3 to 6 month patient doctor-patient relationship,
Right.
which is now no longer in existence, which I believe is great for this program. So I had to have a 3-month doctor-patient relationship. At the time, I had severe pain. I was also 15 years plus of severe opiate addiction. The doctor knew that I was trying to get away from opiates, and the doctor told me after 3 months of being her patient that we could then discuss entering this program, which is what we ended up going with. But it was a long time. I did have an extremely hard time coping with my pain. But I did, like I said, I had an addiction. I was using the black market. I was gaming the system, and finally ended up in a methadone program. And after so many years of feeling ill from the amount of opiates I was taking and almost overdosing and dying several times, I decided it was time to really come clean with my provider and really tell her exactly what was going on with me and wanting the help. Now, I had gone to emergency rooms before this, and I was told that it's not going to kill you, go away. And unfortunately, the space that I was in, I had a strong family that was supporting me, and I really wanted to kill myself at the time. So it would have killed me had I not had the support system I have. So I'm really grateful for this program, though, and you know, I think that if a provider has an easier method of you know, not prescribing this, but you know, making this a recommendation, then I think it would be great.
Thank you. Other questions? Seeing no other questions? Okay, thank you.
Thank you.
Also signed up to speak today is Heather Marie Brown. Three minutes, ma'am.
Good afternoon. Thank you all for being here and willing to listen to this testimony. My name is Heather Marie Brown. I am the patient representative on the Therapeutic Cannabis Medical Oversight Board. So basically, I am the one person that represents the approximately 14,000 patients we have in the state and all of the future potential patients that we may welcome into the program in the future. I am 1,000% in support of this bill. I personally think that this bill is long overdue. I think that we could use some changes and some loosening of requirements and restrictions. But in particular, taking these barriers away is going to make a huge difference, not only in how a provider can deal with their patient, but also the type of relationship that the patient can have with their provider. Because as of right now, it is still very difficult to sit down with a provider and have these conversations. We have very few providers in the state that are even willing to certify, and some of that is due to lack of education or lack of knowledge or lack of understanding as far as what the qualifications are and the wording behind it. This takes away that barrier. And honestly, I do not believe that we should be forcing anybody to go through such extreme measures for their health when they should be responsible for making those choices on how they deal with their health care. I myself had been dealing with issues due to back injuries and other injuries throughout my throughout my youth. I had a very rough youth. Going through medical professionals led me, unfortunately, to develop an addiction, which then in turn ruined my ability to be a contributing member of society and almost destroyed my ability to be a successful mother. Therapeutic cannabis, I fought very, very hard for chronic pain, severe moderate pain, and PTSD to be added to the list of qualifications. And I was grateful to see it happen. I was extremely worried about getting a therapeutic cannabis card for chronic pain has a condition on its own because the medical professionals I was working with at the time wanted to force me into surgery that could have potentially caused me not to be able to walk. They wanted to put me on medications that I knew would trigger my addiction. This year, I am celebrating 23 years of sobriety. So I believe that this is a no-brainer, and I welcome any questions that the committee may have for me, and thank you for the opportunity to speak to you.
Thank you. Questions? Seeing no questions? Okay, thank you very much. And the final person signed up to speak this afternoon is Dr. Joe Hannon. Again, 3 minutes, sir.
Thank you. Start the clock. My name is Joe Hannon, former state rep. I'm a retired foot and ankle surgeon, and I was a member of the New Hampshire Study Commission for Legalization and Taxation of Cannabis back a few years ago. I'd just like to start off by saying, you know, it's actually cruel for the law to require serious side effects, needless suffering, or surgery before non-surgical options for patients. And the provider's freedoms are limited. So they don't have the freedom to recommend or certify patients as they see fit. I have over 31 years in recovery myself, and over that time I've had several serious injuries, 2 motorcycle accidents, several procedures where I was almost forced to take pain medication, and all but one time, and that whole time I took 1 Percocet, and all those broken bones and surgeries, I said no because I was afraid of having to take stronger pain medication. I muscled through it. Don't recommend it. It was pretty stupid. But back then, the option for other non-opiate options weren't as available beyond just NSAIDs. I have many friends in the recovery community that I've worked with and spoken with, and several have gone through, cancer, serious chronic pain, and they've all told me they've had difficulty getting cannabis legally in New Hampshire for any kind of regular, moderate pains, especially, and even severe pain. And they didn't want to use opiates because of their substance use disorder histories. It's actually extremely scary. The one time I did take that little Valium and a Percocet for a surgery, I was a mess. I only took it for one time, spent the whole day in bed, and I was emotionally a wreck for weeks, maybe a few months afterwards. And that was 18 years ago. I don't want to have to go through that again. I don't want anyone to have to go through that. Like I said, cannabis can be preferred over opiates, especially for people that have a history of opiate use. You can't really cut Percocets and some other opiates into smaller doses if you think that's required. It's much easier to microdose or cut a edible or something, drops or any kind of cannabis into a smaller dose where you may not even have any psychoactive effects. You may just have just enough to take the edge off. And that's very important. You shouldn't be cutting up, anyone's listening, you shouldn't be cutting up Percocets or any other opiates. And back when I was prescribing, I would often give people a Percocet prescription after a foot and ankle surgery or a serious injury. And, that back then things have changed. We give like 30 and here you go. That's what you're getting. I know we give less now, but even when you give less, if they only take one or two, those extra pills are going to sit in someone's medicine cabinet. And that is more dangerous. It's a more lethal option to leave around for other family, friends, and children than it is for cannabis. So I beg you to please make this necessary change. And I'd be happy to take any questions or just go back and sit so we can keep going.
Okay, thank you. Questions?
Thanks.
Seeing any questions? So, thank you. I have no one else signed up to testify. Is there anyone here who does want to testify on HB 611 FN? Seeing none, I am going to close the public hearing on HB 611 FN and open the public hearing on House Bill 610 FN, and once again recognize Representative Vale, the prime sponsor.
Thank you, Mr. Chairman, and the honorable members of the committee for the second bill. This is going to be very, very brief. I really appreciate this opportunity to present House Bill, excuse me, again, for the record. My name is Suzanne Vale, and I'm a state representative from Nashua. Thank you for this opportunity to present House Bill 610, which expands the definition of provider in the state law in the section of Title X Public Health, Chapter 126, Section 126-X1.1, X:1. I filed this bill at the request of the Honorable Jerry Knirk, Chairman of the Therapeutic Cannabis Medical Oversight Board, and so I'm going to defer to him to go through the bill with you and to explain what's going on and what his thoughts were when he planned to file this. I just also wanted to mention that I think this is a powerful bill, and I think it's really important as I get back to the stigma of being a therapeutic cannabis patient and being a person who has a chronic illness of any kind. And that's that you want to see your own doctor. You want to see your own doctor, and you want to look at these labels and these terpenes and these cannabinoids and all of these elements to see how they can help. And you would be able to work together with your doctor, your own doctor, without looking for someone who is certified to certify that you are qualified for this program. And with that, I'll conclude my testimony. Thank you.
Any questions for Representative Vale? Seeing none, thank you.
Thank you, Mr. Chair.
Also signed up to speak is Representative Wendy Thomas. Sorry.
Greetings again, Mr. Chair and members of the committee. I am Representative Wendy Thomas, representing the town of Merrimack, and I'm here in support of House Bill 610, which is an act expanding the definition of providers who can certify patients of the therapeutic cannabis program. This is yet another bill that removes obstacles to the cannabis program. If we can agree that patients with severe pain should not be required to go through a trial of opioid use prior to being qualified for the therapeutic cannabis program, and if we can agree that we have an opioid epidemic in New Hampshire that must be addressed, then we should also be able to agree that any physician who can prescribe medications to humans should be able to qualify someone for the non-narcotic therapeutic cannabis program. Some patients have a difficult time finding a provider who is willing to qualify a patient for the therapeutic program, and some patients prefer to use alternative therapies. This bill would allow the patient to pursue alternative therapies and still be qualified for the program. This would allow, say, a naturopath who has a very good understanding of how to treat humans to be able to qualify the patient for the program. As long as the state of New Hampshire trusts a physician to prescribe medications, then they should trust that physician to be able to qualify someone for a legal, medical, and therapeutic cannabis program. With regard to Section 2 of the bill, many pediatricians are reluctant to prescribe cannabis. Some children, like my own kids, transitioned from a pediatrician to a family provider while still young. We felt that our family doctor had a better holistic view of their entire bodies. This bill would not require the parents who use a family provider to then find a separate pediatrician simply to fulfill a program requirement. It allows more flexibility for parents and their children. I would urge everyone on the committee to support this bill that brings relief to many of our most vulnerable patients and vote it OTP out of committee. Thank you.
Thank you. Questions for Representative Thomas? See none. Thank you. And also signed up to speak is former Representative Jerry Knirk.
Thank you. And again, for the record, Jerry Knirk, Chair of the Therapeutic Cannabis Medical Oversight Board. By the way, in the testimony coming around, you're going to notice a few things that I corrected. I found some typos while I was sitting there, so I corrected each of the 22 copies. Anyway, bottom line is that HB 610 was filed at the request, not really just of me, but of the Therapeutic Cannabis Medical Oversight Board, which voted unanimously at its December 2022 meeting to support the bill that is currently written. The board wishes to expand the types of providers who can certify a patient to use therapeutic cannabis. Just a quick review again. To enroll in therapeutic cannabis program, patients must be certified by their medical provider as having a qualifying medical condition. RSA 126X1 Roman numeral 7. I had 8 in it. It's 7. I'm sorry about that. That defines which providers are able to certify patients to qualify for therapeutic cannabis. And the list has grown over the years, most recently with the addition of physician assistants to that list. TCMOB wishes to expand the list of providers to reflect the practice environment in New Hampshire, especially in rural areas where many people have a provider other than a physician or even a primary, even a PRN or a PA as their primary care provider, and to include other patients or other providers, who may be treating a patient. For example, they may be treating with a naturopath, and there's no reason they would have to go off to somebody else to get certified. Now, if we look at it, lines 1 to 5, that's the section that expands the list to include other providers who might consider certifying a patient. When the board first discussed this, we made a list of providers to consider for expansion, including naturopaths, dentists, podiatrists, and so on. But we always know the evil of lists. It's that issue of who's been excluded and who's been included. And we ultimately thought it would be a lot easier and straightforward just to allow any provider who's licensed to prescribe drugs to humans and who possess an active registration from the U.S. DEA to prescribe controlled substances to be allowed to certify a patient to be a qualifying patient. We didn't make up that language. That language mirrors the language that's used already in statute for each of the other provider groups that are currently allowed to certify patients. They all have that same phraseology of license to prescribe to humans and possess an active DEA license. The second part of the bill lines 6 to 10, is also a revision to reflect the reality of medical practice in New Hampshire. Because of the unique risks of therapeutic cannabis in children, and that's particularly true in adolescence, when the brain is developing, THC can have very distinct problems. So you have to really weigh the risks and benefits. Because of those unique risks, guardrails currently exist in statute that a child being considered for certification needs to be certified by 2 providers. Current statutory language mandates that one of the providers must be a pediatrician. But, there's not a whole lot of pediatricians up in the north area where I'm from, for example. Many areas there may not be any pediatrician. A child may have as their PCP a family practice provider who provides pediatric care. So TCMAB felt it would be best for the child to have that second certification, for example, by their PCP, even if they're a family practice provider who provides pediatric care, rather than having to travel to see a pediatrician who's not their provider to be certified. I also need to point out that we only have 11 patients under age 18 certified. So there's not a whole lot of patients anyway that would be affected by this, but it would just make it easier for those few who do need it. But again, we have strong guardrails about kids in that. So please honor the request of TCMOB and pass HB 610 in order to facilitate the certification of our qualifying patients. And I'd be glad to take any questions about that statutory structure or anything.
Okay. Questions? Yes, Representative Nagel.
Thank you, Mr. Chairman. Thanks for taking my question. Maybe explain for me better. I'm trying to see who's not included. And you mentioned naturopaths specifically, but I didn't think that they were licensed to be able to prescribe.
Not all of them are, but some of them can. Some of them can prescribe drugs. That's actually what we were going through, trying to come up with a laundry list. And we were going to contact OPLC and try to sort out who can and can't and so on. And that's where we finally decided just to set the simple guardrail. If you can prescribe to humans, that's so that we don't have the vets. And if you have a DEA license, then you're certified to qualify, because why should it matter if you're a naturopath or a PA or an APRN or a physician or a DO?
So you're functionally just adding naturopaths.
Yeah, I mean, although in dentists as well, because I think dentists are currently not included. And you may be seeing a dentist for a chronic tooth problem, chronic pain, and they may have done everything they can to try to help it, and it's not working, and this would give them a choice.
Other questions? Yes, Representative Bertrand.
Thank you, Mr. Chair, and thank you for taking the question. The Honorable Dr. Jerry Canuck. It's good to see you back, Jerry.
Thanks.
Would you be opposed to where it says at the end on line 9, just simply say a licensed provider of which one is qualified to provide pediatric or adult family care? What I'm trying to get to is that we have PAs, we have nurse practitioners, we have naturopaths. Why limit it to a physician or limit it to that category when above it for humans, they can actually write for almost all of the human subjects, but below it, we're restricting it to a pediatrician or family practice. Why not have somebody that's a PA or nurse practitioner as well?
Well, we did say family practice provider, and indeed that does not, we didn't use the word physician. Family practice provider could be a PA or an APRN who does kids.
Correct. But a pediatrician would be normally a physician. So I want to clarify it that it could be a nurse practitioner who actually specializes in pediatrics.
It could be. But that's why I'm just saying a family practice provider who provides pediatric care. I mean, if you're, I think that's clear.
Okay,
you're saying just say somebody who treats children?
Just, I misread it. I'm looking for somebody who's providing pediatrician is really kind of a physician.
Mm-hmm, yes.
So a nurse practitioner who's doing pediatric care, it's not a pediatrician.
Right. But they would be the.
But providing pediatric care is not family.
I see what you're saying, because that could be an APRN who doesn't do family practice, only does kids. I'm not quite. This may be a question for OPLC as to what kind of classifications we have there, and or maybe for nursing to know how that shakes out, because I don't know if they're still viewed as a family practice provider. And all the practices I've been working with, APRNs do adults and kids, but I suppose in a very large area there could be one who doesn't do any adults.
I'm just trying to remove as many barriers as possible.
Sure. Maybe one could just strike it. And I don't think TCMB would object to saying, or a provider who provides pediatric care, and get rid of family practice, just in case there may be a small number of PAs or APRNs who are providing pediatric care but are not officially a family practice person.
Correct. I
It's
think the intent
possible
by
Michael Holt, who's here, might know a little bit more about some of that licensure issue because he's from the department and might be able to clarify that. Thanks.
Other questions? Representative Nagel, is your hand
If I
up?
could clarify, just put pediatric provider or family practice provider.
May I?
Yes.
Oh, well, the problem is saying pediatric provider or family practice provider, where the initial language was or a family practice provider, period. We did want it clarified that it was a family practice provider who does take care of kids. So we shouldn't use the or construct there, because then that would put us back to what we had, TCMB had sort of objected to. So one could just say, or a provider who provides pediatric care, and that would certainly solve that problem. And I think we would have no objection to that, because our concern was to make sure that it's not a family practice provider who has never looked at a kid, because there are unique problems in kids, and you need to know those unique problems.
Other questions? Yes, Representative Murphy.
Thank you, Mr. Chairman, and thank you, Dr. Former Rep. Knurk, for taking my question. I don't have a problem at all with, pediatrician or family practitioner, because a lot of family practitioners take care of kids anyway. So to me, that makes sense. What I'm struggling with, partly because I don't know, when I had a DEA number, as you know, every 2 years or whatever it was, we had to check off the boxes that we would provide scripts for, 2, 3, or 4, something like that. Never did I check off box number 1, which is LSD and heroin.
Right.
So, but my question is, when you open up this language to be so broad to say that anybody that has a DEA number or license can now, certify somebody into the therapeutic cannabis program, which technically, is still a Schedule 1 drug, even though it's allowed into medical cannabis. My question is, do all these providers that you list, naturopaths, dentists, podiatrists, do they all check off the same boxes as you did as a treating spine surgeon? And if so, how are we going to differentiate their abilities, as well as, not only just prescribing or certifying, but also in evaluating those who are most, best served by this program?
Sure. Well, the issue is, if they are not qualified to prescribe controlled substances, then they're not allowed. So the point is, it'd be only those who have a DEA that allows them to prescribe controlled substances. And again, important to understand that precise language exists in Roman numeral 7A, numbers 1, 2, 3, 4 already, because that's how we have it written in. So that's why I say we did not invent this statutory language. We simply mirrored what was already there. But the issue is, let's say a naturopath does not have a DEA, they can't do it. If they cannot do controlled substances, they can't do it. But if they are a license to prescribe to humans and they have a DEA to allow them to do controlled substances, they would then be allowed to certify for therapeutic cannabis.
Representative Weber.
I'm wondering if we aren't making this much more complicated than it needs to be, because what the statute currently allows is 2 providers, one of whom may never have seen or treated a child ever before, but has a DEA license already. And the other one, it looks like all we're trying to do is make sure that at least one of the 2 has had some experience working with children. So I'm wondering why we need to make it more complicated than that if we've already been comfortable with virtually the same sort of thing all the way along. I mean, one of these people never has to have seen a kid.
May I? Yeah, yes. But I mean, exactly. But that's what's currently in statute, is that we have to have a pediatrician. But the issue is, a lot of kids don't have access to a pediatrician, so we wanted to simply expand it so that it would be somebody else as that secondary provider who does deal with children. But
May I follow up? my point exactly, I'm wondering if we're not, as we're trying to redraft it in many ways, making something that's relatively simple, which is just expanding it beyond pediatricians to other people who have treated children. I'm just trying to get around if we redraft it 6 different ways, are we making it more complicated in this case? And I know I try and redraft other things, but here it's such a very clear objective.
Well, I mean, one could, for example, just change the whole thing. Instead of saying either a pediatrician or if a provider who provides pediatric care, you could just say, shall be a provider who provides pediatric care. One could certainly do that, and that would cover them both. That would be a little more economy of words. And I think that would be something we would still be very comfortable with. I think we were being conservative and not wanting to strike language and trying to just add language, but sometimes that is a little bit more cumbersome. But I think it would certainly not violate what the TCMOB feels, because it would still honor the desire that it's somebody who looks after kids, whether it be a pediatrician or and that's why getting away from the word family practice provider, just in case it's an APRN who does kids only and otherwise doesn't take care of elderly like us, that would be pretty reasonable. So that could make it simpler, and I think that would not violate our concerns. I think we were just more concerned about striking language that, we didn't think that might be good. So, but you know how statutes get cumbersome as we keep adding, just like those standalone conditions, we keep adding stuff and then it gets more and more cumbersome sometimes.
Other questions? I'm seeing no other questions. Okay, thank you.
Thank you.
Also signed up to speak today on this bill is Michael Holt from the Department of Health and Human Services.
All you have to do is strike. Just provider.
Thank you, Mr. Chair, members of the committee. For the record, my name is Michael Holt. I'm the administrator of the Therapeutic Cannabis Program within the Department of Health and Human Services, Division of Public Health Services. My testimony will be brief. It's mostly to avail myself of the committee to answer any questions. This is a straightforward bill that removes a barrier to access. It allows more providers to certify patients for the program. I can confirm what Dr. Knurk said. That is, we have 10 or so minor patients on the program. It's a very limited population. And I would like to confirm that this is a call that we get on a regular basis from concerned parents who are struggling to get their kids onto the program. We're not talking about a large population, and the number 10 reflects the guardrails, but it also reflects the concern that parents have about children using cannabis and THC products. However, kids don't see pediatricians. Pediatricians are difficult, and this would expand it. The two suggestions made in terms of expanding it even further, are consistent with the goals of this bill. Former Representative Knurk, rightly says that the approach taken by the TCMOB was a conservative one, to not strike pediatrician. The department is comfortable with this language, has no objections, nor would we have objections to further expanding this to a more generic provider who provides pediatric care. I'm happy to take any questions. I would like to make an aside to Representative Nagel's question about how long it takes to get a card from us. We have a statutory mandate to approve or deny an application within 15 days, and then after approval to get a card out within 5. We are well within our mandates. We didn't used to be when the program first started, based on staffing and resources as a completely self-funded, non-general fund program. But I'm happy to report that for years we have been well within our statutes. Depending on volume and current staffing levels, we can get cards out within a week, but certainly we're compliant with the 15-day statute.
Questions? Thank you. Yes, Representative Murphy.
Thank you, Mr. Chairman, and thank you for taking my question. And again, I probably didn't say it as eloquently to Dr. Knurk as I should have, but I'm trying to understand, and I have no problem with family practitioner and expanding it to these folks. I guess when I look at this bill and it says any provider that has a DEA number can now certify a patient to be in the program. Is that correct?
currently the law allows for physicians,
Yep.
PAs, and APRNs.
So-
And the requirement for each of those provider types is for them, they must be authorized, licensed as one of those provider types. They must be licensed to prescribe drug to humans, which excludes veterinarians, and they must have an active registration for DEA. It's
So
important.
okay, go ahead, sorry.
It's important to know that therapeutic cannabis is not prescribed in the state of New Hampshire. It is a certification of a qualifying medical condition. And so the DEA is the requirement for a DEA number is intended to mean if you can prescribe, controlled substances, then you can certify for this program. It is not a requirement for a reporting of a prescription based on your DEA number. So there's no requirement for these providers to engage in the federal government and the DEA registration system, to be to certify for the program.
Thank you. And I understand the DEA number and the different categories you listed. I guess my question is more clearly, what other qualifications do you have to have? I mean, what I'm thinking myself, as an orthopedist, I would never feel qualified to certify somebody for that program because I don't know enough about it. So I'm trying to understand what the other qualifications of somebody that certifies are currently, right?
There are no, the state of New Hampshire does not require a certification of medical providers in the state. Other states do require in order to be an approved provider to certify patients, they need to be registered with the state as a cannabis provider. New Hampshire law does not require that. It does not require training. It does not require registration with the state as a cannabis provider, et cetera. So there are no other requirements for certification other than having a provider-patient relationship with the patient, explaining the health effects of cannabis to the patient, explaining health effects and risks to certain target populations, those who are pregnant, breastfeeding, and those who are adolescents. The General Court passed a law 2 years ago to require special education to those two populations. But to answer your question, there are no other requirements in order for a provider to certify their patients for the New Hampshire Therapeutic Cannabis Program.
So when I was
Follow-up?
practicing, follow up, thank you, I'm sorry. When I was practicing then, you're saying that I had a DA number and I had a license that was active in the state of New Hampshire, and therefore I could have certified a patient into the program?
As a physician?
Yes.
Yes.
Okay, thank you.
Representative Palazov.
Thank you, Mr. Chairman, and thank you for taking my question. Would you be able to tell about minors out of those 10 or 11 minors who are currently in the program, what kind of medical issues they're trying to solve with it? And those who were not able to get there, you said you're receiving calls from parents. Are those medical issues the same, or are there some other set of medical issues that they want to solve with this program, but they cannot get on this program so far?
So I do not have the list of minor patients on the program, nor do I have in front of me the qualifying conditions that they qualify for. Based on memory, of the 10, there are pain issues, which is as Dr. Knurk has said, 70+% of our patients are certified for a pain issue. The others are epilepsy. Childhood epilepsy is another condition that is, it's hard to say common. There's only 10, so maybe 2 of them have epilepsy and 6 of them have pain, and others have an undisclosed condition, with a pain condition. There's no the list of qualifying conditions that makes one eligible for the program is not distinguished between adult patients and minor patients. So the list that you saw in the last bill of the list, or the partial list, is the list that the kids are being certified for. Is that the answer to your question?
Yes, thank you.
Okay.
Thank you. Any other questions? Seeing no other questions? Okay, thank you.
Thank you.
Also signed up to speak is Heather Mary Brown.
Good afternoon. Long time no see. Again, I'm Heather Marie Brown. I am the patient rep on the Therapeutic Cannabis Medical Oversight Board. I will not take up a lot of your time, but I do want to express the importance between these two elements that this bill is asking to change. I will tell you that there literally is a handful of individuals within the state of New Hampshire that will or have certified patients for therapeutic cannabis. The idea behind this is something that I have felt very passionately about for a multitude of reasons. We held a listening session where we invited the public, professionals, patients, former patients, hopefully new patients, to come in and talk to us. The issues that were raised the most were accessibility and affordability, were two of the top things. This takes care of, touches on the accessibility part. It is very difficult in the state of New Hampshire to be a patient and have to go and shop around to find, literally shop around, make phone call after phone call after phone call to find a professional, a medical professional that would be willing to work with you, that is qualified under the statute to actually give you a certification. Unfortunately, I've seen several cases where that has led to individuals that will certify, but because certification is not covered under a medical insurance, for those that do have medical insurance, they are able to charge individuals an exorbitant amount of money just to receive a certification. I've had reports of patients having to pay in excess of $500 to $600 just to go in and see a provider to get this piece of paper signed, a piece of paper signed that says, we are certifying you to try therapeutic cannabis. That is absolutely ridiculous. By opening up the statute and allowing for any medical professional that possesses that number to be able to certify a patient, you are taking barriers away that will allow, again, for patients to develop a better relationship with medical providers, to allow patients to feel comfortable to have conversations with medical providers, and to allow for the exchange of information and even to a degree, a level of education for both medical providers and patients alike. As far as the second part of this bill goes, I personally, myself, have always been against creating barriers, whether we're speaking in regards to children's health care or adults' health care. I was able to develop in my own mind a compromise by accepting this. I personally wish that we didn't have to put our children through, our families through the process of trying to find not one provider, but two providers to sign the certification. But again, this is a compromise because where there are so limited amounts of certifying pediatricians or individuals in the state that are willing to certify as a pediatrician, this will allow families another option, another place in another area to search out treatment for their children. Both of these changes I find are necessary and long overdue, and I look forward to answering any questions that you may have.
Thank you. Questions? Yes, Representative Nagel.
Thank you, Mr. Chairman. Thanks for taking my question. You've been involved with this process for a long time, so I'm hoping you could answer my question. Why two pediatric people? Why do we need two to certify?
Well, and anyone in the back, Mr. Holt, could correct me if I am wrong, but to my knowledge, that decision was made because of, I'm probably not going to use the right terms, but, where we do know that cannabis can have a potential effect in adolescents. I think the thought behind it was so that everybody was making the right decision for that particular child. I think it was like a system of checks and balances. I again find that it's a system of redundancy and maybe is unnecessary, but by opening up the statute and changing who we allow to certify and changing that language to a family practice provider or someone that provides pediatric care, I think that does help families out immensely.
Yes, Representative Weber.
Would you also agree with me that in addition to your very thoughtful and complete answer, the other reason for the two providers there was that we needed to get this bill not only past the House, but also past the Senate and get it signed by the governor, whichever governor it was at the time, which has always been an issue?
Thank you so much for your question. If I can speak honestly, yes, most definitely. I think fear, it has been a huge driver of this particular vehicle. I think that fear comes from, again, lack of understanding, education, knowledge, whatever you want to label it as. I think that because the program has been so successful for so many years, that, you know, we as patients, as families, as parents, as individuals, we have been able to prove to the state time and time again that we are responsible with this program, that this program works, that this program helps, that it changes lives for the better. And that, you know, maybe it might be time to loosen up some of these restrictions and to make this an available health choice for those individuals that choose to access therapeutic cannabis instead of creating barriers based on our own lack of understanding or possibly education of it.
Thank you. Other questions? Seeing no other questions, thank you. And last person signed up is Dr. Joe Hannon.
Thank you for hearing me today. Joe Hannon, I'm speaking for myself. I won't repeat anything that was said previously, but I agree with pretty much most of what was said. I will say that as someone who has a 16-year-old son who's driving to his first dentist appointment by himself today, it's his first adult dentist appointment. He's usually going to a pediatrician. He's still going to a pediatrician, but he won't be 18 when he goes off to college. So he's definitely not going to have a pediatrician when he's away from home. So this is something that wouldn't just affect my son for a few months or maybe a little longer for some young adults, but many students to go to school in New Hampshire. Not everyone's 18 when they go away from home. I could maybe answer some questions about being a podiatrist and prescribing. You know, I like the esteemed orthopedist on the committee. I studied the whole body and I know the purpose of all the organs. I know that the heart is supposed to pump Ancef to the bone. And I was fully licensed, had a DEA number, licensed, prescribed narcotic medication to patients. In training, I even gave fentanyl lollipops to pediatric patients with severe burns to the lower extremities. So I had a DEA dispensing license as a podiatrist. So I was able to, I didn't do it because it was not something I really want to do, but I had the ability, if I wanted to give out narcotics from my office. So there are other providers who are more than capable and have the experience and knowledge to do at least as much as a nurse practitioner or another provider can do that's already allowed to certify patients. And I'd be happy to answer any questions, and that's all I have to say.
Thank you. Questions for Dr. Hannon? I'm seeing no questions. Thank you. I have no one else signed up to speak. Does anyone else wish to speak on HB 610? Seeing none, I am going to close the public hearing on HB 610 and open the public hearing on HB 431 and invite the prime sponsor, Representative Wendy Thomas, to come and testify. Yes. Okay, great. Thank you. And we don't time the prime sponsor.
Another cannabis bill. Mr. Chair, members of the committee, to remind you, I am Representative Wendy Thomas. I represent the town of Merrimack, and I come before you today to present House Bill 431, which is permitting qualifying patients and designated caregivers to cultivate cannabis for therapeutic use. As a reminder, I am a New Hampshire therapeutic cannabis patient. I use cannabis on a daily basis for pain and illness. I take those microdoses that were referred to earlier. This bill would allow New Hampshire therapeutic cannabis patients or a designated caregiver to grow cannabis plants at their residence. It would allow New Hampshire therapeutic cannabis patients to have and grow 3 mature, which are flowering plants, 3 immature, which are non-flowering plants, and 12 seedlings, which are defined as 6 inches tall or less. This bill would allow them to grow cannabis at their place of residence and consume the cannabis that they grow. By growing their own cannabis, the patient can choose which effective strains to grow, and they would see a cost savings for their medication. Recently, when the Therapeutic Cannabis Medical Oversight Board met, they voted to unanimously support this bill. So, reasons for home cultivation. Secure home cultivation is not causing any problems. 14 of the 18 states that have legalized adult use cannabis and about half of the medical cannabis states allow for personal cultivation. In the states that have reasonable safeguards, home cultivation has not been a problem. No state has repealed home cultivation. Home cultivation is important for patients. About 6% of Americans use cannabis for therapeutic reasons. Insurance does not cover cannabis. For many people with serious medical conditions, medical expenses and a reduced ability to work make getting cannabis difficult. By allowing home cultivation, you are giving the therapeutic patients financial relief for their non-insurance covered medicine. Home cultivation helps to displace the illicit market. Some patients need more. Some patients don't have the financial means to purchase tested and measured cannabis from the dispensaries. Home cultivation would allow those patients access to cannabis without having to use the illicit market. Home cultivation is consistent with our commitment to freedom and equality. In a free society and a state with the motto, live free or die, adults should be allowed to grow cannabis plants in their homes for therapeutic use. A little bit about what other states are doing. In Connecticut, it is legal for patients to have up to 3 mature plants and 3 immature plants. In Maine, it is legal for patients to have 6 flowering plants, 2 immature plants, and unlimited seedlings. In Massachusetts, you're allowed 6 plants per person or patient, no more than 12. Rhode Island, it's legal for patients up to 12 mature plants and 12 immature plants per patient. And in Vermont, you can have 2 mature plants and 7 immature plants per patient. Since 2009, the New Hampshire House has consistently supported bills allowing patients with qualifying medical conditions and their caregivers to cultivate a limited supply of cannabis. In 2012 and 2019, the Senate agreed, advancing home grow legislation to the governor's desk. Both bills were vetoed, and the override efforts fell short in the Senate. In 2020, the Senate passed a home grow bill in a voice vote, but the outbreak of COVID-19 prevented it from being considered in the House. Finally, there is an amendment for this bill. I've sent it around. It is a draft, and it corrects some drafting errors from OLS. First of all, it corrects some outdated RSAs that were referenced. When we tighten up the security language, the phrase "at the person's residence" was inadvertently removed. This is language that the police wanted in there, and it was an error that it was removed. The amendment would put it back in. The date for the department to allow existing and new qualifying patients and caregivers to designate a cultivation location has been moved in the amendment from October 2023 to December 1st, 2023. This was in consultation with the department and gives them more time in the event that the bill is passed after a veto. The draft I've passed out still has some errors from OLS, and Mr. Holt will speak to those issues when he testifies. Thank you, and I will take any questions.
Thank you, Mr. Chair. Thank you for taking my question. Just out of curiosity, where do you go to get the seedlings for the home cultivation?
So, well, first of all, you can buy seeds. The FDA has declared that seeds are available, cannabis seeds, because they do not contain THC. So you could buy seeds and you could grow your own. There is some discussion with the dispensaries that they will provide seedlings. That's to be developed with each dispensary, but that's an option that could be available. But I would think mostly from seeds. You're welcome.
Yes, Representative Cushman.
Thank you, Mr. Chairman. Seen an article recently about Montpelier, Vermont. There was a contaminated batch of cannabis that was recalled from their state program. Is this bill something that can prevent people being exposed to bad batches of cannabis that may be at the ATCs?
Theoretically, it could, but in New Hampshire, all of the cannabis is tested prior to it being available to patients. And I'm going to guess that there was a mold issue, perhaps, with the cannabis. So that would be tested for. So you're not going to see that in the dispensaries. With plants, this is not growing your daddy's tomato plants. It takes a little bit of time, a little bit of effort. Mold can be an issue, but that's going to kill the plant. So, you're going to have to take care of them.
Other questions? Yes, Representative Pofalt.
Thank you for taking my question. So we have heard a good deal. So you talked a little bit about costs.
Yeah.
We have heard a good deal when we hear about other bills about access, and particularly people who live in the North Country. So can you speak to the location of these dispensaries and the effect that has on people who may live in the North Country or elsewhere?
Well, you should have been here 4 years ago when I presented a bill on that very topic. And because of the bill, 2 more dispensaries were opened up in the state of New Hampshire, particularly in the North Country. This bill would help patients up there. Some of those patients have to drive almost an hour to get to a dispensary, and you're limited in how much you can get. So this would certainly help those patients. And again, cannabis is not cheap. It's not cheap. I take microdoses, so a little bit, goes a long way. But there are some patients that have significant health issues that need a fair amount on a daily basis. And that can be expensive. One other thing to remember, or to know, perhaps you don't know this, is that if you grow the cannabis plant, it's the bud, it's the flowering bud that is used, and it has to be decarboxylated. So you can't, there's no danger of somebody rubbing against the plant and getting euphoric. There's no danger of your dog eating the flower. They'll probably be very calm, but they're not going to be euphoric. The way that you decarboxylate is you apply heat, which is why people smoke cannabis.
Other questions? Seeing no other questions? Okay, thank you.
Thank you.
Also signed up to speak is Jerry Kinnick. Former Representative Jerry Kinnick.
Okay, thank you, Mr. Chair. And for the record, again, Jerry Kinnick, Chair of the Therapeutic Cannabis Medical Oversight Board. A lot of the stuff in my written testimony I can skip because you've already covered it. Basically, the issue is when a person is approved to be a qualifying patient, they're issued a registry ID card that allows them access to an ATC. And that's where they are counseled regarding appropriate strains and routes of administration, and they obtain their therapeutic cannabis. Currently, patients cannot grow their own therapeutic cannabis. Now, it's important to realize that cannabis is not just one compound. It's not one drug. It's a botanical. As a result, it contains hundreds of different chemicals Different cannabis strains have different cannabinoid profiles, most notably the concentrations of THC, that's the major intoxicating component, and CBD, which is non-intoxicating. Terpenes, they're responsible for the aroma of plants. They also vary amongst strains, and they modify the response to the cannabinoids. And the synergistic effect of the cannabinoids and the terpenes is called the entourage effect, and that gives different strains different effects upon symptoms. So patients often need to try different strains for a while to get one that'll give the desired effect upon their symptoms. Once they find what works, they need to stick with it. That can sometimes be a problem because an ATC may drop a strain due to low demand, leaving a patient without access. Also, there was that comment a moment ago about access to, in general to the ATCs, and indeed it is quite a ways for a lot of us anywhere, but specifically in the North Country. So last year, the TCMOB held a listening session for feedback from patients about the functioning of the program. The most common concerns were affordability of the products, accessibility of the ATCs, and availability of the specific strain needed by a patient to treat their symptoms, which may not be available in their nearest ATC. Several patients who spoke to us felt that home cultivation could at least partially address many of these concerns. At its January 2023 meeting, TCMOB voted unanimously that it agrees with the concept of home cultivation of therapeutic cannabis by therapeutic cannabis patients and caregivers to help with accessibility, affordability, and strain availability. I do have a few specific points I'll express, but at this point, understand that I'm now speaking for myself, not TCMOB, as we voted on the concept of home cultivation, but we did not go into the weeds on specifics of the language. Okay, good. You're paying attention. I used the same trick last year on the floor, too. Anyway, the point is that the bill has a lot of really good features, such as allowing a patient who cultivates to be able to submit their cannabis to a lab for testing. That's great because it allows them to get their cannabinoid profile and to ensure safety with respect to contaminants. The bill also has robust protections with respect to limitations and the number of cannabis plants and the registration of cultivation sites that must be enclosed and locked. These protections will make home cultivation safe and secure and controlled and should satisfy the concerns of law enforcement. It's important to realize that an awful lot of patients will probably not grow their own. Some will not have the space, some will not have the skill. I would suggest adding language also, though, to allow ATCs to provide seeds and clones. It currently says seedlings, but to provide seeds and clones to patients to assist them in growing the specific strain they need for their condition. I do disagree with one issue. Page 6, lines 4 through 13 allows home cultivation for potential qualifying patients who have not yet been granted a card. This could be an enforcement nightmare. Again, page 6, lines 4 to 13. Could be an enforcement nightmare, and I feel that they can wait that short time until they get their card and we know their location before they would be allowed to do it. Now, I do not have a copy of the amendment, so I will not comment on that. Again, I'm speaking for TCMOB primarily, and we talked about the concept, not the specific wording. I will defer to Mike Holt for a discussion of the particular problem. So in summary, allowing home cultivation of therapeutic cannabis by the therapeutic cannabis patients will be very helpful for our patients in addressing affordability, accessibility, and the availability of specific strains. And Mike Holt and I would be glad to work with the committee on any needed amendments. Thank you.
Yeah, thank you. Questions? Yes, Representative King.
Thank you, Chairman McDonald. When it comes to and thank you, by the way, when it comes to the reasonable precautions and enclosed spaces, that doesn't preclude being able to grow outdoors, does it?
Well, for example, I have a greenhouse. I don't grow because it's not legal, but I have a greenhouse. If I wanted to do so and I were a patient, as long as I had a way to lock that would be an enclosed, it would be not visible without somebody ripping the plastic off, and it could be locked. So that's the whole issue. It could be done outside. And indeed, it is a problem. Growing inside requires really high intensity lighting and a lot of costs that are there. It's probably a little easier to control the environment than it is inside of a greenhouse. But you're not going to see farms, big, just out in the field somewhere because that's not enclosed and so on and so forth.
Follow up?
Follow up.
What about just a fenced in area with sunlight but no greenhouse? Is that okay?
Ooh, let's see. I'm sorry, can you remind me which line that's on, because I want to make sure.
That's in That's lines 5 through 9 on the first page.
Yeah, okay. Yeah, an enclosed
in the
locked
amendment.
space. I mean, if it's just fenced, I guess it could be locked, but it would have to be not accessible. So you'd have to have a pretty high fence, and, with barbed wire or something like that, probably. I mean, that could certainly be tidied up to make it enclosed and non-accessible if one wishes to add just a little bit more language to that. Thank you.
Representative Murphy, did you have a question or?
Thank you, Mr. Chairman. And thank you, Dr. Ex-Rep, Knurk. A simple question. We had a similar bill last year in front of us about legalization of cannabis. And one of the big concerns was that the availability would potentially compromise the therapeutic home or therapeutic cannabis program. And the reason being was, the whole idea about counseling and education. Do you have any concerns that this would detract from that, or would patients be less likely to participate in the education and counseling part of the program?
It's interesting. When I first was thinking about this, I did have some concerns about that it would drive patients away from the ATCs. It turns out our ATCs actually support this because they have a solid goal of trying to be sure that patients have access to therapeutic cannabis. And they, they're not just there to make a bunch of money. They're there to actually make sure people have the access, and they realize this may be a good way to do it. I can't speak for them, but I know that one of the representatives from Prime is here, Matt Simon, and will speak to their point of view on this. I think, though, probably patients will still start in the program so they can get counseled, find out what the strain is that works for them, maybe find out that that's only available in some other part of the state and they don't want to go there. So then they might get some seedlings or clones from that ATC, which would be a way to still reimburse the ATC for their work, and then start growing on their own. So yes, it might have them out of constant contact, but they certainly might still touch back if they are having some issues.
Other questions? Representative Nagel, did your hand up or?
Would you believe?
It should be a question, though.
In all full disclosure, I'm on the board of Temescal, and we are nonprofit. We are not for profit.
Right.
So in the end, in theory, the goal is the benefit of everybody.
Yes, that's what I mean. These are not people who are trying to gouge the patients. These are organizations who are trying to do a good job of providing therapeutic cannabis, and they see this, as best I understand, as a way to expand that. But Matt Simon can discuss that better.
Other questions? Representative Weber.
I would just have one other question because there was the concern that was asked about and that Representative Thomas spoke about with a batch of therapeutic cannabis in Vermont that was recalled. But is it not true that just as there are potential issues that we have taken better steps to guard against here, that it's also perfectly possible that somebody who is home growing can wind up with mold or some other thing. So it's not a be-all and end-all panacea. It's another route to be explored with all the others.
Yes, I think so. And indeed, that's why I say a lot of people don't have the skill set. I mean, I get problems with my plants that I grow both in my garden and in my greenhouse. It can be a real nuisance. Sometimes they're recognizable, but that is one of the good features of allowing the patients who are home growing to be able to take in for testing if they wish to do so. So there is that tremendous safeguard. And so if they look at their plant and they go, well, I wonder if that's really okay, they can go check it. Also, I would assume that the ATCs will get involved in some decent counseling about how to safely grow so people aren't growing in lead-filled soil with a bunch of pesticides that they're then going to combust and inhale.
Representative Leon.
Thank you, Mr. Chairman, and thank you, Honorable Dr. Knurk, for being here today. My question comes to the idea that one of the people who's a caregiver would currently be limited to just one patient, and I'm just curious about the situations where you may have, say, 2 patients in a household, and if that would be something that would be reasonable within your experience, if we'd be able to expand it to a certain number of people in a household and not just one individual for a caregiver.
Yes, I think that could be a little bit of an uncertainty. In other words, if you do have, let's say, 2 people in a household, do they each qualify for the same to each by themselves have a certain number of plants. So the number in the household would be more than the qualified amount, but they would each be responsible for 1/2 of that. I don't see why that couldn't work. I would think that it would be okay. They just happen to be residing together.
Thank you.
Other questions? Seeing no other questions? Okay, thank you.
Thank you very much.
Also signed up to speak is Dr. Joe Hannon.
Hello again. Joe Hannon. Like I said, I was on the Marijuana Study Commission years ago, and one of the things that we did talk about was home grow in general for adult use, not just medical. And that was the issue of that commission. It didn't seem to be a very controversial issue. There were some members of the commission who obviously didn't agree with it or legalization in general at all. But a vast majority of the people in the commission realized that home grow was akin to home brew of beer and wine. You know, we're allowed to brew. You can have 100 gallons of beer or wine. If you have 2 adults in the house, you can have 200 gallons a year. That's a good amount. And in this bill, it does talk about more than one certified provider for a cannabis patient or 2 cannabis patients living in a home. You can have, if you have 1 provider and a patient, you can have 50 square feet of canopy. And if you have 2 either providers or patients in the household, you can have up to 100-foot canopy. So that is in the bill already. And as far as protections, the homebrew law is really simple. I'm sure, I don't know if you read it much in this committee. I was on Commerce, we had to read it all the time. But it's real short. It's a couple paragraphs, and it just says, it's for personal use is really what it's. You can grow this much, brew this much. It's for personal use. There were no requirements for, locked doors or keeping it from public view. Although it's probably a good idea with some of my neighbors. They're very nice, but I wouldn't leave it still out in the yard or whatever. But as this bill does have parts that talk about, not being able to be seen from public view. One thing I'm not really sure is necessary with or without the use of optical aids. If someone's using a telescope to look into my yard, that's a little intrusive. So I think it'd just be from plain view would be a nice change. And really, that's about it. It's a pretty straightforward bill. And otherwise, if I could make my own medicines at home, I'm sure I would for most things. I've actually gone to the pharmacy several times in the last month for my family, my children, and myself. And there are 3 different medications in my family that we have not been able to get a hold of. Not that there's a shortage of cannabis right now, but if you can't get a medication, I would have loved to have been able to grow, blood pressure pills or whatever it is at home. So, thank you.
Questions? Seeing no questions? Okay, thank you. Also signed up to speak is Matt Simon from Prime ATC. You have 3 minutes, sir.
Thank you, Mr. Chairman, Honorable Committee. Great to see you again. I don't have written testimony. Instead, I'm going to refer to 2 one-page documents that Representative Thomas presented with the packet she gave you earlier. One of them is home cultivation legislative history. One is cannabis cultivation laws in New England. And I mention these because before I worked for Prime ATC, I've been for the last 15 years advocating for cannabis policy reform in New Hampshire, and in particular, legal home cultivation for both patients and for adults. Prior to working for Prime ATC, a job I took about 1.5 years ago, I worked for the National Marijuana Policy Project for 10 years. In that role, I advocated for this therapeutic cannabis law in 2013, back when Representative McKay was chairman, and spent a lot of time with this committee back then. And even before that, in 2007 was when I started advocating for this stuff in New Hampshire. So I really sincerely hope and cautiously optimistically perhaps believe that this will be the 15th and final year that we all have to come in here and ask this committee to do what it has in fact done many times in the past, approve limited home cultivation of therapeutic cannabis. So I'm not going to go through all this, but this is a document I created 5 years ago, and I've updated each year as further developments have happened. Now it takes 2 pages to tell the whole story, but I'm really hopeful this is the last entry, that HB 431 will be the bill that passes into law. And you can see just how close patients have come. 2 votes in 2009 were the difference between this passing and not, and including home cultivation. Again, in 2000, multiple times, it's been within 3 votes. In 2019, it was a 3-vote veto override. The House overrode the veto and the Senate didn't. So the other document is just laws in New England. I made this a few years ago when it wasn't complete, but I had fun updating it last week and now showing that every state in New England, cannabis is now legal not only for medical use, but for adult use, and patients and adults in every state are allowed to grow cannabis for their own limited use. So the Live Free or Die state is, yes, the only state in New England where it is a crime to grow small amounts of cannabis for registered patients and for adults. Connecticut's the only one that hasn't taken effect yet for adults. Patients can grow there, and they've passed it for adults. So July 1st of this year, that will take effect, and we will be truly an island of home cultivation prohibition in New England. So I'll leave those aside. I do want to note briefly on the affirmative defense provision that former Rep. Knurk mentioned. So the bill does 2 things. One is that it adds possession of plants to what's legal for patients. The second part is an affirmative defense. So this doesn't, in my view, create chaos. This means that if somebody happens to be arrested and could be charged with a crime for possessing a few plants before they receive their card, that they would have an affirmative defense that they could take into court. They could still be arrested, they could still be charged, but their attorney could walk into court and say, hey, my client has a card now, it just arrived in the mail yesterday, and do we really want this person to face felony penalties, which is what the penalty is for home cultivation. So
We could start wrapping up, sir.
Absolutely. I haven't even gotten to my employer. Prime ATC supports this. I would not work for any cannabis business that opposed home cultivation. We understand it's not a bottom line issue for us at all. As Representative Nagel mentioned, we are nonprofits in New Hampshire. Our mission is to serve patients, and I have never been able to understand any argument that says exposing patients to felony penalties is in any way beneficial for their health and well-being. So most patients won't want to grow their own. For those that do, our staff members are excited about the possibility of being able to help educate and provide support in any way that we can. If that's selling seedlings or whatever, we're totally open to that. We want to help our patients live their best lives. So be happy to take any questions. Thank you for considering my testimony.
Representative McLean.
Thank you, Mr. Chair, and thank you for taking my testimony. Mr. Simon, one of the things you mentioned in your testimony was some of the history and some of the barriers to passage in the past. I've noticed today with all of these bills, I haven't really seen a lot of law enforcement presence. As part of these discussions, and maybe former Representative Knurk could give input as well. What has been the feedback from the law enforcement community with respect to this legislation? Have they been consulted and given you any feedback at all?
Thank you for the question, Representative. So over 15 years, I've had many meetings and conversations with various members of law enforcement. I would not paint the law enforcement community with a broad brush and say that law enforcement thinks this or law enforcement thinks that, because I think there are hundreds, thousands probably of law enforcement professionals who have their own opinions. I will say the New Hampshire Chiefs of Police Association in particular has weighed in very strongly on this bill and on this issue all along. They opposed therapeutic cannabis no matter how it was written, no matter how restrictive it was, even if it was only for cancer, even if it was only going to help one patient. They were absolutely opposed to passing this law in 2009 and 2013. They've been absolutely opposed to decrim, for that matter, to any form of legalization, to any form of home cultivation. They have been reliably, vigorously opposed and unwilling to negotiate. I remember a 2-hour meeting at a certain police chief's office with their lobbyist and a state senator trying, because the Senate asked us to negotiate. Well, we all sat down for 2 hours. They were not willing to negotiate. There was no version of this that they were ever going to be comfortable with. And for that reason, the legislature ultimately decided, well, we're going to do it anyway. I've also heard the state police major testify publicly that there have been no problems associated with this law in the years that it's been implemented. So the chiefs of police very opposed. I think the silent majority of law enforcement professionals probably do not have any issue with this and do not want to bust people for a few plants.
Other questions? Yes.
Yeah, can I just make a public comment about, you said any police officer, there was one actually in here previously. He had to leave, I noticed, because we are quite over time with when this was supposed to go up. But I know, the only reason I know that is because I've known him since he was a teenager when we walked in. So he is a high-level police officer. So there was someone here, but he did have to leave because of time.
Representative Leon.
Thank you, Mr. Chairman, and thank you, Mr. Simon, for being here and the knowledge you bring. My question is going back to the definitions of seedlings and immature plants. I don't see any definition of immature plant, although as somebody married to a gardener, it's obvious when it actually comes to gardening what mature and immature is, and I didn't know if that would be a point of confusion for anybody. So I'm just curious as to whether we would need to look for a definition of immature plant now that classification is added.
Thank you for the question, Representative. So I'm looking at the bill. I'm on the first page. I'm looking at line 24, and I see a definition that appears to be a definition of immature cannabis plant. It says immature cannabis plant means a cannabis plant that is not flowered and which does not have buds that may be observed by visual examination and which is at least 6 inches tall. The next line is the definition of mature plant that's a female cannabis plant that's flowered and that has buds that may be observed by visual examination. So now that I'm reading this, I'm remembering like 5 years ago when we worked out these definitions and they made sense to me then. They still do. Does that make sense to you?
You're right. I should have put these on. I apologize.
Very well.
Thank you.
Other questions? Seeing no other questions.
Thank you.
Thank you. Also signed up to speak is Michael Holt from the Department of Health and Human Services.
Hello again. Thank you, Mr. Chair. My name is Michael Holt. I'm the administrator of the Therapeutic Cannabis Program. My major point of testimony is that the amendment that was circulated by the sponsor, Wendy Thomas, is a needed amendment. The amendment passed out needs further work, and I am eager to work with the sponsor and the committee to make that amendment accurate so that it addresses the issues in the bill itself. The committee has asked very excellent questions about this bill. This bill has been around the block for years. We have worked with the sponsors in years past to identify obstacles for implementation. There are none for the department to implement this bill. Some of the highlights and the precautions built into this bill, I just like to highlight. This bill allows either the patient or their caregiver to cultivate, not both. If the caregiver cultivates, that means that caregiver can only serve one patient and not the normal 5. It is true that the majority of patient-caregiver relationships are one-to-one, and we have very few caregivers that serve multiple patients, but this limits that caregiver to only having one patient if they're cultivating. Whoever cultivates must report the cultivation location to the Department of Health and Human Services so that it's in the record. One of the things that the amendment does that is critical for a security and public safety standpoint is to require that cultivation location to be at the individual's residence so that it is not in a factory warehouse down the road. It is a location reported and it must be at the residence. Currently under current law, the one testing laboratory in the state can only accept cannabis samples from the ATCs. This bill has a provision that allows that one laboratory or any future laboratories to accept samples from the public being a therapeutic cannabis patient or their caregiver, to bring in samples to have that tested. Certainly doesn't address the issue of, a patient using, pesticides that are bad for them to inhale perhaps, but it does allow for the opportunity to have that tested for contaminants and the cannabinoid profile to identify the potency of the product. Another critical provision is that it does allow for a source of seedlings. The ATCs are permitted to sell a limited number of seedlings to their patients within a certain time period that's consistent with the plant limitations and the seedling limitations in the law. As was stated, seeds are legal federally, so people could grow their own. But that allowance that allows the ATCs to engage in this process with their patients allows the education, that to happen based on that developed relationship. And yes, again, to be clear about the grow, whether indoor or outdoor, the bill does not restrict indoor or outdoor grows. It is presumed to allow outdoor grows, but it does require them to be enclosed, locked, and later on page 2, it requires them to be out of public view. So these are standard precautions in other home cultivation states. But again, to conclude, I would say that an amendment is important for this bill, and I'm eager to work with representatives in the committee to nail that down.
Representative Weber.
In the interest of time, we've normally gone through the amendments needed, but in the interest of time, would you be willing to email to the committee members who will not discuss as a whole, because that would violate 91A, but could you email each of us your specific concerns with the bill as amended by Representative Thomas's amendment?
Yes, I can and will.
Thank you very much.
Welcome.
Representative McKay.
Thank you, Mr. Chairman. Over the 5 years that I was chairman, working to develop this program, and I feel a bit emotional, but surprises me. The one person that held me together, and I think the commission, which was not always easy, was Michael Hope. And he, as you can see today, is a reasonable human being in a very difficult position, so that it's kind of nice that after all these years we can say something positive about this person in the Department of Health and Human Services, who desires a great deal of recognition and support for his great work. Thank you very much.
Well, thank you, sir.
Other questions? Seeing none, so thank you.
Thank you.
Also signed up to speak is Heather Marie Brown.
Good afternoon. Heather Marie Brown, patient rep, Therapeutic Cannabis Medical Oversight Board. I'm not quite sure if Representative Knirk mentioned it. I didn't hear him, but it could just be the acoustics. But I do want to tell you that the Medical Oversight Board did vote unanimously to support patient home grow, which is a huge accomplishment, and I'm very excited about that. So I'm glad to be able to tell you all that. I'm just going to give you a little example. My income is $18,000 a year. I can barely survive as it is, take care of my children, pay rent, electricity, especially with the way that electricity rates are now, heating, fuel, food, you name it. All right. I'm very limited on that. If I were to purchase the cannabis that I use throughout a month from a alternative treatment center, I am looking at spending approximately $10,800 a year. Now my income's $18,000. So guess what I'm not doing? I am not getting all of the cannabis that I need from the alternative treatment centers. Unfortunately, I am not the only patient in that situation. We have many patients that are in that situation. They are forced to do one of three things: either live and suffer, acquire their cannabis from a unregulated black market, or risk their safety and their health by traveling over state borders to other states and spending their money in those states because they can acquire therapeutic cannabis so much cheaper. They can acquire cannabis for so much cheaper. Maine is the wild, wild west when it comes to cannabis, and they don't necessarily have some of the rules and regulations in place that prevent bad cannabis from getting out to the public. So that is always a risk. Medical home grow, in my opinion, is a necessity. It allows a patient to be able to help supplement their supply that they are already currently receiving from an alternative treatment center, and help defer costs for that patient. For me, I prefer to grow outside. So, sir, I already have a 10-foot high, 10 by 10 dog kennel at home waiting for this bill to hopefully go into law, and that puppy's mine. But for approximately $150, I will be able to grow a batch of cannabis that could potentially give me, even under the stipulations of this bill, could potentially give me the enough cannabis to last me for 3 to 4 months out of the year. This is a long time coming. Again, we have a well-established program. Our patients have done absolutely nothing but prove time and time again how serious they are and how responsible they are in regards to their health and in regards to following the rules and stipulations of the program. I think it's a no-brainer, and that we should definitely push for this bill to go into law. I am aware of some of the amendments that have been
Wrapping up, ma'am.
requested, and I agree with those as well. They are just little changes. But thank you very much.
Thank you. Questions? Yes, Representative Polazov.
Thank you, Mr. Chairman, and thank you for taking my question. I agree with general premise that home cultivation will help, especially people on low income. But I wonder, since you gave us an example with certain income level, is it true that people on low income already have some kinds of assistance with their basic needs, like SNAP programs? Some have subsidized housing, some might qualify for housing assistance or daycare assistance. So do you see any of it, and what other needs you see competing with the need for marijuana? Thank you.
I'm going to try and answer that as best as I can. I believe that even if a individual, if I understood you correctly, a low-income individual is receiving some sort of public assistance, that assistance is definitely not enough to offset the cost associated around therapeutic cannabis. I think that regardless of, those individuals are still being forced to pick and choose between paying a bill, buying food, or in my case, being able to walk and function daily. I hope that touched upon your question and answered it correctly.
Yes, Representative Shapiro.
I would just like to suggest that we, given the time and all the bills we have left, that we really try extra hard to keep focused on the bill itself and not extraneous issues.
Okay, thank you. Okay, any other questions for this individual? Seeing none? Okay, thank you. Also signed up to speak is Zach Williams.
Good afternoon, committee members. I'm here to express my full support for HB 431. As a medical cannabis patient, I have seen firsthand the positive impact that access to safe and affordable medicine can have on individuals living with chronic conditions and disabilities where medical home grow is permitted. Medical home grow offers patients like myself the ability to control the quality, safety, and cost of their medicine. With my cannabis regimen and the prices at the local ATCs, I am looking at spending around $700+ a month for 2 ounces of medical cannabis. Furthermore, we have seen over recent years how other states have expanded medical patient home grow rights due to the importance of such programs. I urge you to support medical home grow through House Bill 431 and allow patients like myself the basic ability to access safe and affordable cannabis. Thank you.
Thank you. Questions? You taking questions,
Yeah,
sir?
sure.
Any questions for this gentleman? Seeing none, thank you.
Thank you.
Also signed up to speak is Derek Shirley. I believe he's representing 19 medical patients. Again, 3 minutes, sir. Thank you.
Oh, sorry. Sorry. So first off, good afternoon, everyone. My name is Derek Shirley. I'm a medical cannabis lobbyist living in Maine. I'm here today representing about 20 medical patients, 19, and residents in New Hampshire that are in favor of HB 40 or HB 431. A little background about myself. I am a cannabis patient who practices the right to home grow. I'm a proud cannabis felon for 4 ounces of cannabis. In Maine, I sat on my Maine Cannabis Coalition Board a little over 4 years, where we wrote laws, passed laws through our VLA committees, and later on to our Senate. I sit on my town zoning board of appeals, and I lobby in the Maine State House and local levels to protect and preserve medical rights as patients and caregivers. I too personally am in favor of 431. A little bit of input from the patients from New Hampshire: quality control, affordability, access, increasing access, convenience, personal empowerment, privacy rights, and protection from the illicit market. Now, living in Maine, I have a pretty great patient rights to home grow. I have to make a little bit of correction. We actually have 6 mature plants, 12 immature plants, and unlimited seedlings, and we define our seedlings by 24 by 24 inches wide and inches tall. Compared to HB 43, Section 11A, Line 3, New Hampshire patients are allowed 3 mature plants, 3 immature plants, and 12 seedlings, and defined by 6 inches tall. While we're for this, and we love HB 43, we would really recommend that you maybe look at popping seeds as a statistic. If you have 12 seeds to pop, maybe they all don't pop. Maybe then you put them in the ground wrong. Maybe then only 4 come out of the ground. So if we're gonna get these people home grow rights, let's set it up correctly. Again, this is your state though. I'm not telling you what to do. To be clear, just a recommendation. Same thing with immature plants. I mean, these people aren't getting high. It takes 8 to 13 weeks to flower a plant. So it's like, again, these plants are just kind of sitting in limbo. They're not causing any harm. Again, your state, I'm not telling you what to do. To be clear, there's just recommendations. I'm a patient. I want to thank all the 20 patients that let me represent them today. And I personally want to thank you guys for listening, driving out to Maine. I'll take any questions. And most importantly, I am a person, not a party. Thank you.
Questions? Yes, Representative King.
Thank you, Chairman McDonald. You've been doing this for a long time. I think you know what you're doing.
Yes, sir.
Do you think 3 plants mature and 3 immature is enough? Because it sounds like it's not enough, and you have experience with this sort of thing.
Yes.
Would it be better, do you think, for us to just get anything through now, or should we just go right for the jugular and say 12 plants mature, 12 plants immature? Or better. I mean, we are the live free state.
I'm just a second to add. Just to go on, I don't know any of your names by chance, so I apologize. You made a good point about, it depends. Do you guys want to slam this through or get it done right? You know what I mean? Because like at the end of the day, when you are limiting, like here in Maine right now, I'm actually fighting to put bills to eliminate plant count. That's what I'm doing in my state house right now. So I'm, again, not recommending that for you guys, but I think you should absolutely think about not even how you feel about cannabis, just think of the statistics of popping a plant, growing a plant, don't care what it is. Think about the statistics of the plant. Seedlings aren't hurting anyone. You can't even sex a plant at 6 inches tall. You can't even sex a plant. So even then, after that, let's just say all the seeds popped. Let's say 12 for your law. Pop 12 seeds, 8 come out of the ground, cool. And then I have to wait till they're past 6 inches to sex them. So then even then I might have 5 males that are useless. And then I leave me next to 1 plant, 1 immature plant, and then whatever. So that's all my point is. I don't want to sit here and tell you how to run your program because this is not my state. I just listen to patients that love Maine's program. And yeah, that's all I'm here to do because I think it's really important that if you guys are going to pass a home grow bill, right, you give these patients the access. Give these people what they want and not let them fail. Because right now, you will be back here again if you pass it as is. But again, my patients just want home grow rights. They don't really care how it's written. But that's where I step in and understand the bill a little bit more than the average patient. But I am just a patient at the end of the day. But the big thing is, let's not set these people up to fail. Let's do it right the first time. I know it's hard to get through the Senate. I fought my Senate in Maine many years. I'm a cannabis felon, and I'm proud of it. And that's why I wear my handcuffs today, because I will fight for these rights for these patients until I'm blue in the face. I don't care what state I'm in. But when you're affected by a felony in cannabis, I'm sorry, I'm getting off topic. But yes, to answer your question, if you want to get it through, and just do it as is. But if you actually have the power, the actual numbers to get it done right, get it done right. That's my recommendation. Do whatever you want in your state. Live free or die.
Other questions? I'm seeing no other questions. All right, thank you.
Thank you for your time.
Final person who has signed up to testify this afternoon on HB 431 is Danielle McQueen.
Hello. My
Again,
name is,
3 minutes, ma'am.
I'm sorry, what?
3 minutes, please.
Oh, that's fine. I think I can make it. Thank you for your time. I'm here to support the bill. My name is Danielle. Danielle McQueen. I'm a resident of Belknap County, New Hampshire, award-winning New England cannabis activist. But first, I will always be a mother and one to a cannabis patient. On this journey of fighting for cannabis laws, I'm honored to say I dedicated my life to the medical form in cannabis education and development. I developed a company that has been nominated 20+ times, won 3 awards for cannabis innovation, and most recently I was awarded East Coast Woman Role Model for my work in cannabis. I've seen it from both parts, and I've seen this state from the start. Almost a decade ago, a New Hampshire resident had to sue the state to get medical cards available to her. It's too many years now that have passed to continue this delay in developments. The delay in developments has affected my daughter. My daughter has an autoimmune disease and a form of epilepsy. At one time, opiates and sedatives the only option given for her. After failed pharmaceutical options, cannabis was suggested, but in this state, when she was an infant, there wasn't a well-established medical cannabis program, similar to now, sadly. And as a family, we had to move to Maine, who had already developed a medical cannabis program. Having to move my daughter to get care still seems unfair. So I ask you see the delay in changes in New Hampshire is keeping walls in place that need to come down. In Maine, as a mother, a patient, a caregiver, and a business owner in the cannabis industry the past 8 years, I have seen both sides. This year, I brought my daughter home to New Hampshire. As soon as I brought her here, though, I saw all the same things I stood and fought for so long ago. The medical program needs to be advanced. I just want to share a very short scenario with you. For most of us, when we go to get a medication, we go to a pharmacy. But for a lot of us, even being able to pick up our medication at that pharmacy sometimes is gut-wrenching because of the high cost. But available to all of you is the access to that correct medication, insurance help, and sitting in the counter right there in front of you, an RX discount card for all medication to help with that cost of that medication. For me, that's not how it works with the cannabis medical. Certain patients, like my daughter, require a certain strand of cannabis. There's a different plant with a different compound for certain illnesses, and that strand isn't even available in New Hampshire. And I want to say I want to substitute it like you could generically at a pharmacy. I'd need amounts that cost in the thousands because of the prices and the lack of development here regarding cannabis education and development. These limited state-run dispensaries for some patients are hours away, so highly priced because our state refuses to allow residents, doctors, parents to be involved in cannabis education expansion. This is what our program needs, education. What I learned going through this process in another state, there were states who faced this battle to make this decision, and with growth mindset had developed and have put in place guidelines. And guys, these guidelines are simple. This is simple. Grow the plant that the doctors were teaching us about, just like any new medical device or medication. So many states have been proven and had positive outcomes advancing their medical cannabis programs. In most states, medical patients are given the opportunity and education to be able to grow their own cannabis. This is a very important part, like New Hampshire, who is not fully established like the surrounding programs. Speaking as a mother, I will always pick a plant versus pain medication who is proven to be addictive. An opiate addict can go into a pharmacy and get a free needle to ingest an illegal deadly substance, but yet I can't grow my daughter's plant-based doctor-prescribed medication with guidance.
If you could start wrapping up, ma'am.
Absolutely. I want to end this by one more important fact. With the new practice guidelines the CDC updated last year regarding new guidelines and prescribing doctors, giving them guidelines to follow, like OxyContin. The CDC established this, trying to curb the epidemic of addiction and abuse. And I support it, but now we're going to be seeing more cannabis patients and doctors to seek alternative care, and that is going to be cannabis. All states will see an increase in patients looking to find a replacement to treat pain with the new CDC guidelines. Don't let that replacement be an illegal, deadly, less-priced drug on the street. Let the doctors help them to learn to grow a healthier plant-based way to treat their pain and thrive. That's all I got.
Thank you. Questions for this lady?
No?
Seeing no questions, so thank you
Okay,
very much.
Thank you.
I have nobody else signed up to speak on HB 431. Does anyone else wish to speak? Seeing no one, I am going to close the public hearing on HB 431. At this point, we have no other bills noticed for public hearing today. So the public hearings are concluded for today, and we will be going into executive session.
Do you want to announce which ones we're not going to do?
Sorry?
Right.
Yeah, we'll take, what, 10-minute recess, Representative? We'll have a 10-minute recess. I'd like to start in a couple of minutes. If members could start taking their seats, please.
Yes.
Okay, ladies and gentlemen, I know there's a couple of members we're still waiting on, so we're not going to go too far, but I did want to, number one, recognize Representative Howard, Heath Howard, who is sitting in as a substitute. So thank you and welcome. Given the hour and as we sized up the afternoon earlier, Representative Leon and Representative Weber and I, we all realized that it was going to be, we were being very ambitious in trying to exec 10 bills this afternoon. So we are going to exec some, 3 that will hopefully go fairly quickly. We are going to continue the others to next Wednesday, the 15th, and I'll read the numbers of those. HB 299, prohibiting discrimination in medical care. HB 322, relative to establishing a committee to study the New Hampshire Board of Medicine. HB 323, relative to establishing a committee on emerging medical technologies. HB 454, relative to the membership and reporting responsibilities of the Examining Board of Medicine. HB 582, requiring the Division of Vital Records to collect induced termination of pregnancy statistics. HB 614 FN, directing the Department of Health and Human Services to develop a health outcomes repository related to per and polyfluorinated alkyl substances, and HB 615 FN, requiring independent audits of reproductive health care facilities. The 3 that we will be considering this afternoon, again, this is in consultation with both parties. HB 397, relative to the prohibition of the possession of hypodermic needles for minors. HB 338 FN, relative to prescription drug assistance for individuals with diabetes. And HB 262, relative to laboratory testing by licensed naturopaths. And with that, are we all assembled? Is
We're not, but if we want to open 397, I can pass out the amendment.
Okay, do I have a motion on, do we want to consider the amendment first? Is that? Yeah, we do have an amendment on HB 397. Representative Leon is going to distribute that.
Thank you. I'd like to, I have it right here. It's amendment 2023-04598. It's an amendment to 397. I wasn't sure if it was better to include Representative Merchant without having an exact perfect sign off or not include him. So I apologize for leaving him off. I just thought it'd be worse to include him if he did not want to be part of it.
Thank you.
The audience is a lot smaller now.
The HHS.
It's a big department.
And the clerks. Good time.
Representative McLean, we are about to consider an amendment to House Bill 397.
Mr. Chairman,
Thank you.
my apologies.
That's fine. And you left one for Mark McLean. Right?
Yes, I did. speak to?
Sure. Representative Leon is recognized to speak to the amendment.
Thank you, Mr. Chairman. As we were looking at this bill, it seemed pretty clear that there was some concern around having the needle exchange program included in this because people are worried about misuse of needles and misuse of drugs. That part was removed from, so that part is missing when you look at this at line 10 of the amendment and line 20 of the amendment in both of those sections. Another change to this was that there are a bunch of innovative drug delivery technologies which do incorporate a hypodermic needle, but they're incorporated in such a way that the FDA doesn't allow them to be approved if they can be used to misuse drugs. If you can substitute another drug into a pain patch or anything else, it would not be approved by the FDA and it would not be allowed. This is actually an area where I had quite a bit of knowledge working with Insulet and another couple companies on drug delivery and avoiding misuse of them. So for that reason, the statute is being changed to talk about controller possession of a hypodermic syringe or hypodermic needle. Because when you include any instrument adapted for the administration of drugs by injection, you're looking at innovative technologies that really don't present a risk here. And it just confuses the issue. This would then mean that if somebody had an EpiPen and you handed off an EpiPen, the EpiPen wouldn't be... You could even make the case that an EpiPen, it does have the hypodermic needle in there. But this protects a lot of those other uses where you're going to be going astray. The other part is that it adds under direct supervision so that if they were in possession of the hypodermic syringe or hypodermic needle, the authorized agent that's a youth would need to be under direct supervision. That's something where babysitter-wise you can figure out how that would be interpreted, but this provides a lot more protection and protects those uses where you're asking a child to hold your bag. And somebody doesn't like you, they know you're a diabetic, and they choose that moment. That's the thing. We've dealt with all sorts of excess in policing, and we just want to remove each of those opportunities for misuse. And lastly, it adds the phrase, use of a hypodermic syringe or hypodermic needle contrary to the intent of the prescription is not permitted under the statute. So if somebody's misusing their parent's insulin syringe, it's not protected. So I think that this addresses everybody's concerns. I'd love to hear if there's anything that wasn't addressed in our amendment, but hopefully this is good.
So you're moving the amendment, I take it, Representative Leon?
Yes, so I move this amendment.
Is there a second to the motion? Yes, Representative Nuttarappam. Yes, I know. Well, for the purposes of a second. Do you have any further comment on this, Representative Leon, or?
I think I said what needed to be said.
Any other discussion?
Mr. Chairman, just wanted to thank Representative Leon for working with me on this amendment. It does address the concerns that I heard and ones I had specifically, and that dealt with needle exchange program, that a minor could have access to a needle that was not prescribed to them but prescribed to somebody. So it took care of that concern. And the other one, when talked about contrary to the intent of the prescription, it's the intent not by the FDA, but also the intent of how it's prescribed. So therefore, it takes care of the issue of using it in some manner that was never intended by the prescriber. So I totally support the amendment.
Thank you. Other discussion? Yes, Representative King.
Thank you, Mr. Chair. So we added under direct supervision, and I'm concerned that maybe somebody like the mother who testified, she might keep needles in her car all the time. Daughter borrows the car, she's not under direct supervision. Now all of a sudden she's potentially having life-ruining felony charges. I don't know. I don't understand why we put that in there. I'd rather that not be there personally. So I don't know. I'm just curious why that was added.
Thank you. I definitely understand that point, and I do think that there could be a risk of not removing those needles from a car. But there are certain situations where taking certain instruments with you makes sense. I wouldn't leave my firearm in the car. If obviously, hypodermic needles are a longer-term risk for similar potential outcomes. But if you have a bag full of hypodermic needles that are a part of it, I would think that I think that that's when we're also looking at, do we have it 16 and older for the delivery and all of this? This is where I was trying to get with a compromise. This may be something that would be a good thing to bring even into the Senate for them to take a look and see. I know it's best if they're the same, but this is an early bill, so it would be good to get it out early. I believe it's going to criminal justice, so we can probably take another bite of the apple of that, of trying to make it so that it has that correct intent. I don't know if there'd be desire to change that direct supervision, or if this is something that gets the general intent of this bill out. While meeting most of the need, while it does leave some potential exposure, but we've reduced a lot of exposure to risk here.
I follow up with that.
Follow up.
So I like the fact that you mentioned that later with the joint session with the Senate or something, that it could potentially be taken out. And I would like to see it taken out, because I know, for example, my sister was type 1 diabetic, and there's been times, let's just say, where, she has to throw away her needles in like a specific way. And lots of times it ends up in a huge garbage bag in the back of her car, and she drives around it for 3 months before and so it's just brutal that somebody else could borrow that car and have their life completely ruined because of some, let's just say, delinquency of my sister. You know what I mean? So I don't know. It just, I personally hate the idea of people going to jail for something they did nothing wrong. And to me, putting that back in there, it just allows them, you're not under direct supervision. The other person's in the other room. We're going to ruin your life now. So I would just like to see it gone, but I will vote for the amendment. But I just want to get as few people in prison as possible. And that just adds potentially more people in prison. That's how I see it.
Okay, thank you. Representative Weber.
So I have two comments to make in reply to that. One of which is, although I really truly understand the discomfort that led to the bringing of this bill, my initial reaction was, this is a solution in search of a problem. I don't know of people who are going to jail for appropriately helping people when they are ill. But secondly, I will also say that you or anyone else can approach your senator or testify at a Senate hearing and ask them to do whatever changes you want. And people from this committee have done it all the time, sometimes to the gratification of the committee and sometimes to the intense annoyance of other members of the committee. So that's always a process that's available.
Other discussion? Representative Shapiro.
Thank you, Mr. Chair. This looks good to me, but I on line 19, unless the recipient is acting as an authorized agent for another as defined by RSA 318 :42. I have that up, but it's a long section. Do you have a reference to where it actually defines what an authorized agent is?
Thank you. It's actually in the section above. I did not see that they deleted the comma I that is in the section above that. That maybe, I know that occasionally those minor clerical things like that can be cleaned up. Hopefully that's something that we can move forward with this, even with that missing 3.
Okay, I just thought you might
It's
have
on
that.
on line 20. It's on line 10, but not line 20.
Representative Weber, do you see it?
Yes, and I was going to state about the cleaning up of the clerical errors. I did check with the clerk when we had our issue about Section 1 and Section 2, and he did confirm that that is the kind of thing that we could have passed that with the error. And it would have been, in changing the amendment into a committee amendment, it would have been taken care of. We could have noted that. So I think in this case, that's also something that can be noted and taken care of when it becomes a committee member, if the committee votes it.
Thank you.
Any other discussion? Okay, if there's no other discussion, I will ask the clerk to call the roll. So the motion is ought to pass on amendment 2023-0459H.
Representative Leon,
Yes.
Representative Cushman,
Yes.
Representative Bill King, yes. Representative Kofal,
Yes.
Representative McLean,
Yes.
Representative Seth King,
Yes.
Representative Mazur,
Yes.
Representative Nagel,
Yes.
Representative Polozov,
Yes.
Representative Weber,
Yes.
Representative McKay,
Yes.
Representative Freitas,
Yes.
Representative Cannon,
Yes.
Representative Nutter Upham,
Yes.
Representative Shapiro,
Yes.
Representative Merchant,
Yes.
Representative Murphy,
Yes.
Representative Palmer,
Yes.
Representative Howard,
Yes.
and Representative McDonald.
Yes.
And the vote is 20-0 on the amendment.
Representative Leon.
Thank you, Mr. Chairman. I move ought to pass as amended by Amendment 2023-04598 with those clerical cleanups.
I'll second that.
Okay, motion's been made and seconded. Any discussion? Seeing none, I'll ask the clerk if he's ready to call the roll.
Representative Leon.
Yes.
Just a second.
Oh, sorry.
Representative Leon,
Yes.
Representative Cushman,
Yes.
Representative Bill King, yes. Representative Kofal,
Yes.
Representative McLean,
Yes.
Representative Seth King,
Yes.
Representative Mazur,
Yes.
Representative Nagel,
Yes.
Representative Polozov,
Yes.
Representative Weber,
Yes.
Representative McKay,
Yes.
Representative Freitas,
Yes.
Representative Cannon,
Yes.
Representative Nutter Upham,
Yes.
Representative Shapiro,
Yes.
Representative Merchant,
Yes.
Representative Murphy,
Yes.
Representative Palmer,
Yes.
Representative Howard,
Yes.
and Representative McDonald.
Yes.
Vote is 20-0, ought to pass with amendment.
Consent?
Yes, if there's no objection, that will be recommended for the consent calendar. Okay, next up is HB 338FN relative to prescription drug assistance for individuals with diabetes. Do I have a motion? Representative Leon?
Thank you, Mr. Chairman. I move in expedient to legislate on House Bill 338-FN.
Is there a second?
I'll second that.
Representative King, okay. Representative Seth King seconds. Representative Leon, do you want to speak to your motion?
Yes, thank you, Mr. Chairman. Looking into this bill, it's clear that, we found out that the section that this refers to has never been stood out. It's not funded. So it would require creating a whole new board and a whole new requirement. There would be a lot of work, a lot of money to try and make that happen. This is something where there's other issues as well around it with making sure that there's no generic insulin. And if there was still generic insulin, that might be an easy change, but we need to look at all the different insulin types. This would be a very large, very big change in order to get the sponsor's intent to actually come to fruition. So by ITLing this bill, it would need to come back in substantially changed form. So there should not be a problem with it coming back in the second year of this session. Additionally, I listened to the State of the Union address, and $35 insulin copays is a priority out of DC. So trying to recreate and stand up a program that doesn't exist and isn't funded when there is a federal effort to do this, and we would need to rewrite the bill, just doesn't seem like it's the most appropriate use of committee time, given everything else that we're trying to handle this year and this coming summer and fall. Therefore, since we would be able to change things up and somebody could introduce a different bill to achieve this aim for next year within this term, I believe that an expedient to legislate is the most appropriate, given time constraints.
Representative Weber?
Thank you, Mr. Chair. And I will say regretfully that I agree that this bill and this program is not workable, although the intent of the bill is very admirable. And I'm very glad that we have the opportunity now with cameras to say on the record that if this bill is ITL'd, we are only ITLing the use of a very problematical vehicle and not precluding the entire spectrum of things we might be doing for people who need insulin to make it more available and more affordable, that we're just restricting this one program. So with that having been said and that caveat, I am sadly, but realistically going to vote for ITL.
Other discussion? Yes, Representative Palmer.
Thank you, Mr. Chairman. I think Representative Weber has sort of addressed my concern, which is that what I've heard before is that if a bill is ITL, that you can't bring up the overall issue again easily. But if this can come up, particularly in the if there's we hear that there's federal changes that would make it easy for us to enact something in New Hampshire, then yeah, then that makes sense to me.
Thank you. Other discussion? Yes, Representative Nagel.
Thank you. This is a little bit of a tongue-in-cheek thing, but I did not watch the State of the Union address. When that point was brought up, did both sides cheer or did just one side?
I didn't watch it either, so I don't know.
I wasn't watching that carefully for it. I just noted, oh, this is what we're trying to do in New Hampshire.
Okay.
Maybe they're going to look at it federally.
Okay.
Representative Shapiro.
Yes, I understand and regretfully agree that this bill as brought to us is really flawed and is problematic, and among other things, it doesn't have any financial note about who's going to pay for this and how it's going to be paid for. Still, in principle, I would have a tremendous amount of difficulty voting to ITL, so I won't vote to ITL, and I would hope that it could be retained. I think I noticed also that during the State of the Union speech that was proposed by the president, but clearly the State of the Union speech is a place where a lot of ideas are proposed and they don't necessarily come to fruition. I hope it does. Then we can just end this bill.
Other discussion? Seeing none, I'll ask the clerk to call the roll. Motion is ITL on HB 338 FN.
Representative Land,
Yes.
Representative Cushman,
Yes.
Representative Bill King, yes. Representative Kofalt,
Yes.
Representative McLean,
Yes.
Representative Seth King,
Yes.
Representative Mazur,
Yes.
Representative Nagel,
Yes.
Representative Polozov,
Yes.
Representative Weber,
Yes.
Representative McKay,
Yes.
Representative Freitas,
No.
Representative Cannon,
Yes.
Representative Nutter Upham,
No.
Representative Shapiro,
No.
Representative Merchant,
Yes.
Representative Murphy,
Yes.
Representative Palmer,
Yes.
Representative Howard,
No.
and Representative McDonald.
Yes.
I have 16-4
16-4.
ITL.
Okay, do we know if there's going to be a minority report at this point, or?
That looks like no minority report,
Minority.
but it would have to go, I believe, on the regular calendar with four no votes.
Okay. Right, 2 is the limit, right? I believe.
I beg your pardon?
2 is the limit if it can't be more than 2 if it goes on consent.
Under the speakers that I worked on, it was 2. It's a speaker's policy. I have seen as many as 4, but I don't think that's really sensible. I mean, we have a significant difference of opinion about the ultimate way to deal with the bill, so.
Okay, all right, thank you. All right, next for our consideration, House Bill 262, relative to laboratory testing by licensed naturopaths. Do I have a motion? Yes, Representative Cushman.
Thank you. I move that we
recommend House Bill 262 ought to pass.
Okay, to pass. Is there a second to that?
Second.
Representative Merchant seconds. Representative Cushman, do you want to speak to your motion?
Yes, thank you. There was some confusion during the hearing, I think, on the reasoning and what this bill does. But I hope that it was clarified that this is really a technical change. I think it's kind of like being polite to just include the naturopathic doctors in this lab testing statute. It doesn't change anything that they're able to do, besides clarifying that along with all the other medical practitioners, they don't have a duty to care for someone who brings them labs that they ordered themselves. I think that's the only real impact of the bill. It just clarifies. So I hope you'll all support the ought to pass.
Discussion. Yes, Representative Weber.
Well, I started out as a solid ITL on this one, but having looked at what already exists, it does seem that we have a real glitch between the issues of reporting and interpreting and who does it. And maintaining that, given that the practice is already allowed, seems like removing that problem is a good idea. So I'm going to vote in favor of the ought to pass.
Representative Nagel.
For my following comments, I'm going to be kicked out of the medical society, but I'm going to make them anyways.
We won't tell them.
Thanks. I mean, in terms of scope of practice, I have serious problems, but it exists and I brought this up in all of our discussions on this. It already exists in the scope of practice that they are allowed to order and interpret these tests, and I think it's impossible to not acknowledge that and vote against that.
Representative Merchant.
What I initially was looking to not support it, but then when I went back and looked at it, the naturopath can actually order, interpret their own labs, but they only can interpret the labs they order. So if a patient wants to bring something to a naturopath that they didn't order, they can't interpret it. So all this does is allow the naturopath the ability to interpret an order brought to them by a patient or brought to them by another provider. So I think it's kind of extension logically to say if you can interpret your orders that you order, but you can't interpret someone else's lab, that's kind of doesn't make any sense to me.
Representative Shapiro.
Yes, I'm going to vote for this, and I think that not only does it change nothing or very little, as Representative Merchant said, but I think, it's an opportunity for us to vote for people to have the most diverse choices in terms of making their own medical opinions without hurting anybody.
Representative Murphy.
Thank you, Mr. Chairman. I also was in the same boat initially to ITL right from the get-go. But the testimony we heard yesterday, specifically from Dr. Liu, was one that really, I thought, attacked more of their historical background, the standard of care, their training. That's not the scope of this bill. The scope of this bill, as everybody else has mentioned, is basically allowing them to do what they already do. And it was a technical error a year ago not to include them. So I will vote ought to pass as well.
Thank you. Other discussion? Yes, Representative Cushman.
I have one more piece of information to offer the committee, although it seems we have good support. I spoke with Courtney Tanner earlier because I think from Dartmouth Hitchcock, I think it was there was a little it was a little unclear if Dartmouth Hitchcock was opposed to it because Dr. Liu works there, but Dartmouth Hitchcock is not opposed. They're neutral on the bill.
Thank you. Did I see a hand up? Yes, Representative Palmer.
Yes, and actually Dr. Liu himself said that he was neutral on the bill. And I think the concerns I had to do with finances, which has actually nothing to do with this bill and would have to be addressed elsewhere. So I'm in favor of this.
Thank you. Other discussion? Seeing no other discussion, I'll ask the clerk to call the roll. Motion is ought to pass on HB 262.
Representative Leon,
Yes.
Representative Cushman,
Yes.
Representative Bill King, yes. Representative Copal,
Yes.
Representative McLean,
Yes.
Representative Seth King,
Yes.
Representative Mazur,
Yes.
Representative Nagel,
Yes.
Representative Polozzo,
Yes.
Representative Weber,
Yes.
Representative McKay,
Yes.
Representative Freitas,
Yes.
Representative Cannon,
Yes.
Representative Nutter Upham,
Yes.
Representative Shapiro,
Yes.
Representative Merchant,
Yes.
Representative Murphy,
Yes.
Representative Palmer,
Yes.
Representative Howard,
Yes.
and Representative McDonald.
Yes.
And it's 20-0.
Consent?
Yes, if there's no objection, we will put this on the consent calendar. That concludes the bills that we announced previously for this executive session. So I will adjourn the meeting until next Wednesday.